Good afternoon. Today is Tuesday, March 3rd. This is the meeting of the House Judiciary Committee. We're going to start with our first bill, HB 310, with Delegate Kaufman. You may proceed.
Thank you, Madam Chair, and I know everyone is sad about this, but it is the last time I will be before you this session. For the record, my name is Delegate Aaron Kaufman, and I'm here to respectfully request a favorable report on HB 310, Correctional Services, Restrictive Housing, Individuals with Developmental or Intellectual Disabilities as amended. And once again, Madam Chair, I'm bringing you a bill with no opposition and no fiscal note. I want to begin by acknowledging that solitary confinement has caused real harm to people and the families in our state. No one deserves.
Delegate Kaufman, excuse me. Could you bring the mic closer to your mouth?
I'm sorry.
To your face?
Yeah. Okay.
Thank you.
So should I start again or?
However you'd like to proceed.
Okay. Okay, so good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Delegate Aaron Kaufman, and I am here to respectfully request a favorable report on HB 310, Correctional Services, Restrictive Housing, Individuals with Disabilities, or Intellectual Disabilities as amended. And once again, Madam Chair, it is a bill without a fiscal note or opposition. I want to begin by acknowledging that solitary confinement has caused real harm to the people in our state. No one deserves to sit in isolation for extended periods of time. At this moment, however, Maryland law does not establish a statutory limit on how long someone with IDD may be placed in restrictive housing. There's simply no guardrails in place. Examples of intellectual and developmental disabilities include but are not limited to autism, cerebral palsy, and Down syndrome. I've worked closely with the medical team at the Department of Public Safety and Correctional Services, DPSCS, and I'm proud they're supporting this legislation today, as well as advocates in the disability community to find a path forward that is both humane and workable. Through this collaboration, DPS has indicated, as you'll see, they've agreed to screen every incarcerated individual for indicators of IDD during the standard medical intake process that happens to everyone. If indicators are found, a clinical professional may recommend to limit the inmate's time in restrictive housing to no more than 15 consecutive days in a 30-day period, and this includes for administrative and disciplinary housing. This bill means that no one will be overlooked at intake, and vulnerability will be identified through an already existing process. Research regarding the association of restrictive housing from incarceration with mortality after release from the National Library of Medicine indicates that prolonged restrictive housing causes measurable harm, particularly for individuals with intellectual and developmental disabilities. A large-scale study of more than 229,000 formerly incarcerated individuals found that people who spent time in restrictive housing were 24% more likely to die within 1 year of release and were more than twice as likely to recidivate. The same study shows that higher rates of self-harm and behavioral crises among individuals placed in isolation compared to those in therapeutic or clinically informed settings. Maryland's Behavioral Health and Public Safety Center of Excellence has identified the overrepresentation of individuals with IDD in the correctional system and has called for trauma-informed, disability-responsive practices and reduced reliance on isolation. This bill responds directly to those recommendations. In my experience, working in the disability field for decades, people with developmental disabilities may have more sensory issues than the general population, which can be exacerbated in prison, and in many cases have less understanding of why they did what they did was wrong. That is what makes passage of this bill essential. HB 310 may not resolve every concern surrounding restrictive housing, but it is a meaningful step in the right direction. Today we have an opportunity to establish a clear guardrail where none exists. Supporters of this bill include the Department of Public Safety and Corrections, the Governor's Office of the Deaf and Hard of Hearing, Maryland Alliance for Justice Reform, National Federation of the Blind, among others. It is important to highlight the bill has no opposition. The proposed IDD screening would be incorporated into initial medical intake procedures, and as a result, HB 310 carries no fiscal impact. For those reasons, Madam Chair, I respectfully request a favorable report on HB 310, Correctional Services Restrictive Housing, Individuals with Developmental Disabilities as amended. Thank you, and after my panel goes, I'm happy to take any questions.
Thank you, Delegate. Whoever's ready to go next.
Good morning, Chair Bartlett and members of the committee. My name is Donald, and I respectfully ask for a favorable report on House Bill 310, Correctional Services, Restrictive Housing, Individuals with Developmental or Intellectual Disabilities. I was incarcerated for more than 35 years. For 6 years, I worked in biohazmat cleanup in housing units that included both disciplinary and administrative segregation, and I regularly interacted with men who were held in isolation. Over the years, I came to recognize that many of the individuals in segregation struggle with intellectual or cognitive disabilities. I'm not a clinician, but when you live alongside people for decades, you can tell when someone processes information differently. What I saw most often was not defiance, it was confusion. There was one individual who had been involved in an argument and was placed in segregation for several months. Every day he would ask me, "Why am I here?" I would explain it, and the next day he would ask again. It was as if the explanation never stayed with him. He did not understand the punishment. He only understood that he was alone. This was not rare. When someone does not understand why they're being disciplined, isolation does not teach a lesson. It creates fear and frustration. Imagine being locked in a small room for 22 hours a day, day after day, without fully understanding why. For someone with an intellectual or developmental disability, that experience can be overwhelming. From what I witnessed over 35 years, this is a responsible step forward. I respectfully ask for your favorable report on House Bill 310, Correctional Services, Restrictive Housing, Individuals with Developmental or Intellectual Disabilities. Thank you.
Thank you. And Mr. Dews, if you want to come on up. Thank you.
I'm a little wet, so
That's all right.
apologies for that.
Did you want to give him a minute to dry off?
No, I can.
If he wants.
I will be very quick.
Okay.
Christopher Dews, representing Out for Justice. Want to thank Delegate Kaufman for sponsoring this piece of legislation. We think this is a really good piece of, just a good bill generally that's going to help mitigate the certain traumas that can occur when individuals are in restrictive housing. We know that this is targeted to just one specific group as of right now. In the future, we'd like to see that expanded. But for the purposes of this bill, we think it's a great piece of legislation that's going to help a lot of people, specifically those who are most vulnerable when they are behind the walls. And so I know it's going to be a long day, so I'll stop there and just say me too.
Good afternoon, Madam Chair, fellow delegates. My name is Benjamin Charlton. I'm an attorney with the Forensic Mental Health Division of the Office of the Public Defender, and we also ask that you issue a favorable report on this bill, right? Restrictive housing is a euphemism for solitary confinement, and the science shows that being in solitary confinement worsens physical and mental health issues. It increases the likelihood of suicide, and it increases the chances of recidivism for any person who is in solitary confinement. And that goes against all of the goals of incarceration or the use of restrictive housing by DPSCS. These outcomes are even worse for individuals, incarcerated individuals who suffer from developmental or intellectual disabilities. They're more likely to worsen mental health outcomes for them, and they're more likely to spur co-occurring latent mental health issues that have not been exhibited before, like depression, major depressive disorders, and anxiety disorders, in addition to PTSD and other mental health issues that can develop while incarcerated. And it's because of the torturous nature of that type of confinement. In addition to that, people suffering from developmental disabilities or intellectual disabilities are easier targets to be placed in restrictive housing because of their disabilities. They become targets for other inmates, for scapegoating, for violations that they might occur. They are easier to take advantage of or to be duped into ploys that are developed by other inmates who don't have those same disabilities. And people with these disabilities have a lesser understanding of the rules and processes that will get them placed into this type of restrictive housing. As was mentioned earlier, the lack of understanding of why they're there and the day after day questioning of what they did to get themselves placed into that situation. So because of those issues experienced specifically by those this group that is covered by this bill, we ask that you treat disabled people the way they deserve to be treated, and that is humanely. And we ask that this bill does that, so we ask for a favorable report. Thank you.
Thank you. And just in case Christopher Danielson or Jake Dudinsky came in, Christopher, would you like to testify now? Oh, Jake, okay. That would be fine, actually. Okay, that would be fine, Mr. Dudinsky, if you could come on up. And is Kristen Mack available? Oh, she's going to be online, okay. Yep. So can you pull in Christopher Mack, please, and Christopher Danielson? We're just going to go ahead and finish out this panel. Okay, Mr. Dudinsky, whenever you're ready.
Yes, sorry, Madam
worries.
Chair and members of the committee. I was having an internal bleed on Tuesday, but I thought it was important enough for me to be here for this. I'm also autistic, so I'm going to try my best. If I run over, please, by all means, feel free to ask me to stop, but I'm going to try. So just give me a second. So my name is Jake Dudinsky. I'm the Vice President of Autism on the Go. I'm someone living with autism and a mitochondrial disease here in the state. I was a commissioner in the Montgomery County Intellectual Developmental Disability Commission for 2 years. Ever since its inception, I was one of 2 members with IDD on it. I'm here in support of House Bill 310. Cannot stress that enough. I also testified on the Senate companion bill. I got to meet many of your colleagues, which I really genuinely enjoyed. They're great people. I want to thank Delegate Kaufman and his office. When the disability community raised concerns about the original bill's language, they listened to us actively. They worked with us to change the bill to make it to where we felt really strongly about it. They changed certain things like may assess to shall assess, which was a huge thing, allowing interpretation to requirement. Being from North Philadelphia, I can't stress how important it is. Suggestion versus requirement. That was a massive language change. I'm also nervous and I'm shaking, and I apologize. I'm trying my best.
Mr. Dudinsky, you're doing great.
Thank you. You know, I also noticed that they changed the mandatory, they made the screening process mandatory, and again, not suggestive. Mandatory means they have to do it. Suggestive means it's a suggestion. There's a very clear difference between I suggest you do something and you are legally mandated to do this thing you already do. I can't stress that enough either. Maryland isn't alone in doing this work. Colorado and New York have both passed IDD specifically targeted protectorates in 2021. Colorado's law explicitly mentions IDD, and New York's HALT Act includes developmental disabilities as a protected group. It really does. Both of these laws are still standing, which persuasively demonstrates that IDD-specific protections can and do work and are constitutionally considered valid. It also means that, and this is a quote, Ovid wrote that, you know, dripping water hollows out stone, not through force, but through persistence. Today, Maryland has the opportunity to continue that line of progress, and I know that you will. Right now, Maryland has no limit, 0, doesn't exist. 0 is not acceptable. 15 out of 30 is a step in the right direction. It's not perfect, but it's progress. I'm asking you to pass this bill. I'm asking you to pass this bill for everybody like me who can't sit here and speak for themselves. And I'm asking you to pass this bill mostly because it's the right thing to do. And Madam Chair, if I could say one more thing, if that's okay. Harriet Tubman was born right here on Maryland's Eastern Shore in the great county of Dorchester. And she told us that every great dream begins with a dreamer, and that we have it within us through strength, patience, and passion to change the world. That is why I am here. This is how progress works. This is what it looks like, one step at a time. Thank you.
Thank you. You did a great job. So we're going to move now to Chris Danielson, please, online.
Yes, ma'am. Thank you, and I apologize. I'm totally blind, so I can't tell if or how well you can see me. So,
We can see you just fine. You're doing great.
okay. Good afternoon, Madam Chair and members of the committee. My name is Chris Danielson, and I serve as Second Vice President of the National Federation of the Blind of Maryland. And we respectfully urge you to give a favorable report to HB 310 as amended by the sponsor. Thank you, Delegate Kaufman, for that. This bill takes an important step toward protecting incarcerated individuals with developmental or intellectual disabilities from the disproportionate harm caused by prolonged restrictive housing, what most of us know as segregation. As amended, the bill requires mandatory screening at intake by a trained or licensed clinical professional to assess for developmental or intellectual disabilities. Under Maryland law, these include blindness, low vision, and deaf blindness, which is why we're speaking on the bill. Making screening mandatory rather than discretionary ensures that disability is identified early before harm occurs. And the bill also creates a meaningful safeguard if a clinical professional recommends that an individual not be placed in restrictive housing for more than 15 consecutive days within a 30-day period. The facility may not exceed that limit. And that's important because it ties placement decisions to clinical judgment, not administrative convenience. Restrictive housing typically means being locked in a cell for approximately 22 hours or more per day. Research and lived experience show that prolonged isolation can cause severe psychological, technology glitch there, psychological harm. For individuals with developmental or intellectual disabilities, the effects can be even more damaging. Many struggle to process complex rules, understand rapid verbal instructions, or access printed materials. As a result, behavior that is actually related to the disability can be misunderstood as being intentional. And thus misconduct. We appreciate that the bill includes a narrow exception for serious prohibited acts, and that preserves institutional safety. While this bill does not solve every problem, it is a meaningful improvement over the status quo. Maryland can and should adopt this legislation and treat Maryland can and should ensure that disability is treated as a need for accommodation, not a justification for isolation. For these reasons, we respectfully request a favorable report on HB 310. Thank you very much.
Thank you, Mr. Danielson. Kristen Mack.
Good afternoon, everyone. Chair, Vice Chair, members of the committee, thank you so much for the opportunity to testify in support of House Bill 310 as amended. I am a civil rights attorney who regularly represents incarcerated individuals in the state of Maryland, including people with developmental and intellectual disabilities and serious mental illnesses whose disabilities are never identified when they enter our state prisons. HB 310 does three critical things. First, it requires that at intake, a trained mental health clinical professional screen individuals for indicators of development or intellectual disabilities, instead of leaving it to chance or discretion. Second, it authorizes that clinician to recommend that a person with these disabilities not be placed in restrictive housing for more than 15 consecutive days in a 30-day period. And third, it then prohibits the facility from exceeding that 15-day limit for those individuals except for when they commit a clearly defined prohibited act. From my practice, I see how the absence of this structure plays out. Clients with developmental or intellectual disabilities often do not understand rules, they struggle to process staff orders quickly, and they react out of confusion or fear, not malice. Without early identification by someone trained in mental health, those behaviors are misread as willful defiance, and the response is often automatic placement in restrictive housing for weeks at a time. HB 310 ensures that disability is recognized upfront and that a clinical voice is at the table before we subject someone to 22+ hours a day in a locked cell. One of my current cases involves a mentally ill man, Lamont Milley, who was placed in an extreme isolation cell at Western Correctional Institution. It's called a behavioral alert cell with no bed, no property, and virtually no access to basic hygiene. because of behaviors rooted in his mental illness and difficulty following officers' instructions. Over 9 days in that cell, he was deprived of water and basic care to the point that he died of dehydration. An internal investigation later confirmed that required rounds are not done. The logbooks were falsified. HB 310 speaks directly to this kind of scenario by requiring disability-focused screening at admission, centering a clinical professional in decisions about restrictive housing, and limiting how long vulnerable people can be subjected to the most extreme forms of isolation. We urge you for a favorable report on HB 310. Thank you.
Thank you. Members, do we have any questions? Delegate Phillips.
Thank you, Madam Chair. And thank you, Delegate Kaufman, my friend. Delegate Kaufman, you know, you and I have talked about this, and I am going to support this bill. I do have a question. In your conversations and in the bill, in your conversations with DPSCS, have you discussed any type of reporting specifically on the use and verification that the testing will be done and that the individuals who we're dealing with today will not be housed more than the 15 days? Your bill does not talk about any type of reporting. Can you talk to that?
Yes. I felt like that lightning had struck to get the Department of Public Safety and Corrections to support my bill. And they said that that this is what they could live with and nothing more. So I tried to take yes for an answer. But then again, you know, it's the committee's work product now. So, you know, you all are free to do with it what you wish. But I feel that it was a very, Jason Davidson worked very hard with us to get to a point where his team could support it, and that's where we are.
And I appreciate that, but you would be open if we put some trust but verify in this?
I always think you're a very wise and learned person, Delegate Phillips. So whatever the committee deems appropriate would be up to you all.
Once again, thank you for bringing the bill, Delegate Kaufman.
Delegate Woods.
Thank you, Madam Chair. I also want to thank you, Delegate Kaufman, for this bill. I think that it's an excellent bill, and that when we take the time to meet people in the context where they are, that we can better serve them and assure that their needs are met. And so my question to you is, isn't that so?
It is indeed so, and I'm glad you're keeping my seat warm for me, Delegate Woods.
In the spirit of the work that you do and continue to do. So thank you. Thank you, Madam Chair.
Thank you, my friend.
Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate Kaufman, for bringing the bill and your panel as well. And my question, and I'm looking at the reprint of the bill on page 3 of 4, and I'm going to bring your attention to restrictive housing, the definitions, and what restrictive housing does not include. And the reason for the question is one of your panel brought this up, and I just want to be clear. Number 4, it says protective custody requested by the incarcerated individual. And my concern is, and one of the scenarios that was brought up by your panel was, if an individual has a developmental or intellectual disability and may not know they're being the victim or subject of a situation by another incarcerated individual, how can DPCS protect them in that scenario because they don't know they're being the victim and they're not requesting this protective custody? How would those folks receive protection, or how could we work that?
Yeah, I defer to the Public Defender's Office. Hold on.
To the extent that DPSCS is aware that a person with a disability of this kind is the victim, then they should also know who is victimizing them and can react accordingly in that situation, if that makes sense, right? The person who, instead of protecting or housing a person with a developmental disability alone, right? The people who are victimizing them could be housed separately, change units, change facilities, or if that's the behavior they're exhibiting, that also places them in a space where restrictive housing could be enacted as well.
Person that's actually doing the victimizing?
Yes.
Now, how would that be different than if the individual requested this? Wouldn't that also be where they, instead of someone requesting it, they would just remove the problem?
I'm not sure how they make those decisions normally. I mean, there's a lot of different reasons why people request restrictive or protective housing. So I think that that's a little further afield.
I'm just trying to figure out how we can protect these folks, even if they don't feel like they need to be protected. It's just in that one, and I know that's a small percentage. I'm just trying to make sure that those folks are covered as well.
Yes, I mean, I guess I don't know would be the answer. The most complete answer I can give you.
Fair enough. Thank you.
Thank you.
Thank you, Madam Chair.
Thank
Delegate,
you.
if I may, can I respond to that? So I think this is the start to that. To date, there is no type of screening process for this. So it's required under law that there is just like a medical evaluation within the first 24 hours of someone entering a facility, but that's the only requirement as is. So once we start tracking it, I think the onus is on DPSCS at that point. If they've been flagged with, potential disability, I think they're going to have to start doing more to protect those people because it's in writing. That's really the reality of it.
Understood. Makes perfect sense. Thank you. Thank you, Madam Chair.
Thank you. The Vice Chair.
Thank you, Madam Chair. My question is, how did you decide on this matrix of 15 consecutive days within 30 days?
Well, Madam Vice Chair, I just felt that after talking to a bunch of people that this was a reasonable time period. I wanted to still preserve the tool, but I felt that half a month was sufficient. So that's why I chose 15 days.
Okay, thank you.
Delegate McComas.
Thank you, Madam Chair. I noticed that there was really no numbers in the fiscal note, and I guess what I'm thinking is that, and there's a significant amount of people that are in the system that do have disabilities and could be preyed upon, so I was just kind of wondering how it can be reconstructed within the different penal systems to allow for them to have their own kind of cocoon within the larger area. And to be, in other words, but also be able to have, a quality of time in the prison system as opposed to just languishing in a cell.
You want to take this?
I mean, how DPSCS makes its decisions about how to organize its tiers and things like that is generally left up to them. But to the extent that, people who are suffering from similar disabilities require similar services and ought to be housed together, that would be ideal and potentially would create cost savings if those things have to be provided across many different facilities. And so identifying people early, which is not currently done and which this bill allows for and requires, would allow DPSCS to deliver those services more easily, whether it's through the special units that already exist at Patuxent or other units as they recognize the severity of this issue through early identification and are able to meet those needs more readily.
Just one extra question. So how would you start doing the early identification? When they're sentenced or when they go to jail pre-sentencing and pre-trial, or?
So as the statute is currently written, it is there is the intake process, the regular medical intake that is done for every person who is put into the custody of DPSCS. Evaluating for developmental disabilities and intellectual disabilities is now a requirement, or would be a requirement as a part of this statute. So they would have much better numbers. But things that happen in court, including at mitigation hearings and sentencing hearings, and through the pretrial process that deals with competency and sort of culpability issues that are related to mental illness, as well as things that occur before a person ever enters the criminal system, treatments that they've received would all become a part of potentially what could be screened for, things that DPSCS would be able to look at to determine if a medical professional would be making the recommendations that are contemplated in the statute.
And Delegate, for what it's worth, it would be wonderful to have a local counterpart to this, because there are tons of folks in Maryland that are pre-conviction that stay in local detention centers for a very, very long time before their trials and before they're in DPSCS's custody. And the same issues are happening at the local level as well. So to answer your question, this is all post-conviction because they're going into a state institution.
So in other words, any documentation, whether it be from, let's say, their schooling or the pre-sentence report, in other words, that would be all used by whoever the evaluator is. The evaluator isn't just going to look at the person, they're going to kind of look at the history too?
I would hope so, yes.
That's what I'm hoping, Delegate McComas.
Okay.
It's to take a holistic look at the person and determine whether or not they have developmental disabilities.
Thank you. Members, do we have any other questions for this panel? If not, that concludes this panel. We're going to move on to our next panel. And we have Benjamin Charlton and Heather Warnken, please. Is Ben wait, you've already testified. Thank you.
Thank you, Madam Chair.
All righty. And Heather Warnken, I saw, okay, there you are. Whenever you're ready. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law. You've already heard a lot of powerful testimony about why this bill is so important and why addressing the misuse and overuse of solitary confinement, restrictive housing is such an urgent issue for this committee to address, especially for vulnerable populations, including those with IDD. So I will just keep this brief and say that our position in the Senate cross-file was favorable with amendments because we were worried that the May language did not give the bill enough teeth to make sure that individuals were actually screened and identified. And we want to commend and really appreciate the hard work of the sponsor to strengthen the language with the amendments and expand the reach of this important bill. Thank you.
Thank you. Do we have John Sexton here today? John Sexton? Okay. Mr. Sexton, can you go on the other side of Ms. Warnken and have a seat? And you will have 2 minutes for your testimony. Thank you.
Madam Chairman, thank you. Members of the committee, I don't think I'll need the whole 2 minutes. It's just real quick. All I wanted to say today is that this is an excellent bill, but it's needed not so much because of the policies of the Division of Corrections, but because they don't really have the capacity to deal with these demographics of people. They don't have the psychologists, they don't have the wherewithal and the staff that could connect with them. One of the committee members was asking about, well, how would they know if a person gets in trouble? Well, there's not really a whole lot of people they can talk to, and if they had the psychologists and if they had the staffing they could deal with that specifically, that would be a lot better. And I'm just encouraging you to keep that in mind, is that at some point you're going to have to start giving pins and giving employees to the Division of Corrections or the public safety to deal with these kind of issues, because this is becoming a more prominent issue every year. Thank you.
Thank you. Don't go anywhere yet, Mr. Sexton. Members, do we have any questions for either Ms. Warnken or Mr. Sexton? Okay. Seeing none, thank you very much. That concludes our panel, and that concludes our bill hearing for House Bill 310. Ma'am?
I'm unfavorable with testifying. Lucy Hemsley, Disability Rights, Maryland.
Ma'am, can you come forward? I don't have you. I got dues, but I don't see unfavorable. Ma'am, I don't see any unfavorable testimony, and nor do I have your name. Tell me your name again, please.
Lucienne Parsley from Disability Rights Maryland, and I did sign up to testify.
I have, yeah, I have under info, I don't have you as disability, but hold on, me as unfavorable. Rachel London? Is that what you said?
No, Lucienne Parsley.
Okay, thank you. Oh, I see. Okay, for some reason, I do not have you here, but since you are here, please go ahead with your testimony. You have 2 minutes, please.
Okay, Madam Chair, members of the committee, thank you very much for the opportunity to testify today. My name's Lucienne Parsley. I'm the litigation director at Disability Rights Maryland. We are the state's designated protection and advocacy center for people with disabilities. We do appreciate House Bill 310's attempt to limit the use of restrictive housing for individuals with IDD, but we have serious concerns that the bill may do more harm than good. We appreciate the amendment to require DPSCS to assess each new intake for IDD. Although this is already happening in DPSCS facilities, it would be helpful to put it in statute. Unfortunately, the bill would permit DPSCS to place individuals with IDD in restrictive housing for 15 days out of every month and potentially much more than that. Significantly, the bill's proposed definition of restrictive housing is much narrower than the one currently in Correctional Services 9614 and would exclude from the definition many housing placements when an individual may be kept in their cell for 22 or more hours a day. The result would be 2 conflicting definitions of restrictive housing, one applying to people with IDD and another more expansive definition that applies to everyone else. The narrow definition of restrictive housing and the exemptions of categories of restricted acts in this bill create a giant loophole that would make the 15-day rule meaningless. For example, the definition of restrictive housing includes a form of physical separation that has not been requested by the individual. Many individuals with IDD we have met have requested to be in restrictive housing because they are afraid and have been targeted by other people. These individuals could and often are placed in restrictive housing for an unlimited number of days because they don't meet DPS's definition of restrictive housing. For these reasons, we cannot support the bill. If the bill were amended to delete all the text, except the requirement for DPSCS to conduct the assessment for intellectual or for IDD and all new intakes, we would be pleased to withdraw our objections to the bill.
Thank you, Ms. Parsley. I will say I scoured through our entire witness list, and I don't have you listed for House Bill 310 as unfavorable at all. I allowed it today because we have 155 witnesses, and I didn't want to delay. So next time, please assure that you are signed up on the bill. Members, do we have any questions? Okay, seeing none. Thank you very much.
Thank you.
Okay, so now we conclude the bill hearing for House Bill 310. Next, we're going to move to Delegate Maricopa North, House Bill 592. And Delegate Maricopa North, I'm going to go ahead and call up a few people on a panel. Is that all right with you?
Okay, one of them might not be here because we got a call saying that person had a car accident, so.
Okay, well, they'll let me, I'll find out. Elizabeth Hilliard from Office of the Public Defender. Erica Lamont.
Okay, great.
Diana Phillip.
Madam Chair, that is individual that said she could not attend due to a car accident.
No worries. And can you go ahead and pull up Ronnie Taylor if he's virtual? He or she, I'm sorry. And so Delegate, whenever you are ready, you may begin.
Thank you, Madam Chair. And I would, before I start, I wanted to introduce my intern, Naomi Nicholas, who will offer the testimony. And
Delegate, can you move that microphone?
Oh, I apologize.
Yeah, that's all right.
Chair, I didn't realize I was that far away. Can you hear me a little better now? Okay. Good afternoon, colleagues. Delegate Bernice Maricopa North for the record. I am going to introduce my intern, Naomi Nicholas, who has worked also on this bill, and she will be providing testimony on my behalf. So go ahead, Naomi, take it away.
Good afternoon. Madam Chair Bartlett, Vice Chair Davis, and esteemed members of the Judiciary and Health Committee. My name is Naomi Nicholas, and I'm a senior at the University of Maryland in College Park, and I come before you to offer testimony in support of House Bill 592, Task Force to Study Forced Infant Separation from Incarcerated Individuals. Every day, thousands of women experience the beautiful phenomenon that is childbirth. They get to experience the moment their newborn rests on their chest and cries for the first time. They get to experience the joy of continuing to bond with their child. Most mothers in the U.S. cannot imagine being separated from their children in the first few days of their life. However, this is the reality for hundreds of women facing incarceration in the state of Maryland. Infants are stripped of their mother and are faced with a rise in stress that will never dissipate. When separated from their parents, cortisol, a stress hormone, floods the brain and begins to damage brain cells. Furthermore, it can cause an overactivation of the amygdala, which can later on compromise the child's ability to evaluate risks and make good decisions. That is why HB 592 has been introduced. This bill would establish the task force to study infant separation from incarcerated individuals, composed of legislators, experts in maternal and child health, pediatric and maternal health nonprofit organization representatives, as well as individuals with lived experience of the current inadequate system we have regarding postpartum infant separation. The mission of this task force is to study the prevalence of pregnancy and postpartum incarceration in Maryland, evaluate best practices from other states, and ultimately make legislative recommendations to reduce forced infant separation and promote bonding between incarcerated mothers and their children. Forced infant separation has detrimental effects on both the mother and child. The child is more likely to develop PTSD and substance abuse disorder. The mother is more likely to experience postpartum depression, grief, and feelings of detachment. This bill recognizes the need for a comprehensive and well-informed approach to ensure that future proposed policy measures are targeted, effective, and sustainable. The task force findings will be indispensable in shaping policies that are evidence-based and considerate of the well-being of incarcerated mothers, their children, and the public. Forced infant separation is not the only option. In 2021, the Minnesota legislature passed a law preventing the forced separation of infants from incarcerated parents. Today, only 11 states in the United States and the federal system operate prison nursery programs where newborns can reside with their parents in custody. These nurseries are few and far between, frequently only offered at one facility in the state, and eligibility for participation is limited by many factors. Establishing the task force will ensure Maryland moves towards a more just and humane approach in addressing the health and safety needs of incarcerated mothers and children. I urge a favorable report in House Bill 592.
Thank you very much.
Good afternoon, Chair Bartlett, Vice Chair Davis, and distinguished members of the committee. My name is Erica Lamont. I'm the Advocacy Director for Children's Rights from Maryland Legal Aid. Maryland Legal Aid requests strong support for HB 592, which would establish the task force to study forced infant separation from incarcerated individuals. Maryland Legal Aid provides free legal services in all 24 jurisdictions of Maryland, and we represent we have and we do represent thousands of children in child in need of assistance matters and guardianship matters across the state, and we have done so for decades. As a result, we have a deep expertise in issues affecting vulnerable children and families. HB 592 responds to an urgent problem. Currently, Maryland law requires that an incarcerated individual be returned to prison as soon as giving birth, as their health allows, resulting in near immediate and traumatic separation between a newborn and their parent. These forced separations have extensive short and long-term consequences, including higher rates of depression, anxiety, instability, and disruptive attachment for the infant. But we also know there is a better way. Research on prison nursery programs demonstrates dramatically positive outcomes. One longitudinal study found that only 4% of women participating in nursery programs returned to prison for new crimes. Another study showed that 59% of the infants in such programs were discharged into the community with their mothers. 83% of those children remained with their mothers 3 years after reentry, demonstrating lasting stability where early bonding is supported. HB 592 does not create a program today, but ensures the state undertakes a thoughtful, data-driven examination of how to reduce unnecessary separation. For the children we represent whose earliest relationships shape their lifelong development, and for the parents seeking to break the cycles of trauma and incarceration, this task force is a critical first step. For these reasons, we request a favorable outcome. And as you heard, Diana Phillips of the Coalition to Protect Maryland's Children, she was very excited to testify, and unfortunately, she was unable to, but she requested that I let the committee know that the Coalition to Protect Maryland's Children also strongly supports this bill.
Right. Thank you, Madam Chair, members of the committee. I'm Elizabeth Hilliard with the Office of the Public Defender. Us too, and I'm happy to answer any questions. We think this is a great bill, and we urge a favorable report.
Thank you very much. Do we have Ronnie Taylor? Could you bring Ronnie Taylor in, please?
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. For the record, my name is Ronnie L. Taylor, Community Impact Director at Free State Justice. We advocate for legal justice and equity for LGBTQ+ Marylanders through direct legal services and policy reform. I strongly support House Bill 592. This bill addresses a data and accountability gap that directly affects infants, parents, and long-term public health outcomes. Maryland imprisons women at higher rates, and nationwide, an estimated 3 to 5% of incarcerated women are pregnant at intake. Immediate postpartum separation affects infant neurological development and maternal mental health. Research consistently shows that early bonding promotes attachment, stability, and long-term health, while forced separation increases trauma and postpartum depression. Over 80% of incarcerated women are mothers, many of whom served as primary caregivers before their incarceration. When separation occurs at birth, its impact extends beyond a single family. The state incurs costs through foster care, medical services, and child welfare programs. House Bill 592 recognizes that Maryland lacks comprehensive data on the number of pregnant and postpartum individuals in custody, the infrastructure available to support them, and the long-term effects of separation. Without this information, policymaking remains reactive. This task force assembles legislators, agency officials, medical providers, public defenders, child welfare experts, and directly impacted individuals to review best practices and determine if current practices meet constitutional and public health standards. This issue intersects race, poverty, and maternal health disparities. Black women are incarcerated at disproportionately high rates and already face higher maternal mortality risk. Incarcerated worsens with these disparities. For LGBTQ+ families, including transgender men and non-binary individuals, who may become pregnant while incarcerated, inclusive data and policies are vital to ensure proper care.
Thank you for your testimony. Members, do we have any questions? Delegate Ericon.
Thank you, Madam Chair. You said folks could become pregnant while incarcerated. Can you explain how that's possible?
Certainly, Delegate Ericon, I believe that question is for me. There was a report years ago, I want to say it was 2019, and I can send that to your office. Someone who identified as a transgender man became impregnated by a correctional officer. And while within the facilities, became pregnant by a correctional officer and was essentially separated from their child at birth. And so this is why we issued a favorable report on this piece of legislation.
And was this individual being housed in the men's prison?
This individual was being housed in a woman's prison.
Okay, and they still had that happen to them?
Correct.
Okay, thank you.
Thank you. Members, do we have any other questions? Seeing none, that concludes our panel for House Bill 592 and our bill hearing for House Bill 592. We're going to next call up Delegate Long for House Bill 527.
Thank you, Madam Chair. Is it all right if I bring my my panel with me? Come on up.
Delegate Long, I have Edward Kinney from the Public Defender's Office. Is that correct?
I'm here. Okay.
Okay.
This is my intern, and I asked him to come up so we could talk about this. He's got a lot of information.
Is he going to testify?
I'm sorry?
Is he going to testify?
Yes.
Okay, so between the two of you, you have 2 minutes.
Yes, ma'am.
Okay, thank you.
Good afternoon. Okay. Good afternoon. For the record, I'm Delegate Bob Long. I'm here to testify on HB 527. It would remove people that are on home monitoring systems with the ankle bracelets. We've had a lot of problems with them not adhering to the policies. And that's what we're here today to talk about. You know, I'm of the understanding that if you make an agreement that's not a right, but it's actually a privilege, and you break that, you should take and pay whatever you know what you have to do. The home monitoring system, actually, there was a problem with it where the state tried to remove the contractor, and the judge actually put him back in, put the same company back in. Problem is, and I'm sure everyone here has heard different problems with home monitoring. You know, juveniles, seniors, or juveniles going out and continue breaking the law. We want to make sure that we do wherever we can to make sure they have a clean and precise line of what they know they're supposed to do. That's one of the problems I believe a lot of our youth have right now. The line keeps moving, so they keep pushing the envelope. Anyway, I would ask for a favorable vote, and I'm going to ask my Vince here to give you some more information on it.
Delegates, Madam Chair, we identified 3 pretty extreme examples of people who have committed crime, both minors and adults, while under house arrest, home detention. The first was the Columbia Mall shooter. I'm sure everyone is aware of that. Emerson Zia, in February 2025, went to a mall and ended up shooting a 15-year-old and a 16-year-old. He was currently being monitored through an ankle monitor, and before the shooting, he had violated his monitoring and went to the mall to scout it out before the shooting, and he was not taken off of home arrest. And this eventually ended up leading to the shooting of 2 teenagers. An unnamed minor from Baltimore City in June of 2025 went on a crime spree while having an ankle monitor on. At midnight, he stole a vehicle and eventually went on to do a carjacking around 6 in the morning and later on rob a grocery delivery driver. Before that, he had 18 prior felony offenses, and the Department of Juvenile Services ended up changing their policy after this to mandatory detention for any youth arrested for serious crimes while wearing a monitor. And it brings up the question of, if we are treating minors like this, why are we not holding adults to the same standard, especially when it comes to people like Emerson Zia, who we see that shows adults are capable of more destruction. Thank you for your time.
Thank you. And Mr. Kinney, I asked you to come up, but can you just hold for 1 second because you're unfavorable. Members, do we have any questions? No, not you personally, Mr. Kinney.
Thank you.
Do we have any questions? Okay, seeing none, Mr. Kinney, if you would please proceed with your testimony.
Thank you. Good afternoon. I'm Edward Kinney. I'm from the Office of the Public Defender, and we're urging an unfavorable report here. This bill would essentially remove any discretion the Commissioner of Corrections has to take a look at the individual and say, maybe in this case it makes sense to keep him in home detention. In preparation for this, I decided, we should look up and figure out what these rules are and these conditions are that we're talking about here. So I pulled up the COMAR, and I looked at the regs, and obviously some of the regs are pretty serious, like having a firearm. And obviously in that situation, no one's saying that removal wouldn't be appropriate. But it also includes things like, testing positive for drugs, even if the person is willing to go into a treatment facility and has otherwise complied with all the conditions, that would be automatically back to the DOC. If you lose your job because maybe you overslept, that's a condition that's in the COMAR. No discretion, you're back into the DOC. Let's imagine you get a new job, okay? You get a new job. You're doing so great. You get a new job. You don't tell the people in the detention unit. I'm not condoning this, but it happens. That's a rule violation, and under this bill, they'd get sent back to the Division of Corrections. This is my personal favorite, because I've got a client this would affect, okay? He's got a mom who is suffering from cancer. Terminal cancer, stage 4. He calls his mom on the phone and has a 10.5-minute conversation with her. That's a rule violation, and under this bill, she would automatically get sent back to the Division of Corrections. Let's think about how this would actually play out, okay? Because this is what's going to happen. The case manager is going to say, if it was up to me, you'd stay in the program, but my hands are tied because of the legislature, and so we have to send you back. So for that reason, we are opposed and we urge an unfavorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Valentine.
Thank you, Madam Chair. Thank you, Delegate, for bringing the bill. I did have one question. Why would calling your mom be a rule violation for your client?
So the rule says that if you're on the phone for more than 10 minutes, that's a condition.
So it's a time limit issue?
It is.
Okay, I didn't understand the point.
Yeah, and I think the point of the rule is that you don't want to tie up the private phone because they want the home detention unit to be able to reach the client. Right? I mean, we're not saying that the rule isn't appropriate and there should be some sort of accountability, but the accountability shouldn't be, we're just automatically going to send you back to the Division of Corrections. Yeah, I feel like there should be some discretion, and that's why we urge unfavorable.
Thank you. I didn't know there was a time limit. Thank you, Madam Chair.
All righty. Thank you so much. Thank you, Delegate. Thank you for being here. Oh, we have a question. Delegate Woods, I'm sorry.
Thank you. I wanted to know if you would be willing to provide some requested amendments for such as the conversation to the bill, if you would be favorable of it with some reasonable amendments.
Sure, I'm willing to entertain that. And the bottom line is we need to make sure we have clear, decisive lines. Once they cross that, that's it. And I understand what he's saying about the 10 minutes. I understand why, because they figure if the phone's tied up, it's kind of hard to tell if they've moved on or whatever. But anyway, no, I wouldn't have no problem with that. And I understand what he's saying about losing a job or something, but I think that should be a discussion with his parole officer or whoever's implementing this program. But I think we need to definitely make some changes, that's for sure. Yes, I'll be eligible, willing to work with you.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Taylor?
Thank you, Madam Chair, and thank you for bringing the bill, Delegate.
Thank you.
Just to be clear, your bill has to do with incarcerated individuals. So they've already gone through trial. They are incarcerated. They're serving part of their sentence and are under home monitoring, right? Not pre-trial, right? I'm just making sure because my bill has to do with pre-trial, and I'm making sure there's no overlap.
That's a good question. Yeah, that's basically what it is. If they've been released on home monitoring. I would even say that if they're on home monitoring waiting for trial, I think the same rules should apply.
There are rules.
Okay.
Yeah.
Everything should be uniform and everybody knows what's in front of them and they know what they can and what they can't do. That's what this bill is all about, because I think there's so much confusion around the home monitoring and, people are just taking advantage of it. I'm sorry, but that's just the truth of the matter.
Would it be okay if I just address Delegate Taylor's question?
I'm okay with it.
Is that okay?
Yes.
Briefly? Very briefly.
Briefly.
I mean, I think that one of the key differences between the pretrial and incarceration is that these individuals they've already got one step out the door. And so that's another reason why I think discretion is so important, right? Because you'll have a situation where someone's going to get sent back for, at the end of the day, probably like 2 or 3 months. And there may be some positive benefits. I'm not going to deny there might be, but there's also a real cost there, right? Because you're sending them back to the Division of Corrections for like another 60 days, 90 days, and then they're going to be right back on the street. So that's why I think it's important that there's some discretion there to say, does this really make sense?
Okay. Thank you. Members, do we have any other questions? Seeing none, that concludes our panels and our bill hearing for House Bill 527. We're now going to move to, is Delegate Buckle here? I do not see Delegate Buckle.
I can let him know.
I'm sorry?
I can let him know it's in my committee.
Okay, thank you.
Thank you.
Okay, no worries, that's fine. Delegate Embry, oh, no. We're gonna have a brief recess, please. We are resuming our bill hearings today for Tuesday, March 3rd. We're going to call up Delegate Stinnett for House Bill 819. And Delegate Stinnett, whenever you're ready, you may begin.
You said begin? Oh, okay, I'm sorry. Good afternoon, Madam Chair, Vice Chair, Judiciary Committee. I am Delegate Sean Stinnett, representing District 41 in Baltimore City, presenting House Bill 819, Commission to examine the expungement laws of Maryland, which creates a commission to examine Title 10, Subtitle 1 of the Criminal Procedure Article for the purpose of redesigning the statute for efficiency and equity. 10 years has passed since the passage of the Justice Reinvestment Act, which created the expungement statute and made a limited number of convictions eligible for expungement. Since its passage, many legislators have returned each year to discuss adding more charges to the expungement list, the conditions of expungement, and the expungement process. This has prompted calls to update the statute in its entirety rather than take a piecemeal approach. House Bill 819 seeks to establish to review the expungement statute, identify inefficiencies, compare us to other states, and develop solutions. I urge for a favorable report.
Thank you, Delegate Stinnett. Do we have everyone from your panel? Because
I'm going to get the others, but Megan McDermott is on the panel as
well. So we have Megan McDermott?
Yes.
Yes. Yes. We have, we don't have Heather. Do we have?
They're outside, Madam Chair.
That's okay. Hold on. Just a second. Sean Link?
Yes.
Okay. And is Zachary Alberts here?
Outside.
Okay. No worries. Do we have Saquon Merritt? Okay, great. I just needed to know who we have so we can keep rolling. Who's going to go next?
I think Ms. McDermott.
Okay. Ms. McDermott. Thank you.
Good afternoon to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid. I started representing clients in expungement matters in 2017. Impacted people, advocates, and this committee have done a lot to advance expungement opportunities since that time. We added conviction eligibility to the statute. Then there came shielding of some dispositions. Then Maryland legalized cannabis. We went from 1 petition to 4. Then we added more eligible charges under the conviction list. It's a bit of a whirlwind just listening to that, and those are only a few of the changes. These important reforms have unintentionally created a process that is practically unnavigable for a pro se litigant. With some exceptions, people should be able to file expungements without an attorney. The process is form-based. The court's website has the forms posted, and they can be filed in person or online. But that said, expungement is difficult even for attorneys to understand. I should know, I field calls from my colleagues with questions about it all the time. Imagine how challenging this must be for someone without legal training, for someone who is under extreme pressure because obtaining an expungement is critical to their employment or housing needs. At Maryland Legal Aid, we do our best to help. We assisted over 2,000 expungement clients last year, but there are simply not enough resources for the over 1 million Marylanders who have a criminal record and might be interested in expungement. The commission created by House Bill 819 would study the statute, identify the pain points, and look to best practices to make recommendations so the expungement practice works as it should and is accessible to everyone, especially vulnerable and low-income Marylanders who have the most trouble accessing the court system. We urge a favorable report. Thank you.
Thank you. Whoever's next.
I'm happy to go next.
Thank you.
Yes, Christopher Dews representing Out for Justice and actually Life After Release. So this piece of legislation emerged after many, many conversations, of course, with legislators about the piecemeal approach that we tend to take when it comes to criminal record expungements. Every year, and you're experiencing that today, there's individualized pieces of charges that are just not eligible for expungement. And every year we keep coming back, trying to make changes to that statute. There's also situations where in which new laws or new convictions are actually created in statute, but expungements are not available for that, which we then have to come in and add the ability to expunge those charges much later in the line. So the purpose of this piece of legislation was to kind of step away, or try at least to move away from the piecemeal approach and take a holistic approach to just redesigning the statute. It's been 10 years since the Justice Reinvestment Act, as the good delegate has said, went into effect, and things change a lot in 10 years. New charges are added, things are removed, things are adjusted. There's also some inconsistencies that we see in statute. There's an individual who I know is going to testify who has, for example, a counterfeiting prescription charge, which is eligible in 2 other sections of law, but not eligible in his specific section. There's situations where I could go through a litany of different circumstances where in which somebody should probably be eligible, but because of the black letter writing of the law, they just can't have it happen. I know there's been conversations around the unit rule and other different things. The point is to bring all the forces together to have a conversation and decide how we should redesign the statute based on the 10th year anniversary. I just also want to highlight that on the commission itself, we have a lot of different forces, from the State's Attorneys Association to OPD and I want to highlight this, 2 representatives from 2 different crime victims advocacy groups, including one with expertise serving criminalized survivors of violence. We wanted to ensure that the victims' voices are also in these conversations as we design and redesign the expungement statute. I'm happy to answer any questions that anybody has as to the nature of the commission, why we did it, and specifically who's on it. Thank you.
Thank you, Madam Chair. And members of the committee, the Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on HB 819. Additionally, OPD did file written testimony in support of all 9 bills before the committee today concerning the expansion and clarification of expungement. Out of request for everyone's time, I declined to sign up for all of them, but I'm happy to address questions. The existing expungement system is a critical tool benefiting many individuals by clearing barriers to jobs, education, and housing, ultimately reducing recidivism. But it's also confusing, as you've heard, having been built up piecemeal over the past decade. Today's proposed panoply of amendments solve some problems, but also ultimately highlight the need for an expert commission to investigate expungement further and learn from other state systems. OPD supports this commission to review our expungement scheme holistically. My written testimony highlights 3 particular areas of concern: offense eligibility, as you've already heard a bit about, as well as the obliteration of records and a personal right of access to one's own records. To focus momentarily on obliteration, state law currently defines expungement as removal from public inspection by any of 3 possible methods. There's obliteration, removal to a separate secure area, or partial access. Unfortunately, we've had many OPD clients who successfully expunge their records, only to find that third-party background checks or other federal systems continue to flag these cases. In one case, a client came to me a few months ago because his background check listed a case as pending because there was no record for it after he had actually been acquitted 4 years ago, and the court had automatically expunged that matter. So this can be corrected when people are able to access a certified record of the court case file, but only if it's been preserved, not if the court has gone forward with obliterating it. I think this commission should study methods to avoid such inaccuracies at the outset and limit other unintended harms. For these reasons, we would urge the committee to issue a favorable report.
Thank you, Madam Chair, Vice Chair, and members. My name is Saquon Merritt. I'm an impacted individual and also employer, owner of Lightning Electric, master licensed electrician. I come from, in my better times, the Park Heights community, places where drug economy is everywhere and consequences hit hardest in poor communities. I lived that. I'm not proud of that chapter, but I'm also not running from it. I did my time. I did the work to change, and today I'm building something legal and positive, jobs, training, and structure, and opportunity to the community. What this bill is really about is the fact that the distribution of a conviction becomes a lifetime sentence for a lot of people, even after they've served their time and proven growth. It blocks jobs, licensing, housing, education, and the basic building tools of stability.
I think we might be on the next one, but commission, let me just, I think. Commission, this one. Sorry, Madam Chair.
Okay. Apologies for that, okay? They had me testifying on a lot of bills today. Apologies. All right. But let's just keep it clear. As I said, my name is Saquon Merritt. It was a time I was sentenced to 25 years without parole in 2012 for 2.3 grams of heroin. Expungements are really something that affect me because now, with those convictions still on my record, I can't even grow my company the way I need to grow it. I can't get financing, I can't get capital to give people in the community the jobs, the well-paying living wages that they deserve because of my conviction that's still on my record. It even also affected me during the pandemic, PPP loans, which we had to fight the Trump administration and pass because of my conviction on my record did not give me access to it, nor my employees that worked for me at that time during the global pandemic, which is something that's just unreal to say that we don't deserve the same opportunities of relief that everyone else did during the global pandemic. I say that to say, I would like for this bill to pass favorable. Second chances should not require a law degree. There's a lot of brothers that just do not understand the components of the law and how they may work, right? It causes us to go through so many things. Again, as he mentioned earlier, my co-chair mentioned that you need a law degree to even try to get this thing passed. I would urge you guys for a favorable decision on this bill, and I am here for any questions you may have afterwards. Thank you.
Thank you very much, Mr. Merritt. Yep, they've got me on a lot of bills today, too. So. I completely understand. It's hard to keep them straight. Okay, members, do we have any questions for this panel? Delegate Taylor.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill. I love, yeah, I love it. Anyway, but Chris mentioned that, you know, he thought, would you like to tell us who's going to be on the commission?
Absolutely.
Thank you.
So, and this is all, of course, in the bill language. I just wanted to highlight that I'm actually going to take this in reverse. We have 2 individuals with a criminal record that is currently ineligible for expungement. And we wanted to make sure that was there so that so that we are not speaking for the impacted people, but the impacted people can speak for themselves, specifically those who have a charge that is ineligible for expungement. We decided to have 2 individuals with from victims' crimes advocacy groups, and specifically a victims' crime advocacy group that represents criminalized survivors of violence. So what that means is these are individuals who have been victimized, so they're victims, right? But they've also got themselves caught in the criminal legal system, which is different than just an organization that represents just victims. So we thought that both of those voices would be important as we're determining which charges should and should not be eligible for expungement and how those rules should be broken down. We We have 2 individuals from the Maryland Bar Association who have experience providing expungement, so that way we have individuals who've actually done the expungement process and can speak to it from a level of experience. We have a workforce development organization. I have, of course, my own personal preferences with the Center for Urban Family, but I'm not going to dive too much into that, who actually have hosted expungement clinics and have worked with individuals that have a criminal record. We also wanted to ensure that there was a research organization that has been working on criminal justice affairs and the impact that the criminal record has on access to employment, housing, education, financial literacy, financial opportunities and everything else. We also, of course, had the regular state officials, in which we included, of course, the Office of the Public Defender. We also included the Department of Corrections, specifically because they house a lot of the expungible documents, and we added the Maryland State's Attorneys Association. I can't speak for what they're going to do today because I have not necessarily read the bill file, but I will say on the Senate side, we did have them come up and testify, and they mentioned that you do need to have a degree in expungements just to be able to understand the statute, to be able to understand whether or not it is, okay, so it says it's eligible, but then you have the unirule, it is eligible, but this was a subsequent offense and stuff like that, and it can confuse a lot of people. So long answer to a very short question. Thank you.
I understand that. Thank you.
Thank you.
Thank you. Members, do we have any other questions? All right, seeing none, that excuses this panel. Thank you very much.
Thank you.
I'm going to call up Lauren Lipscomb, Heather Warnken, Jamie Grace Alexander, Amber Wallen, Zachary Alberts. And if you, we're going to go ahead and call up Mr. Stephen McDonald, who's virtual.
No, thank you.
And Ms. Wilt, I wasn't calling you up just yet because you're listed as unfavorable.
Yes.
Okay. Yep, I'm still on favorable panel. Thank you, though. Okay, so I only see 4 people. I see Zachary Alberts, Amber Wallen. Okay, thank you. Heather Warnken, Jamie Grace Alexander. I'm Jamie. Okay, great, perfect timing. And Lauren Lipscomb. Okay, we're going to start with, I hate to do this to, actually, I'll start with Mr. Alberts.
Thank you.
And then we'll just go in reverse order. Thank you.
Thank you, Chair Bartlett and members of the House Judiciary Committee. It's great to see you all today. I want to give some background on why the Center for Urban Families is so enthusiastic to support this legislation. As a West Baltimore workforce development organization, we run quarterly expungement clinics. Over half the individuals we serve are justice impacted, and we are an organization that tries to get people that aren't working into work, right? That's all we do on the workforce side. Individuals with a criminal record, as you all know, are much less likely to be able to access the workforce, housing, and education. As an organization that specializes in this and finds employers that are background friendly, it's still 20% easier for us to place people without a record than place people with a record. And that's why this is so important. I had an intern over the summer in our advocacy shop who, together with me, went through every single conviction in the Maryland Code to try to figure out what we think should and should not be eligible for expungement and expanded eligibility. It was as painful as it sounds, but the most interesting part was she's very young, she's Gen Z, and just seeing where she and I, who have generally the same principles, disagreed on things, just made it clear that this is such a complex issue, right? There's questions of forgiveness, there's questions of protecting victims, there's questions of second chances. What's best for Maryland, right? How do we get people off benefits into the workforce? That it's clear a commission of experts was really important. We would ask your favorable report. I just love to point out a few charges every year where it kind of makes no sense which ones are and are not expungible. So the ones I found this year, CR 6-403 is trespassing on a private property, but CR 6-402, which is a different type of trespassing on a private property, the difference is, was there a sign posted or were you verbally told? One's expungible, one isn't. If you discharge fireworks without a required permit, that is not expungible. That's because no one's come up here and said, this is ruining my life, and so we were able to make it expungible, right? There's a million of these. For this reason, we request a favorable report. Thank you.
Good afternoon, Chair Bartlett and members of the committee. My name is Amber Whalen, and I'm a resident of District 6. I'm here to share my personal experience as you support HB 819. Before I tell you what's on my record, I want to tell you who I was when I got it. I've never been in trouble a day in my life. I earned an associate's degree from Howard Community College and was building a career as an educator in Baltimore County Public Schools. Then I had a mental health crisis. I had bipolar 1 disorder along with depression and anxiety. This all started because of a manic episode. I wasn't sleeping. I wasn't checking in with myself, and the medicines I was prescribed were making things worse. While this was happening, my employer made a payroll error, leaving me behind on rent and bills. Every time I tried to get help, I was sent back to the same HR representative who told me over and over she couldn't help me. Because I was manic, I snapped, sent threatening messages to the HR representative. I told her I was going to come in and shoot her. I never owned a gun. I've never been violent. I have no history of threatening behavior. I am not a threat. I am a young woman in crisis who needed care, not a criminal record. But because multiple people worked in the office, not the school where she worked, I was convicted of threat of mass violence. Because of how background screening works, I never got the opportunity to explain what happened. Employees see my record and move on. I have to live with my mom. I can't even adopt a dog or volunteer at an animal shelter. People who see my background think I'm dangerous and a terrorist. I hope that in time I have to speak with you today and you can see that I'm not. I'm just a normal person trying my best who had a fallout with mental health crisis that has defined ever since. And I would like you to support HB 819 so a panel of experts can decide whether there are conventions like mine, which currently are not expungible, that should be depending on the context. As a reminder, making something expungible does not guarantee an expungement. It just gives people a chance to make their case. You have heard my case today. If you think that this will give you the evidence to prove my story, I should be able to get an expungement. I would ask that you support this legislation. I urge your favorable report.
Thank you. Next. Yep.
Thank you. Good afternoon, Madam Chairwoman and committee. My name is Lauren Lipscomb. I am a Baltimore County resident. Today I'm here in my capacity as the chief of the Conviction Integrity Unit in the Baltimore City State's Attorney's Office, in which I've been a prosecutor for 20 years. I'm here today to provide testimony on behalf of the Baltimore City State's Attorney's Office and State's Attorney Ivan Bates. As well, I am the chair of the post-trial subcommittee for the Maryland State's Attorneys Association. We support House Bill 819 and urge a favorable report. Our reasons for support are threefold. First, the existing statutory construction is confusing and not user-friendly to even prosecutors and judges. As chief of the CIU in Baltimore City, I oversee all circuit court expungements, and I've managed expungements in various capacities since 2013. My unit is tasked with staying current on expungement law changes and reviewing petitions for eligibility. We have gotten to the point that one might need a degree in expungement law interpretation to accurately interpret the laws, given how confusing the language has in fact become. Second, the sheer volume of expungements coming through the system is huge. In Baltimore City, we've had over 580 expungements come through since January 1st of this year. Third, and lastly, ineligible cases are starting to slip through the cracks and being expunged. We are having situations in which there are cases where repeat offenders may be having cases that are ineligible and are automatically being expunged, and this puts public safety at risk. We believe that HB 819 provides a good step forward in studying the overall statutory scheme and addressing processing loopholes that are increasingly creating dangerous outcomes for our communities. In reviewing this bill, we would recommend that a stakeholder seat be included for the chiefs and sheriffs, as their agencies are also directly impacted by this. We urge a favorable report on House Bill 819, and I thank you for your time.
Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support on HB 819. A lot has changed in the past decade since the passage of the JRA, as you've heard today. And that includes a growing awareness on the myriad collateral consequences that follow individuals who have an arrest or conviction record. A lot of progress has occurred in this piecemeal approach. And as you've seen with the many expungement bills in front of the committee today, there's a lot of work to do. We love this bill because it really takes a step back and looks at this issue more holistically. And we believe strongly that, especially given the thoughtful diversity of perspectives around the table with this commission, that a lot of really important good work can be done. Our center does a lot of convening across research, policy, and practice to solve hard problems, and we feel that this expungement commission bill is taking that approach, and we urge a favorable report. Thank you.
Hi, my name is Jamie Grace Alexander, and I'm a paralegal at Baltimore Action Legal Team. BALT is a legal collective formed in response to community calls for legal support during the protests that followed Freddie Gray's murder in 2015. BALT is a legal services organization determined to deliver community-focused lawyering to over-criminalized Black Baltimore, and our direct service work includes warrant recall and expungement work, working to emancipate people from the lifelong weight of the criminal justice system. So expungement law is not at all self-explanatory. You've heard that from many other people. You needed a flow chart and at least 5 different forms to work through a record. Recent changes to expungement law have expanded eligibility for many people, but have not made the process simpler for someone trying to expunge their own record. A commission that examines Maryland's expungement laws would see the critical failures of a system meant to keep over-policed people criminalized while allowing one-time offenders clear preference. At BALT, the majority of our client work is expungement, seeing clients who have had criminal records for most of their lives, regardless of the time since their last charge. Often the only reassurance we are able to offer those people who have cases that are ineligible for expungement is the possibility of the laws changing. That hope rests with this voting body and in Maryland's legislature. A commission to examine Maryland's expungement law could help us simplify this process to something more reasonable instead of arbitrating people's past transgressions here year after year. If you're as tired as I am of debating the minutia of expungement law, I urge you to vote favorably on this bill.
Thank you. Please call in Stephen McDonald online.
Hello.
Hi, Mr. McDonald. You have 2 minutes with your testimony, please. Thank you.
Hello. Thank you, Chair and the committee. I'm here in support of House Bill 819 with amendments to add Section 5701D4 because it would allow courts to evaluate rehabilitation instead of forcing people to live indefinitely with technical statutory barriers. As a constituent of Vice Chair Davis, I appreciate the committee's consideration on how this legislation would affect me as a District 28 resident. When I was 18 years old, I was in a serious car accident where I received a spine injury where I was prescribed pain medication to treat it and became addicted. I didn't understand the risk of addiction and my doctor didn't educate me on it. And I began misusing the meds and ended up altering my prescription dosage. After serving my sentence, I was committed to recovery and now have been clean for 12 years. College was not financially feasible and my record would have created some barriers. I chose a trade school to try to get my life back on the right path. I graduated from a 5-year apprenticeship program and then got my master plumber's license. I'm a licensed tradesman and a primary provider for my children and family. My charge falls under criminal law section 5701D4, and while other statutes covering almost identical charges under section 5601 and section 8610 that are able to be expunged, mine cannot, just because of how the statute is written. The conduct is the same, but the statute is labeled. I'm excluded from relief. That inconsistency is what keeps my record in place. Right now, judges do not have the discretion to review my case based on the rehabilitation. I have worked hard to be held back. I feel everyone should get a second chance if they change their life for the better. Most union plumbing jobs I work for are on government contracts or federal facilities which require strict background checks. Because of my record, I've been denied placement, promotions, and missed opportunities to advance. Since I've had this charge, I've been in front of three judges that said they would have granted me my expungement just based on my accomplishments and how I turned my life around. But my charge is not in law, so I urge a favorable report.
Thank you very much. Members, do we have any questions? Delegate Woods.
Thank you, Madam Chair. Is it Waylon? I want to make sure I pronounce your name correctly.
Yes, Waylon.
Thank you so much. Thank you both for your testimony. My question is, if you don't mind answering, did you actually have a therapist to write the documentation about the past history and diagnosis in the request for expungement?
Well, I'm unable to get it expunged, so I wasn't able to talk to someone about it.
So you couldn't even have a conversation about the past history?
No, not really.
Madam Chair, is that okay?
I believe the question that you're asking is, because it wasn't, I believe the answer that we're hearing is because it was ineligible for expungement, there was no need to go to that, through those steps. Is that correct?
Yes.
And can I ask another follow-up question, just for clarification? Can you repeat for me again why I know you said they gave you a mass, threat type of, but is that the code that says you can't get the expungement, for clarification?
Yes, it's threat of mass violence, and it's currently not expungible on the expunge list.
Thank you. Thank you, Madam Chair.
Sure. Delegate Conaway?
Thank you, Chair. Thank you, committee, for coming in to testify. To the first witness, is your testimony written? Is it online?
Yes, sir.
What's your name again?
Zachary Alberts.
Okay. And can you tell the difference between the two trespass charges?
My understanding of the difference between them, not a criminal lawyer, but is that the main difference is one has posted signage saying no trespassing, and one is like you've been verbally notified that you shouldn't trespass.
Is that the 6-42 that you have in your letter?
6-403 and 6-402, yes, sir.
Yes, okay. But you don't know why the verbal one isn't expungible?
My guess is it's the onesie-twosie way. We've been adding expungible statutes over the years.
I have no clue as to what onesie-twosie is. So
bit by bit, how bit by bit folks come in and say, this is the charge I have on my record. This is the way it's messing up my life. Y'all realize that it's an issue and it should be expungible, and so you add it.
Okay, I thought you did a good job on your letter. Do you have a full list of all of the things that are not expungible?
I do have a full list. It's about 900 convictions.
Yeah, can you send that to me?
Yes, sir, happy to.
To that, can you send that to me today, please?
Yes, sir.
Thank you very much.
Would you send it to the full committee, please?
Yes.
Thank you very much. Members, do we have any other questions? Okay, seeing none, that concludes this panel. Thank you all for coming in to testify. I am going to call up Laura Wilt on the unfavorable panel. Thank you for being here, and thank you for your patience.
Good afternoon, Madam Chair and members of the Judiciary Committee. Laura Wilt, I'm the senior attorney, or one of the senior attorneys with Maryland Crime Victims Resource Center. And I'm here asking for an unfavorable report today on House Bill 819. I really wanted to get along and to say I was supporting this bill. I went through it in detail and our office discussed it. The problem is we recognize the importance of the issue of expungement and how untenable all this piecemeal legislation is. But we're asking you to look at the bill. A lot of times we all vote for commissions, but let's look at the detail. First of all, the purpose of the bill, the purpose of the commission, look at the language in number 3, and this is all in my written statement. It's to develop an alternative statutory scheme that provides a streamlined process. How about add the language streamlined process that protects community safety as well as allow broader eligibility for individuals. So we're not opposed to that. We just want our laws to reflect community and public safety and victims. The membership of the commission I go through this in detail in the written statement. Although the bill reads on its face to include a broad range of participants on the commission, the overall composition remains completely slanted. In summary, there are 16 members of the commission. Out of the 12 who are not senators or delegates, at least half of them are advocating from one viewpoint. So when you break it down, more than half are from one viewpoint, and the viewpoint of public safety is left to only 3 members. If this was a balanced look at expungement, it should include an equal number of victim advocates who work on behalf of those victimized by crime, public safety advocates. My written testimony suggests some of the other people that should be included. How about employers? How about somebody from the Office of Administrative Office of the Courts? Well, so with that, I just believe it's going to lead to biased outcomes that will not stop this gridlock. So with a more balanced commission, we would be happy to support this.
Thank you very much. Members, do we have any questions? Delegate Woods and then Delegate Ericon.
Thank you, Madam Chair. Can you talk to me about the racial disparities that impact persons requesting expungements in Maryland?
No, ma'am. I really can't comment on that. I mean, the laws are the same, whether or not they apply differently. I cannot. That's not my area of expertise.
Okay. Well, it is a fact that racial disparities have a major impact. People of color are more inclined to not receive expungements than those who are not.
And we are completely in favor of looking at the laws regarding expungement. We're not opposed to that. We just would like a balanced evaluation and a balanced panel.
Thank you. Thank you, Madam Chair.
Delegate Ericon.
Thank you, Madam Chair. Thank you for being here. Could you get us maybe a draft of exactly what you're looking for, just so we can have a copy of it, if you haven't already sent it to us?
Yes, it's not exactly a draft, but it does list the people that I suggest could be beneficial to such a group. One of the major complaints I hear is that it's so difficult to get this expungement done. People don't file because it's difficult. Well, then let's get somebody on the commission, not just a one-time visitor who, testifies in front of the commission one time, but people that actually work for the courts, work for Department of Public Safety, and, get those people in the commission as well, not just a one-time visitor. I know that's common practice. Yeah. Let me look at my letter and I'll update it.
Thank you so much. I appreciate it.
Yes.
Delegate Conaway.
And so why is it difficult to do these expungements? Why do people find it difficult?
Why is it difficult to,
You said people find it difficult. So why is it difficult?
I probably am not the best witness to that. I have seen for 30 years in practice, I've been in the criminal courts for 30 years. I have seen the petitions for expungement. There is a form created by the Maryland Judiciary. Yeah. It has a number of check boxes. It doesn't look difficult to me. And we have, but I'm hearing repeatedly it is. So I'm not, what I think we need to do is look at streamlining that process, making sure our forms are readable, making sure that the attorneys who are free attorneys at every courthouse across the state are ready to help get those filed.
So are you saying possibly the way that it's written, the language that's used is a little bit too difficult to understand for the layperson?
I cannot testify that they're difficult to understand. What I do agree, though, is it's extremely difficult to find out what is eligible and what is not. And but the Maryland Judiciary does publish, I pulled up a list of all the crimes that are eligible or not eligible. Okay. It's there, but the layperson's not going to be able to go through that easily.
Can you send that list to me? What's your name again?
My name is Laura Willett.
Yeah, okay. Can you send that list to me?
Yes, I have it up. I can send it right away.
Thank you so very much.
Yes.
Thank you. Delegate McComas.
Thank you, Madam Chair. I was looking at your letter, and what really struck me is that there were companies that have folks, home care, juvenile or senior centers, and very vulnerable adults. And then you always think of lawsuits for negligent hiring.
Yes.
And so somebody gets everything expunged and they look good and they're very personable, maybe a sociopath or psychopath, somebody that's very charming. You think, oh, this would be a great person to work for the company, and then they do something bad, and then can you be sued for negligent hiring?
Certainly, and I believe there are bills pending this session that would expand the liability for charitable institutions. That was one bill that we saw, that if a nonprofit or somebody's employing someone who ends up, you have to take certain steps to make sure you're not putting people in danger.
If you don't, and so if it's expunged, the person that got it expunged isn't going to tell you, oh, well, I just robbed, 20 years ago I robbed a bank, and then they're a teller or something. And the bottom line is you kind of need to know who you're dealing with, and there has to be a level of trust. And I guess what I'm concerned about is the liability for employers.
And really that we need to let our employers decide who is safe. If we eliminate that record from the public record, it's as if it never happened. I don't know how we can allow our employers, our neighbors, our family to make decisions that benefit them. If it's erased, you can't make that benefit. You're going to hire somebody to come into your home, you have no ability to make that decision. You're going to let them in because you don't know any different.
Delegate Cardin.
Thank you, Madam Chair. Thank you very much for coming to testify. Are you suggesting, I'm reading your testimony, that the Office of the Public Defender, perhaps legal aid, perhaps the ACLU are not interested in public safety? They're not advocates for public safety?
I would say that's probably not their number one concern. Yes. I would say their number one concern is protecting the rights of those who are convicted. Now, a piece of that is public safety because we want to protect their safety as well. But I would say that's not their number one concern.
Okay, just one quick follow-up is, so if a defense attorney believes that somebody is being wrongfully prosecuted, would it not be in the public safety to make sure that the prosecution is done properly?
I see your point, and I don't disagree, but if we're going to label someone, whether they're putting the public over an individual, then I'm going to say they are advocating for the individual over the public.
Okay, thank you.
Well, given some of this discussion, it seems that we do need a commission to discuss this issue.
I don't disagree.
Okay, great. Thank you so much. I appreciate you being here.
Thank
Members,
you.
That concludes this panel, as well as the bill hearing for House Bill 819. Now we're going to call up Delegate Taylor, and we're going to call House Bill 743. Actually, yes. Okay, so we're going to call up Christopher Dews, Christina Marquez, Frank Boston, Ari Plott. Okay, so I see your face. Are you saying you don't need to testify, Mr. Dews?
Home detention monitoring.
This is House Bill 743.
Me too, Madam Chair.
Thank you very much. There's a reason why I like you. Okay. Okay, Delegate Taylor.
Thank you, Madam Chair. Good afternoon, Chair Bartlett and members of the Judiciary Committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. House Bill 743 makes an important but narrow change to Maryland's private home detention monitoring law. Under current law, when a defendant on pretrial release is monitored by a private home detention monitoring agency, that agency must notify both the court and a designated law enforcement agency within 24 hours when there's a general violation. If there's tampering with the equipment, notification must occur within 1 hour. If the individual enters a prohibited area, notification must be immediate. This bill does one thing. It repeals the requirement that law enforcement be notified for pretrial monitoring general violations. Those are your violations that are within 24 hours. It does not change the obligation to notify the court in those instances. It does not change the immediate notification requirement for prohibited area violations. And it does not change the 1 hour notification for tampering with monitoring equipment, and then those more serious circumstances, notification to law enforcement and the court remain intact. Pretrial release conditions are set by the court, and this bill ensures the court continues to receive timely notice of violations so it can determine the appropriate response. By streamlining notification for routine or technical violations, House Bill 743 seeks to prevent unnecessary strain on law enforcement resources while still preserving immediate or expedited notification requirements for more serious issues like equipment tampering or entering prohibited areas. To conclude, House Bill 743 is just a modest adjustment that maintains public safety, preserves accountability, and promotes a more efficient use of resources. I respectfully ask for a favorable report on House Bill 743. Thank you.
Thank you. And whoever wants to go next?
Madam Chair, members of the committee, my name is Ari Plout, and I'm here on behalf of A1 Home Monitoring, here in support of House Bill 743. Thank you, Delegate Taylor. You did an excellent job explaining the bill and the purpose behind why we support this bill. Members of the committee, if you recall 2 years ago, 2024 session, City Administration had a bill, and that was the crux of where this home monitoring all came from. It was a bill from 2 years ago. And Delegate Taylor broke it down perfectly. There's 3 categories, and for each category, there's 2 requirements of notification. First category, an exclusionary zone. If the defendant violates an exclusionary zone, then there's an immediate notification to both the police and the court. If the defendant tampers, then there's a 24-hour notification, 1 hour notification to the police and the court. And then if there's any garden variety type of violation, then that would require 24-hour notification to the police and the court. All this bill does is remove the requirement for those garden variety violations to notify the police. And why do we believe that it's unnecessary? There's no warrant that's issued, so the police are getting these notifications. They're not really doing anything with it. As Delegate Taylor stated, we support all the provisions of the bill, except we feel that this one minor change is for judicial economy. The chiefs and sheriffs, I believe, submitted a letter of support, and they're on board with this bill as well. And the only other last thing I would say is if it's up to the will of the committee, then you can make it prescriptive for specific violations. But just to have a category of all violations have to go to the police, we feel that's unnecessary. And with that, we'd ask for a favorable. Thank you.
Thank you. If you want to go next.
It seemed like Me Too is the way to go. They've done a wonderful job of explaining it. Just to narrow it down a little bit more, in 18 months, we've been doing the bill that was passed in 2024. And I personally believe it was a needed bill. We did need to restructure the way the violations were reported. Accountability needed to be had with the timeliness of them. But now that we've done it for 18 months, we're seeing where certain refinements could come in to better help home detention, the judicial system, law enforcement, and everyone to kind of streamline the process. As they said briefly, they fall into 3 categories. An exclusionary area, which would be a stay-away zone or home, is an immediate notification to the court and law enforcement. A 1 hour notification is a tamper of which somebody cuts their band or they have a dead battery. Everything else falls under a 24-hour notification. The court continues to get those notifications, as does law enforcement right now. As much as I wish they would care, law enforcement can do nothing with making them pay me if they don't pay. That is one of the examples. If they stop at McDonald's after work, we are notifying the court that they did not go with the schedule that they were supposed to. Law enforcement, by the time they're home in 24 hours or back at work or what, are not reporting to that. They're not doing anything. The way that it is currently set up, the failure to provide a receipt from McDonald's is in the same category to be looked at and to be cataloged as an exclusionary area. So if there's 10 alerts that come through at the same time, and the 7th is an immediate response and needs action, the police officers have to look through and decipher whether the other ones are actionable before they even get to that 7th one. Thank you.
Did you finish your sentence? You can finish
Yeah,
your
I
sentence.
just was,
Okay.
yes, I did. Thank you.
Okay, great. Mr. Boston?
Yep. Madam Chair, members of the committee, I'm Frank Boston III. I am here today on behalf of A1 Monitoring Company. We strongly support this bill, and thank you very much, Delegate Taylor, for sponsoring this common sense legislation. Delegate Taylor, Mr. Plout, and Ms. Marquis did a fantastic job explaining the bill. Anything else I say would certainly be repetitive. I'm here to answer any questions.
Great, thank you. Can you bring in Mr. Brian Frank online? Hi, Mr. Frank, you have 2 minutes for your testimony, please.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Brian Frank. I am a principal with A1 Trusted Monitoring, which is a private home detention monitoring agency. We are testifying in favor of this legislation. The goal of the legislation is simply to refine Section 20-401, specifically notice to law enforcement in instances where the violations are what I would define as the garden variety violations. I'm sure my colleagues have discussed the 3 categories of violations, so I'm not going to repeat that. The rationale for the change is that law enforcement cannot and does not do anything with those garden variety violations unless and until a warrant is issued by the court. And remember that in all instances, the court is receiving notice of the violations and making the determinations as to whether or not a warrant should be issued, a show cause hearing should be held, or to do nothing with respect to the reported violation. I expect that you'll hear Chief Judge Morrissey testify against the change, essentially asserting that other committees are looking at this home detention landscape and that we should wait for a complete and comprehensive study until acting. Several responses. I wouldn't sacrifice a good change in the pursuit of perfection. The chiefs of police support the legislation. I can tell you that in Baltimore City, based on the estimates we were able to gather, there are about 400 private home detention monitoring agent violation notices submitted each year. And of those, 80% are the garden variety. If you translate that into the number of man hours, assuming an hour per violation, that would be almost 8 weeks of one person's time. Thank you, and we respectfully request that your committee issue a favorable report.
Thank you. Members, do we have any questions for this panel? Delegate Conaway?
For coming in to testify. I don't know who can answer this, but what is the meaning of the garden variety of violation? What can, you have 5 of them that you can give an example of?
Yes.
Garden variety?
Yes, Delegate Conway. First of all, the 2 other categories are the exclusion and the tampering with the unit, but the others might be making an unauthorized stop, failing to provide documentation for so-called appointments that would otherwise be allowed, failing to pay certain fees, failing to participate in a program. Those are the kind of, I'll call them technical type violations that violate the court's order, yet, you know, there's nothing that the police would do about those violations.
Okay, and did you read the judiciary, what their her letter said?
I did not, I did not, Delegate, but I did from the last time that there was
Well,
testimony.
didn't you did comment on what you thought Judge Morrissey might say.
Yes, because of his prior testimony.
So he's going to say something different than this letter says?
I don't know what.
Okay, this letter says removing the requirement for private home detention agencies to notify law enforcement of court-ordered home detention violations, comma, even minor violations, risk weakening accountability and delaying critical responses necessary for public safety. You disagree with that?
I do disagree with that because of our experience with the Baltimore City Police Department, where they take specifically no action. They examine the priority and severity of the submitted violation and take no action on all of those items that I mentioned. If there's a specific garden variety violation that Judge Morrissey would suggest be included for notification to law enforcement, we, of course, are mindful of public safety. We just think this currently burdens public safety and the police.
Right, so you're saying that because Baltimore City law enforcement doesn't take any action, it doesn't need to be reported?
No, it's still being reported to the court first and foremost. They make the determination that there's nothing that they can do or will do until a warrant is issued, because they want a judicial determination in those instances that they should take some action.
Thank you.
Delegate Conway, it still gets reported to the court within 24 hours.
Yeah, I understand that, but why wouldn't it get reported to the police department?
May I clarify?
Go ahead.
Sure.
So the immediate and anything that's actionable by police would 100% get reported. It doesn't change here. The things that they really have already told us in their program of how they categorize them is not actionable are the items that we're asking to not have to be reported directly to law enforcement and instead would only need a court-required notification. That way, the court can deem, if they decide to do a warrant, we would notify law enforcement of that instead. So like Brian said, it could be that they stopped at McDonald's on the way home from work and they didn't give a receipt. They didn't pay us. We've had issues where somebody had to go to the hospital. It's not in their court order where they can seek medical treatment. So we have to do a technical violation that they went to a medical appointment. Even if they're back home, they're back at work, they've given us all the documentation, we still give that to the court. And right now, we have to also give that to police, but they aren't doing anything with it. So it's those type of things that we're trying to say, now the police officers are having to categorize all of these violations when it's more important to public safety to give them the ones that they can actually go out and handle.
Well, thank you for your explanation.
Thank you.
Delegate Mangione?
Thank you, Madam Chair. Excuse me, thank you for being here. And I guess my question would be, just so I understand how it works with the monitoring, is how the agency would determine whether or not the individual that is late, I guess, to return home while they're on the monitoring, like how can you tell that that's not a safety issue? Or you're saying the reporting happens after the fact? Like how do you know if somebody's late because they stopped at McDonald's that they're not about to go commit something serious because they didn't actually be where they're supposed to be?
Right now, that falls under a 24-hour category. So we don't determine whether what they did was justified or not. We have to notify the court regardless. But we're saying we were notifying the court and law enforcement simultaneously with that alert. But at that point, they are most likely home or back to work. That law enforcement is just not acting on those things. So it's better to alert law enforcement of the things that they are actually able to act on.
Okay, so I guess, and again, this is, I mean, just honest, just trying to learn how this works. I mean, if you're on this monitoring because you've committed some type of act, you're being monitored 24/7, right?
Correct.
And there's a time frame for when you're supposed to return home, right?
That is correct.
Yeah, and I understand you're saying after the fact that you shouldn't have to report. I guess that's what you're saying, if it was determined that it was only somebody went to McDonald's and didn't have a receipt. But I'm saying, what about that real time? And maybe it's not even in regards to this bill, but real time not being where they're supposed to be and reporting that to law enforcement, so therefore they can act. You see, is there, that's what I'm wondering, if this may inadvertently cause a problem because of the real-time action of somebody we can't deem is not dangerous or could be dangerous.
This bill doesn't change anything that's already ordered for us to do. So in real time, there is not anything that currently has us produce a violation within a minute of them not being home or something. That is a 24-hour violation under everything that's already in law.
Okay, so you have 24 hours to make that
The
report.
only thing that is if there is an exclusionary area. So if you have a stay away order from a particular zone or property or something, that if they enter that area, that is an immediate
So like a domestic dispute, you would have a GPS saying that maybe they're next to their ex or whatever.
Yes, we have zones and then we have
instantly
buffer
targets.
zones. So we know if they're getting close and then we know if they're getting in. And that is an immediate call to law enforcement and a violation to the court. But
Thank you
anything just outside, that is not, that right now under law, it requires a 24-hour notification so that the court can see they're stopping at McDonald's every day or they're coming home late, but that doesn't currently, it doesn't require immediate notification.
I understand much better now, thank you.
Delegate Aragon.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. So the case I'm trying to wrap my head around, and I guess the argument that I'm trying to wrap my head around is that because, as Delegate Conway mentioned, one jurisdiction is being kind of unresponsive to this stuff. So there's obviously some discretion here in what they follow up on. So, you know, we're looking at specifically, you know, one of the worst cases I've seen for one of my constituents was the Dante Harris and Amy Caprio case. His mother repeatedly called to say, my son is on an ankle monitor, he's missing, he's not coming home, can somebody please help? I mean, she called over and over again to the very jurisdiction that you guys have identified as using a lot of discretion, or has been. So I guess I'm kind of wondering, you know, how can we make sure that, I mean, look, two mothers lost their children because of this case, right? We had a boy on an ankle monitor, and his mother was desperately trying to save her son from making a mistake and could not do it despite calling over and over again about his violation. How can we make sure that that specific situation just stops happening? You know what I mean? How come, and does this bill really get us going in that direction of preventing these kids on ankle monitors from just vanishing and us not even trying to find them?
If I could, Delegate, I think what you're speaking about are those juvenile cases, and those juvenile cases were not by private home detention monitoring agencies. When someone's not where they're supposed to be, they are reported within that 24-hour time period, unless it falls under some kind of tampering or exclusionary zone. That wouldn't change. That would still go to the court. This court would still make the determination to issue a warrant, and that's when law enforcement would dispatch somebody. So that's the chronology of what would happen. What we're trying to address is what I've called the garden variety or Mickey Mouse type events. So your circumstance would not result in any change. It would still be ultimately reported, and then the court would make the determination that someone wasn't where they were supposed to be and issue the warrant.
I do understand that the court, my issue would be cutting out the police notification and going straight to the court notification, because even though one jurisdiction maybe isn't playing ball right now and they seem to be using wide discretion, we don't want that, really. We don't want that wide of a berth because people are losing their lives. So, and I just don't know if this policy is in line with our consistent attempts by this body to tighten down on these kind of violations, or if it's actually loosening it, and so we could potentially see more of them.
Well, as I mentioned, if there were specific circumstances that constituted garden variety that the court or the legislature determined should be added to the list, that would be great. We would be more than glad to comply. We just see it as inefficient both for the police as well as the system to burden them with 80% of their notices are do-nothing type notices, which again would translate into man hours that would otherwise be able to be used, for example, on serving warrants where a home detention defendant has an open warrant, and we're able to work with the police to direct them exactly where they are and even issue a siren so that they can be picked up by the police at the location.
Well, that's certainly a useful feature, but yeah, I'm still there. I still think there's a way for us to get after those folks as quick as possible, and I'm disappointed that there's still a jurisdiction who's not participating. So thank you.
Thank you.
Thank you. Members, do we have any other questions? Okay, seeing none, that concludes this panel for, no, it does. Yep, it does. I'm sorry. That concludes this panel for House Bill 743. We're going to call up Chief Judge Morrissey for unfavorable panel, please.
Good afternoon, Madam Chair Bartlett and Vice Chair Davis, members of the committee. I'm glad Delegate Taylor is out of the room because I respectfully oppose her bill, even though she's my own personal delegate. I'm sorry, darn it. I'm sorry, Delegate. She does a wonderful job for District 23, and I voted for her. Oh boy. So originally in the 2024 legislation, the judiciary supported this bill because it had the 3 tiers. We wanted an immediate, we wanted a short term, and we wanted the 24-hour notice because we thought that would comprehensively kind of pick up the system. The system needs work, and I'd like to compliment Delegate Williams as well as Senator Hedelman for their work on the legislative Justice Reinvestment Work Group. I'm a member of the Justice Reinvestment Oversight Board, and I've asked them to create their own work group. And Carlos Acosta, Judge Acosta, who's a circuit court judge out of Montgomery County, is spearheading that. And we're looking to put in a justice reinvestment type of structure around this. There is no structure with the private home detentions. It's licensed by the Department of Public Safety. It's paid for by the judiciary, but there's really no regulations that go on with this. There is no garden, Delegate Conway, as you aptly pointed out, there is no garden variety of violation of these things. These are violations, and whether law enforcement is acting on it or not, I would hope that they would. I would hope that they would find it important that there would be repeated violations of an individual, say, going to a particular parking lot 4 or 5 times in an hour period at 2 o'clock in the morning. It's wrong to say that there has to be a warrant in order for someone to be arrested. Police have the ability to do an on-view arrest if they see criminal activity afoot. In violation of your pretrial home detention is a criminal violation. So I don't know why, it may be a lot of work for the private home detention to send this notice, and it may be a lot of work for the police to take a look at this and decide whether or not they're going to act on it. But I think out of an abundance of caution, we want to make sure that safety is the primary concern here. So I would ask this committee just pause for a moment. Let us try. We're hopefully going to combine the legislative work group with the Justice Reinvestment Work Group. We have all the players there at the table. I think we can come up with a comprehensive type of structure, very similar to the way that Justice Reinvestment works with technical and non-technical. The private home detention companies are part of that, and they'll be a voice to that, as well as the police, all the other players. The Governor's Office of Crime Control Prevention is staffing that work group. So I would ask this committee to give an unfavorable report, and I'd be happy to answer any questions.
Members, do we have any questions?
Thank you. Sorry, Delegate Taylor. Thank you. Did you? No?
No,
okay.
Okay.
Thank you, members of the committee.
Thank
I
you.
appreciate
Thank you,
it.
Chief
And I
Judge.
thank you for taking me.
Thank you very much. You have a good day. Members, that concludes our bill hearing for House Bill 743. We're going to quickly move to, just 1 second here. Delegate Taylor, if you don't mind, I want to go ahead and take Delegate Buckle, who's here, and then I will come back to House Bill 187. Delegate Buckle, thank you for your patience.
No problem.
This is House Bill 463. We have for your panel, Laura Wilt and Linda Duncan.
I believe that's correct. I'm not
Okay.
sure. I just came in. I know there's Ms. Duncan.
Also, we have Ann Pack. I saw, yeah, okay.
I have info.
We have his info. Do you, are you going to testify unfavorably or with an amendment?
I'm going to testify with a recommendation for further stuff.
Okay, well then we'll call you up in just a second. Thank you. Delegate Buckle, whenever you're ready.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, and members of the Judiciary Committee. I appreciate your time and indulgence this afternoon. I know you hear a lot of difficult issues and spend a lot of time here. House Bill 463 is really very simple. In recent times, I was very happy to support Delegate Embry's bill to eliminate diminution credits for those convicted of first-degree rape, a bill which I believe its genesis was the horrible situation that occurred to Pavel Lepere in Baltimore City, I believe in 2024. I think members of this committee that served during that time are pretty familiar with the horrific circumstances of that incident and how the individual who committed that crime was someone who had been repeatedly convicted and incarcerated for sexual offenses prior to the culmination of his criminality that resulted in her rape and death, and also the rape and attempted murder of other individuals prior to Pavel Lepere being involved with him. First-degree murder is blessedly a fairly rare occurrence. I wish it never happened in the state of Maryland. I wish no one committed the type of predicate acts that result in a first-degree murder conviction. The fiscal note reveals that in the last year there were roughly 100 convictions in the state. That's going to fluctuate from year to year, but it seems like a reasonable baseline number. I want to make very clear that when we talk about eliminating diminution credits, we're talking about the absolute worst of the worst. If a first-degree rapist is a horrible human being that did something that takes away a part of someone's humanity that can never be restored, then certainly someone who commits and is convicted of first-degree murder is a similar individual. They took away someone's loved one in a way that can never be brought back. They did something that is beyond the pale of our human civil experience, and they did something that may very well resonate with a certain level of criminality and ease of violence that cannot be remedied. The purpose of the criminal law is multifaceted, but one of the purposes of the criminal law is deterrence. It is to prevent individuals and to provide that knowledge to the community that if you do something so heinous as first-degree murder, it's not accidental, it's not felony murder, it's premeditated, malicious murder. And if you do that, I don't believe that our correctional system should work to get you out of jail earlier after a jury, a judge, parole commissions, whatever it may be that has the right to establish that early release date for you. Why are we giving you diminution credits for quote unquote being good while you're in prison? And I can't fathom the logic that says diminution credits don't apply to first-degree rapists, which they shouldn't, and I'm glad that Delegate Embry took the lead in making sure they don't. They should also not apply to those individuals who committed first-degree murder, which is what Jason Billingsley, who killed Pavel Lepere, that's what he's in jail for today. He's not there for first-degree rape. He's there for her murder. Thank you, Madam Chair.
Thank you. And whoever is next, please.
Hi. My mom, which is 67 years old, was the victim of a heinous violence act, the first-degree felony murder of 15 years ago, her murder occurred in 1990. About 15 years ago, her killer was finally apprehended, and I thought justice would be served, but it wasn't. 2 years later, in 2007, I was informed of her that he was eligible for parole due to something called diminution credits. And after researching its background and purpose, I became inspired to start my journey in getting this bill to eliminate diminution credits used to reduce the time served in felony first-degree murder. In addition to amending the existing bill, diminution credits on first-degree murder, I wanted to present an alternate, if anyone's interested after the hearing, of how the diminution credits can be used, because I'm not saying get rid of diminution credits, but get rid of how you use them to be only used during incarceration and to make the person a better person coming out, more functional coming out. That would redirect the credits. As the sentence that's stated by law, the felon would do the complete sentence, and this bill, as Delegate Buckle said, was approved for the Parole bill, which I was here last year. I've been doing this for this is now my 11th year trying to get this bill passed. And for the Parole bill, it was presented in January, and it was passed within 4 to 6 months afterwards, only one time. But then that's because she was a friend of the mayors, of the governors. And what we would like to do is to have the same respect for our mom, to get this bill passed, to stop allowing diminution credits to be used to reduce the time served on a sentence of first-degree murder.
Thank you, Ms. Duncan. Ms. Wilt?
Good afternoon again, Laura Wilt, Senior Counsel with Maryland Crime Victims Resource Center. I am asking for a favorable report today on House Bill 463. The sentence for first-degree murder represents a justice system's the most serious sentence, a recognition of the value of human life taken through intentional and premeditated violence, knowing that the offender's release date is constantly moving. It's a moving target, with diminution credits reducing the period of incarceration for the offenders. Surviving loved ones often experience secondary trauma, the reopening of trauma, and the quiet erosion of the accountability of the court's sentence that the court sentence was supposed to represent. Families of those who were murdered live with that loss for a lifetime. Their loved ones, what we hear over and over again, their loved ones do not receive a reduction in the permanence of death, and the one that killed them should not either. Yet under current laws, victims' families are overwhelmed by the numerous post-conviction hearings and modification rights allowed to offenders. House Bill 643 promotes transparency, certainty, and integrity in sentencing. Clarity and finality in sentencing means the chance at emotional stability for the survivors of homicide. It allows families to rebuild their lives without the reoccurring fear that the sentence that they were relying on will be shortened. We believe this bill is a step towards increasing the sense of safety and control experienced by survivors of violence, and we ask you to remember how many of them exist in your jurisdictions when you're voting on this and other bills that promote integrity in sentencing. Thank you.
Thank you. Members, do we have any questions? Delegate Ericon?
Thank you, Madam Chair. Thank you, Ms. Duncan, for being here. Again, you said 11 years you've been fighting for this.
This is going on my 11th year. Some of you look familiar, some
Yeah,
of you kind of
we
new.
appreciate you. Delegate Buckle, thanks for coming here. I was trying to look at the history of this bill because Ms. Duncan had mentioned she'd been here 11 years. Did you submit this bill last year?
This was part of our Republican caucus bill that not only eliminated diminution credits for first-degree murder, but also included a variety of other limitations on reductions of sentence or violent offenders. I believe it's been, for a couple of years, it's been an element of that. We've worked with the committee to try to narrow it down, and in recognition of Delegate Embry's success on a bipartisan basis of eliminating diminution credits for first-degree rape, we elected this year to tailor and narrow the bill to diminution credits for first-degree murder.
Oh, okay, that must be why I actually don't see it anywhere in your history. Thank you.
I have my notes. Delegate Woods.
Thank you, Madam Chair. I was just trying to, thank you for the bill. I was just trying to understand, or can you help me understand, what is the average number of diminution credits a person who's committed first-degree murder might obtain?
I don't know if I could tell you what the average credits would be. I think the Department of Corrections probably would have to do that analysis because it's very dependent upon individuals' conduct and what they do. There's a variety of things that they can do while incarcerated to accrue diminution credits. Typically, for these types of crimes of violence, they're limited, and I think that you can see that in the fiscal note that diminution credits for first-degree murder do not accrue at the same rate as they would for stealing a car or a drug offense, and they shouldn't. But it would be difficult for me to say what the average amount is. A lot of times, diminution credits can anecdotally reduce your sentence by 33, 40%, somewhere in that range. In terms of the actual time that you were incarcerated.
Could you possibly see if you can find that out?
Yeah, we can ask the department if they have some analysis of that.
Sure, thank you. May I have a follow-up? Thank you. Also, I'd be interested in knowing, because I know just in the same way you can earn the diminution credits, they can also be revoked. So I'm also interested in knowing what's the average number of revocation and as well as what's the average number of diminution credits?
They definitely could, and hopefully the department keeps track of that data that could share with us. Someone can be a, I don't know, I would use the word model, but someone can be a prisoner who's trying to abide by the rules for a certain period of time, and then can have an episode that demonstrates that they're not ready for that type of diminution credit assessment.
I'd love to receive some of that updated information.
I would too.
Thank you so much.
Thank you.
Thank you, Madam Chair.
Can I say something?
Can you just, be perfect. Can you hear me? Okay. I looked that up, and it used to be they could get like a total of about 5 days a month, but it has increased. They can get a total, they can earn diminution credits for little small things like doing extra jobs inside the prison, and the jobs isn't anything to make them a more conservative or better citizen when they come into public. They take classes that would give them some extra credits, but it is a little bit more than 5 days a week, and it does add up.
5 days a month?
I mean, a month.
Okay.
And I would say, trying to be responsive to my friend Delegate Woods, I just glanced at the fiscal note, and it says that there is a Maryland Diminution Credit System report published by the Department of Legislative Services just a couple months ago in December 2025. There's a hypertext link, which I'm not very good with computers, so I just have it printed off. I can't get that. But I think maybe, I'll definitely take a look at that and see if that provides some of the information, and you'll have access to that too through your computer system.
Greatly
and hopefully that Maryland Diminution Credit System report contains some of that information.
Thank you so much. Greatly appreciated. Thank you, Madam Chair.
Thank you. Delegate Cardin?
Chair, first of all, thank you all very much for coming, and my condolences to you, ma'am, on your loss. Delegate Buckle, you do a good job of describing the worst of the worst and the heinousness of first-degree murder, and there's no doubt about that.
Yeah.
But you do spend much of your time in the Ways and Means Committee, not in the Judiciary Committee. Is that
By the grace of God, yes.
Fair enough. We have people come in here, and we've had first-degree murderers come in here and testify before us. And there are those that I would venture to argue that probably deserve to be in jail for 40, 50, 60, 80 years. There are others who come in and testify, and it is clear to us that in spite of the heinous crime they may have committed, that they are a risk to be able to at least venture to try to rectify what they have done and become a positive source. And if we remove that ability, remember, there is oversight on all of this, right? I mean, you just indicated that there's ability to take away, give, but there's also Department of Corrections that looks at this as both a tool to be able to control inmates as well as a ability to be able to advise us on who can be good returning citizens. So if we take away this tool, we take away that information.
So what I would say is, what we're not taking away is all of the other, and I believe individuals on my panel have talked about that. If you're convicted of first-degree murder, and you're sentenced to life without the possibility of parole, that is a judicial determination that you shouldn't be getting out of jail. Now, we've created other things depending on the age and the circumstances of your crime. The second chance, Delegate Pasteur's on our committee now, she's a wonderful lady. I don't want to mangle the name of her bill. Second Chance, Second Look Act. There's a variety of other ways that you can do it without the fairly technical mathematical application of diminution credits. So I believe that you're correct, that there are individuals out there who can provide oversight and try to look very hard at the actual records and into the soul to the greatest extent you can of another human being and determine, are you no longer a risk? Are you someone who has demonstrated the redemption necessary to return to civil society? That won't be changed by eliminating the diminution credits if you are convicted and sentenced to life with the possibility of parole. Parole Commission still has control over you. Probation system still has control over it. Diminution credits are a fairly mathematical application. As Ms. Duncan indicated, if you're incarcerated for 30 days and you were a good prisoner, you didn't stab anybody, you didn't fight anybody, you didn't get any administrative write-ups, you get a credit for that number of days for just being there. And prisoners understand that. I live in a community that has probably where the majority of the first-degree murder convicted individuals in the state are incarcerated is at the North Branch Correctional Institution, about 10 miles from my house. I have relatives, friends, clients that work there. And they will tell you that certainly the individuals incarcerated there, they get knowledge about this very quickly in the system. They find out, hey, if you don't do anything wrong, as you indicated, it's used as a tool to incentivize better behavior. But I think there's still plenty of options in Maryland law for an individual who is eligible for parole, eligible for the Second Chance Act, eligible for other judicial relief to come in and present to a fact finder that they're appropriate to get out, as opposed to we just applied a mechanical application of the number of days you were here and let you out years early without that oversight.
Can I follow up on something that the delegate stated? Yeah, so diminution credits also allows them to, okay, the law states you have to do at least 50% of your time before you can come up for probation. And we even with murder, but diminution credits helps to shorten that 50%, and it should not. You know, they should do the 50% at least on there, because a lot of them now, they're not getting life, they're getting, I've forgotten what it's called, but they have like, they do the 40 years or something like that. But they should serve, the diminution credit should not interfere with at least the first 50% mandatory by law.
Thank you.
Delegate Conaway and then Delegate McComas.
Thank you, Chair. Thank you, Delegate and panel, for bringing this bill. Delegate, was this diminution credit topic talked about in 2017 during the Justice Reinvestment Act?
You know, my friend, you may have a better recollection of that than what I do. I don't recall it specifically coming up.
Why is that?
Well, you know, you're a smart guy.
I was here.
And the Justice Reinvestment Act, as you well know, brought together a wide variety of different criminal justice applications, some of which increased sentences or increased punishments for certain crimes, and some of which reduced it for others. And I think was sort of an omnibus approach to it. So I don't recall that exactly.
Okay.
And, you know, I do want to make sure, I'm just talking about first-degree murder.
Yeah, so what it says here was the first-degree murder was capped at 20 days per month for violent crimes, including murder, even as others saw an increase to 30 days.
Right.
So some people get more diminution credit.
That's correct.
Than the ones that do murders, but we did visit this in 2017, right?
Yeah, you did.
Yeah, I think that's and that sounds accurate to suggest that, and that's kind of what I was trying to allude to. You know, if you're convicted of stealing cars, you should probably get diminution credits, and you get them at an accelerated rate compared to this crime. But my perspective, quite simply, is that this crime is not ripe for diminution credits at all. It's ripe for, just as first-degree rape is not, it's ripe for an actual evaluation by a parole commissioner, by a judge, by a panel that really looks at the totality of the incarcerated individual and determines, are they ready to return to society? Have they paid their full debt? As opposed to, we just use math and say, well, you were here long enough, you counted your days off, and now you get out early.
Well, thank you very much for your answer. And just so you know, when I first came here 20 years ago, I was in agreement with you.
Thank you.
Members, do we have any other questions? Delegate McComas?
Thank you, Madam Chair. Ms. Duncan, it rang a bell. And
Yes.
I remember, I can't remember what our bill was about, but I remember your mother.
Yes.
And I remember the pictures, the crime scene. And isn't it fair to say we used to present them to the committee and then we got banned, correct?
Yes, that's why I didn't put anything out.
Right. Well, I think the committee maybe needs to, if you want to, kind of explain the horrific crime scene, how little your mother was and how many times she was stabbed. And I think wasn't the pretext of theft initially? I forget, but I know, I still see Mom, and I know that you tried many times, and we were unsuccessful, but it was a very gross murder. It was a horrible murder, and your mom didn't deserve that, and she was a lovely little lady.
She was very little, yes. She was 67 years old. She was very small in stature and everything. Apparently it was a robbery because they had first-degree felony, but she was stabbed over 30 sometimes. She did try to defend herself, but no woman has the mask of a man, muscle mass of a man. And she was tied with a scarf around her mouth. The knife was left in her throat. It was pretty heinous. It's very, very bad. But the thing of it is, with the diminution credits, is that I am not saying to take them away, but for certain crimes, we need to reevaluate how you give them to them. These inmates they're not stupid. They know that if they wash dishes and maybe go to the library, they can get a couple of more credits added on to them. They're doing small things. These are things that it's not going to help them be productive and contributing when they go into society. And the first thing is to make sure that they have repented, that they forgive, that they realize that they've made a mistake. So diminution credits should be used inside the facilities, but not to shorten time on first-degree felony murders.
Thank you.
Yes, and thank you.
Thank you, Ms. Duncan, for sharing your story about your mom. And members, do we have any other questions? I'm so sorry for your loss. Seeing no further questions, that concludes this panel for House Bill 463. We're going to call. Thank you. We're going to call up let's call up info first. Ann Pack, please.
Thank you very much. Ann Pack, co-founder and director of advocacy for Prepare, and we actually work in parole advocacy. And so I just want to start by saying all first-degree murder charges are life sentences. All life sentences are not first-degree murder charges. So because all first-degree murder charges are life sentences, this falls squarely into 7301D with parole. So the parole eligibility is not 50%. It is 15, 20, or 25 years minus diminution credits. And this is really important because diminution credits is integral to the calculation of the parole eligibility for everybody that we're talking about today. So if you want them to have access to parole in the order that they currently have it, we need the diminution credits. And because a life sentence, with the exception of suspended life sentences, most life sentences do not have an expiration date. They do not earn good conduct credits, which means they can only earn up to 10 diminution credits per month because of the one assignment rule, which means they can only have one job. They can earn ICs or ECs and SPCs, so that's 10 days per month. And that's current DPSCS policy. So even though the law might allow for somebody to earn up to 20 days, they only have the opportunity to earn 10. Currently, we have a major problem with parole eligibility and life sentences. We've got those 3 calculations I've talked about. There's the impact of 4 Maryland Supreme Court cases that make it more complicated, and 3 later statutory changes. Some people get no diminution credits, some people get no parole, some people you have to look at the type of sentencing hearing to figure out which calculation they go under. Some people have gone back to court because their sentence was determined to be an illegal sentence, and there are still unlitigated issues. So really, this would add calculation number 13 and 14 to the 12 that we already have. And I really would like us to come to the table and talk about this with a group of people, a group of experts, so that we can return with a reasonable way to simplify this process.
Thank you. Members, do we have any questions? Thank you. Seeing none. We're going to move on to our unfavorable testimony, John Sexton and Edward Kinney.
Good afternoon for the second time, committee. First, let me just say that I'm sorry to all the victims of violent murder, period. The devastation and torment that they go through is incomprehensible, and we have to recognize that. A lot of what I had to say was going to be what Ann just said. So on a criminal law 2-201, the judge doesn't have a choice. He has to issue either life without parole or he has to issue a life sentence, one of the two. Once that happens, the diminution credits that are earned don't go towards a release. It only goes towards your initial parole hearing. Once your initial parole hearing is had, all the diminution credits that's been accumulated go to 0, and you no longer earn the diminution credits. They're no longer calculated. The other thing I would say is that it was just a couple of years ago in 2021, rather than 15 years, we raised it to 20. So it was just a couple of years ago that we raised the time up. Once the parole commission comes into play and they take it off the tape when they hear your case, it all goes away. The diminution credits doesn't really have any applicable unless the judge changes your sentence. I would say unfavorable because I don't think it's important to keep them, even though that it doesn't really have any appreciable effect to the release date. It's important that they have them because most of the time they're the ones that feel the most guilt and shame, and what they work towards accomplishing things, and they're the ones that facilitate things for younger people to try to get them on a right path and try to save people from doing the same things that they did. Thank you.
Thank you. Mr. Kinney?
Good afternoon. This is Edward Kenny from the Office of Public Defender. We are urging an unfavorable report here. And I agree with some of the things that have been said, but I disagree with some others as well. And I think the first thing I'd like to say is this. 55% of first-degree murder sentences are suspended, which means there's a term of years sentence. So it's not an insignificant number of people who will have an expiration date on their sentence. And that's what this bill affects. Now, the public defender represents most of these individuals. We represent, and we think about like a standard, the average person, which is a life suspend all but 36-year sentence. We represent the person who has done everything they're supposed to do, is working, has stayed out of trouble, has gotten maybe their high school diploma. We also represent the person who's done none of those things. We represent the person who has committed infractions, who's committed assaults. We represent both those people. We need to be very clear what this bill says. 2 people serving a life suspend all but 36-year sentence. One person's doing everything right, one person's doing everything wrong. This bill says they should be released at the same time. The current system says The guy who's doing the things right gets released a little early. So that's point number one I'd like to make. And then point number two is this, which I think is really significant. If you commit an infraction in the Division of Corrections, what happens? Have we thought about this? Because today what happens is you lose your diminution credits. That's the penalty. So I believe in deterrence, as the senator said. And I think diminution credits, the system creates deterrence. Crime fell across the state of Maryland last year. Incredible falls all across the board, except one exception. What was that exception? That exception was the Division of Corrections. 13 murders, that was the most in a decade, right? 3 already this year. Now is not the time to be getting rid of diminution credits. And so, members, I would strongly urge you to vote down this bill. Thank you.
Thank you, Mr. Kinney. Thank you, Mr. Sexton. Hold on one second, members. Do we have any questions? Seeing none. Thank you. You are excused. That concludes our bill hearing for House Bill 463. Members, we're going to Delegate Taylor. I appreciate your patience. We're going to go back to you on House Bill 187 and continue in our order as presented unless there are any extenuating circumstances. I'm going to call up Megan McDermott, Melissa Rothstein, and Christopher Dews. And Delegate Taylor, whenever you're ready, and Mr. Dews is being called. Thank you.
Okay. Thank you, Madam Chair. Good afternoon, Madam Chair, Vice Chair, and members of the Judiciary Committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. Just want to start off script. This is my favorite bill. Just want y'all to know. Okay. Same as last year, this bill seeks to correct a problem faced by Maryland legal aid and pro bono attorneys who work or volunteer their time during expungement clinics. I decided to pursue this legislation while attending an expungement fair in my district. During the fair, I sat down with a couple of attorneys and asked if there were any particular expungement challenges that I could potentially address through legislation. The attorneys shared with me that occasionally a client will show up to an expungement fair in Prince George's County with qualified expungible offenses, but his or her record reflects a case terminated with no finding or a no finding disposition, neither of which is in statute. So in these cases, because Maryland's current expungement law outlines specific criteria for removing court records from public access, the attorneys are unable to expunge the client's charges. This bill was voted out of the House last year, didn't move in the Senate due to some scope concerns from the Judiciary. And we worked over the interim. Our judges have examined the issue, and the bill before you is our final product. And then one last quick comment. The public defender is now in favorable, not favorable with amendments. Our state's attorneys association recommendation, it appears to kind of take us back to where we were with the first bill last year. And the Attorney General, there seems to be an interpretation issue with the unit rule, which kind of goes back to a previous hearing that says, these are very complex issues when you're dealing with expungement. So I believe we just need to take some time with the state's attorney to work through those. So with that, I urge a favorable report on House Bill 187. Thank you.
Thank you. Whoever's ready to go next, please.
Good afternoon to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid. I've supervised our expungement practice at Legal Aid for many years. House Bill 187 would allow expungement of no finding and case terminated without finding dispositions. These dispositions function as convictions,
but because they're not typically used in Maryland, they were never incorporated into the expungement statute. Thousands of people whose cases were adjudicated in Prince George's County are faced with a bizarre roadblock to expungement as a result. For decades, these individuals were asked to plead no contest in criminal proceedings. Usually in Maryland, such a plea would result in a guilty conviction. But in these cases, a no finding or a case terminated without finding disposition was entered instead. As I said, this practice went on for decades, likely in an attempt to give folks some relief from being associated with a guilty disposition. However, since that time, as you well know, Maryland has expanded its expungement statute to include convictions, and the tangible impact of expungement greatly surpasses any positive gain from receiving this obscure disposition. And so these individuals who, in effect, received a guilty disposition and served sentences and are otherwise eligible for expungement have been left behind without access to it. It's pretty clear this is unfair. People should not be penalized because of a rogue legal practice, no matter how well-meaning it was. House Bill 187 does not expand the world of charges eligible for expungement. It simply allows cases with these specialized dispositions to be expunged, using the same standards as convictions. Please report favorably on House Bill 187 so all Marylanders have equal access to expungement and economic stability. Thank you.
Good afternoon, Chair Bartlett, Vice Chair Davis, members of the Judiciary Committee. My name is Melissa Rothstein. I am an expungement attorney for Out for Justice, and I urge you to issue a favorable report on House Bill 187. And thank you to Delegate Taylor for bringing this important bill, particularly for the residents of Prince George's County, who are disproportionately harmed by the inability to get a no-finding disposition expunged. As Ms. McDermott laid out and is detailed in the written testimony, this bill is a technical fix to provide the same expungement opportunity to a no-finding disposition as is available to findings of guilt for the same charges. I will not reiterate those points, but would like to add some data and context for why this is so needed. Last year, I worked for the Public Defender's Office, and I was providing expungements for several years there. And we calculated approximately 15,000 cases, predominantly in Prince George's County, from the early 1990s through 2019 that would be impacted by this bill. Those cases, as Ms. McDermott had McDermott had suggested, were ones that were certainly not intended to have a worse collateral consequence than conviction, and really were intended to minimize the consequences of conviction. Among the examples that I was provided for why such a disposition would be entered would be for where factual findings may have immigration consequences, where somebody was eager to resolve a case before their lawyer was able to get any discovery, or for when somebody who had been on probation or parole, particularly in a drug-related case, and was successful in recovery and wanting to be able to have a resolution and move on from there. This was the no finding disposition was specifically intended to further that mitigating circumstance and reduce the consequences of the plea. As has been mentioned before, this is not intended to expand the eligibility to anybody who wouldn't otherwise be eligible with a conviction. So for these reasons, I urge the committee to issue a favorable report.
Christopher Dews representing Life After Release, which is a nonprofit reentry program in in Prince George's County, in which the vast majority of individuals would be impacted by the work of Delegate Taylor here with this piece of legislation. Simply put, we did discover, as we looked into it specifically from Life After Release's perspective, that we did have a lot of individuals who have a no-finding disposition. It was very confusing when we tried to get their records expunged, and so as we hold multiple expungement clinics all throughout Prince George's County, so for that, we just simply urge a favorable report, and we thank Delegate Taylor for taking this on. Thank you.
Thank you. Members, do we have any questions? Seeing none. That concludes this panel. I'm going to call up favorable with amendment, Carrie Borzilleri.
Oh, thank you.
Good afternoon. My name is Carrie Borzolari, and I'm here on behalf of the Maryland States Attorneys Association. The Maryland States Attorneys Association supports House Bill 187 with amendment as provided in our written testimony. The purpose of our oral testimony is to make sure our position is clear and consistent. The cross-filed bill, Senate Bill 320, came into the Senate on February 17, 2026. As to the Senate Bill 310, the MGA system did not permit a sign-up of favorable with amendment. We are signed up as opposed. However, we made our position clear on the record that we are in support with amendment to ensure the language of the statute is clear. We have no further testimony beyond that clarification and would submit on our writing in asking for a favorable report. Thank you.
Members, do we have any questions? Seeing none, thank you.
Thank you.
That concludes our testimony for House Bill 187 and the bill hearing. Oh, no, I'm sorry. For our unfavorable testimony, we have Laura Wilt, please.
Great. Good afternoon again. Laura Wilt for the record with Maryland Crime Victims Resource Center. I am asking for an unfavorable report on House Bill 187. The idea of with amendments could be or favorable with amendments could be appropriate to my testimony. As I detail in the written testimony I gave, I reviewed this as someone who has worked in, I think it's like done work in 5 different jurisdictions in this state so far. And when I read the language here, without having, hey, this is a problem in a particular county, I read the language and said, well, someone with a case that is not disposed of by an unequivocal conviction. I thought, what in the world? With 29 years, what does that even mean? I didn't know what that meant to not have a finding. So it is unusual that a particular judge would have that language, but what I'm afraid of is that that language does not include legal terms commonly used by lawyers engaged in criminal practice and would lead to a lot of confusion. My first jump is that in a case that's put on the stat docket, for example, or a case where somebody's given a probation before judgment, neither of those has an unequivocal conviction, right? So if you read this without further definition, why wouldn't that include a person given probation before judgment? Why wouldn't that mean someone whose case was put on the stat docket? And if something's put on the stat docket, it's meaningful. It means you're still on the stat docket for a couple years, you maintain your, you do what you're supposed to do, and then it can be expunged. This doesn't have, what I read, any time frame. So hypothetically, somebody goes in and says there's no finding of guilt, it's a probation for judgment, I can have it expunged. So it is the confusion of the terms that brings our opposition. Thank you for listening.
Thank you. Members, do we have any questions? I have a question. I don't quite understand. I understand that you were saying in your testimony, I believe it was your testimony. Perhaps it wasn't. I guess my question is, you were saying that you didn't want it to be considered like, just in your oral testimony, treated as a probation before judgment?
I think
in that regard, right?
If I misspoke, what I'm saying is if I read those words, not disposed of by an unequivocal conviction, then that's a probation for judgment. They don't have a conviction. So I think probation before judgment would be captured in this right to the expungement. Okay. Or a case that's put on the stat docket, there's no conviction there.
Oh, I see your language on what you're suggesting in your testimony.
Just when I'm looking at those words as a lawyer in practice, I think it could apply to a lot of scenarios that are beyond what the intent was.
Okay, thank you. I see. Delegate McComas?
Just a real quick question. Should it, where you have, if the case is not disposed of by an unequivocal conviction, should you also put in stat or probation before judgment, because that's what's really used by most of the bar, except for Prince George's County, where there was no finding. In other words, use what is kind of common use in the court.
I agree with that conclusion, that we
So it
should
should
use
be-
the terms commonly used. But I know that what I'm hearing is that Prince George's County was using different terms.
Right,
so-
but you could still put that in there too, and Prince George's
You
County if you
could,
want.
yes. Yes.
Or not, but I just think it would be good, because I think that I could see in my district where that they'd say, what's that mean exactly? As
Yes.
it is.
Yes.
But a STET and a PBJ, they'd
Yes,
understand.
and I think there are already specific rules about when those can be expunged, and we just don't want to mix those up, confuse the two.
Right, but I'm not looking at the whole statute, so.
Yeah.
Delegate Taylor?
Thank you, Madam Chair, and thank you, Laura, for bringing
Yes.
up these points.
Yes.
I'm just wondering if we're making it a little more complex than it has to be. When I was at the expungement fair, the attorney showed me the case file for the particular client, so to speak. And in the disposition column, it said no finding. They showed me an example that said no finding as a disposition. Otherwise, that finding would have been guilty normally, right, of some charge. Or in some cases, it said terminated without finding in the disposition column. That's all we're talking about. We're saying if somebody comes in and the pro bono attorney that you're working with pulls up your file, and normally what they'd see is, oh yeah, you have an expungible offense, but doggone it, under disposition, it says no finding. I can't do anything for you. So do you understand maybe better how this works? I don't know that the words unequivocal conviction, which, by the way, passed the litmus test of Judge Morrissey.
Yeah, he got it.
So I just,
And the boxes checked, if I could inquire, was that on the new, I'll call it the MDEX system now that it's electronic, or were these older records?
Well, that I can't answer.
Okay.
All I know, it was on a computer.
The other, and I knew that the State's Attorney's Office Association had suggested language that they felt would protect the records in this scenario, and I was not exposed to those in advance. So my testimony is specifically just on this language without evaluating what has been suggested as an alternative.
Thank you for being here.
All right, thank you.
And that concludes the testimony on HB 187. We're going to call HB 362, Delegate Grammer's bill. And I understand that it's just you and Stephen McDonald. Is Mr. McDonald virtual? Okay, you may proceed.
Okay. Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Janet Price, Chief of Staff to Delegate Robin Grammer. I am presenting House Bill 362 on behalf of Delegate Grammer as he is out sick today. HB 362 establishes that a person who has been granted an expungement shall be determined for all purposes not to have been arrested for, cited for, charged with, or convicted of the underlying offense. Maryland does not have a federally recognized expungement statute, and the federal government does not recognize expungements in our state to be real expungements. Right now, under Maryland law, a court can grant expungement, which removes or hides criminal or court records from public inspection, but it's unclear how completely that record is considered erased in real life or under the law. That ambiguity can lead to people still being required to disclose the old arrest, charge, or conviction on job, housing, licensing, or other applications, even after the court has ordered expungement. HB 362 attempts to remedy this problem by establishing that a person who has been granted an expungement shall be determined for all purposes not to have been arrested for, cited for, charged with, or convicted of underlying offenses. An expungement process should truly provide a fresh start, since many Marylanders continue to encounter barriers in employment, housing, and licensing even after their records are expunged. Thank you for the opportunity to present HB 362. I would be happy to take questions, and I ask for a favorable report.
All right, thank you. The next favorable witness is Stephen McDonald. Mr. McDonald, you may proceed.
All right. Thank you, Chair. As a member of the committee, my name's Stephen McDonald. I'm a resident of District 20 in Charles County and a member for Out for Justice. That this testimony is submitted in support of House Bill 362 with amendments to add my charge under Section 5701D4. Maryland's current expungement laws make it difficult for people who have completed their sentence to move forward, creating barriers long after the system involvement should have ended. My record is not eligible for expungement not because of public safety concerns or ongoing involvement with the criminal justice system, but because of technical statutory inconsistencies. Criminal law section 5601 and 8610 include a misdemeanor for counterfeiting or altering a prescription and is eligible for expungement, while section 5701D4, which criminalizes the same conduct, is not. These charges are functionally identical yet treated differently under the statute because expungement eligibility has been added piece by piece without aligning laws that cover the same behavior. People like me are denied relief based solely on how a charge is labeled rather than the substance or severity of the conduct. I've been to court 3 times, and the judges and attorneys have agreed that there needs to be a legislative fix for my charge because there's legislative intent there. My only charge is holding me back from advances in my career, promotions, and getting clearances for my government jobs, and I'm a sole provider for my family. I urge a favorable report. Thank you.
Thank you, sir. Colleagues, questions for this panel? Seeing none, that concludes the favorable testimony for this bill. We're going to hear now from the unfavorable panel. And I am going to call Carrie Borzilleri. How's that?
Good afternoon once again. My name is Carrie Borzilleri, and I'm here on behalf of the Maryland States Attorneys Association. The Maryland States Attorneys Association is opposed to House Bill 362 as legislation which is unrealistic, contrary to the purpose and direction of the expungement statutes, and would direct that an untruth be statutorily ordered. The expungement statutes in the criminal procedure article and as set forth by the General Assembly are designed to prevent public access to records of arrests, charges, and dispositions of cases when an individual is deserving of such protection. When expungement is directed, the agency with such information must either physically obliterate the record or remove the record to a separate secure area to which persons who do not have a legitimate reason for access are denied access. Expunge is defined as removing information from public inspection. The law permits the opening or access to records if a party follows the procedure set out in Criminal Procedure Section 10-108 and a judge determines that there is good cause to do so. There are many circumstances where such action is appropriate. For example, if an individual has been charged with a crime and the case was dismissed or even resulted in a conviction which was expunged and then someone else was charged with the same crime, a prosecutor would be ethically obligated to disclose the information to the next charged person as potentially exculpatory evidence. This legislation would require the prosecutor to violate their ethical obligation and effectively lie. This bill would require and very generically directs that with an expungement, the individual was for all purposes never arrested or charged with an offense. This requires that everyone endorse an untruth. There is a big difference between not allowing any access to a record and denying that the act ever happened. We ask for an unfavorable report with regard to House Bill 362. Thank you.
Thank you. Colleagues, any questions for this witness? Seeing none, that concludes the unfavorable testimony on this bill, and it concludes the hearing on this bill, HB 362. We're going to call HB 397, Delegate Grammer's bill also.
Hello again, and thank you, Madam Chair, Madam Vice Chair, and members of the committee. For the record, again, my name is Janet Price, Chief of Staff to Delegate Robin Grammer, and again, I will be presenting House Bill 397 on behalf of Delegate Grammer, who is out sick today. HB 397 adds failure to obey a court order to report to confinement to the list of crimes available for expungement. I am joined today by Mr. Wes McNeil, who is a resident of District 6. Mr. McNeil went to purchase a firearm and had several charges expunged from his record in order to do so. One charge that cannot be removed was failure to obey a court order to report to confinement, as it is not on the list of charges available for expungement. In his youth, Mr. McNeil reported a few minutes late to a court date. Although he was only a few minutes late, this resulted in a criminal charge, which continues to be on his record. As you know, recidivism declines radically with age. The purpose of expungement is to give those who have not offended again an opportunity to live a normal life. This year, we have made a change to the bill. This bill would require this change would require a waiting rule of 15 years before a person could, hypothetically, have this charge expunged. Delegate Grammer knows Mr. McNeil personally as a man of trustworthiness and character and considers him to be a person for which the expungement process was designed for. Thank you for the opportunity to present HB 397. I would be happy to take questions and ask for a favorable report.
Thank you. Is Wesley McNeil virtual? He hasn't been there? He was initially signed up to be in person.
Yes, ma'am.
And it doesn't appear as though he's here virtually.
Okay.
So we're going to conclude the hearing on this bill, HB 397. There's no unfavorable, so thank you for that one.
Yes, thank you very much.
Any questions? I'm sorry.
Oh,
No questions. Thank you.
okay, thank you.
All right, we're going to call HB 697, Delegate Grammer's bill, also. And we have, wait, hold on, 1 second. That is not it. Do you have witnesses?
I believe there's one, should be Linda Duncan.
What's that person's name?
Linda Duncan.
Okay, I'm sorry, I've got it now. All right, you may proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. For the record, my name is Stephanie Buttons, legislative intern for Delegate Robin Grammer. Delegate Grammer is out sick today, so I'll be introducing House Bill 697. House Bill 697 removes the use of diminution credits for first-degree murder. We have all heard Linda Duncan's story, whose mother was murdered in a horrific act of violence. Since the sentencing of her mother's killer, Ms. Duncan has been fighting to remove the use of diminution credits for first-degree murder in the state of Maryland. Victims of murder don't get a second chance. They never get another chance to see their loved ones, and most importantly, they don't have a second chance to say goodbye. If Ms. Duncan's mother does not get a second chance at life, why should her killer? In 2024, the Pavel-Lapere Act removed diminution credits except only for first-degree rape. Crimes surrounding sexual abuse and rape are horrific crimes, which the state of Maryland has already established. Perpetrators of first-degree rape do not deserve time off for good behavior. However, our current ruling on this is contradictory. It doesn't make any sense to remove diminution credits for rape and keep them for murder, especially when it's objectively worse to have your life taken. For the only crime that steals another person's life in future, to give the perpetrator time off for good behavior is an injustice. House Bill 697 fixes this injustice and ensures no time off for good behavior for murderers. Thank you for the opportunity to present House Bill 697, and I'd be happy to take questions and ask for a favorable report. I believe she was supposed to be here in person.
Seeing no questions, that concludes the favorable panel on this bill 697. We're going to call the unfavorable panel now. That includes John Sexton and Edward Kent. I should be on there for info, actually. She's on there for info.
Yeah, I should be on there for info as well.
Yes. And Pat.
Yes.
Yes.
Should I
testify?
Yes. Should I be with them?
Yeah, come and join us.
All right, I'll come join you.
So, good afternoon. This is Edward Kenny from the Office of the Public Defender. As with the previous diminution bill, we are again asking this committee to issue an unfavorable report. And really, I don't have much to add from my prior testimony, so I'll just leave it at that. For the reasons that I said, I guess half an hour ago, we remain opposed to this bill as well.
Would you like to go next, sir?
Ann Pack, Director of Advocacy for Prepare, and kind of picking up where I left off, I am favorable to the idea of working through a solution on the issue of diminution credits as they relate to life sentences. I think we need to loop in commitment at DPSCS. I think we need to loop in the Maryland Parole Commission, the Office of the Public Defender, the State's Attorney's Office, parole advocates, organizations like PRISM, victim advocates, victim services, and impacted individuals who all have expertise in this area because of the impact that these different laws and cases they influence one another in unexpected ways. So just to highlight a single example, Hansen v. Hughes is a 1982 case. Because of Hansen v. Hughes, life suspended cases are the only cases where the parole eligibility is based on the suspended portion of the sentence rather than the executed portion of the sentence. So if I had 70 years all suspended but 20, I go up for parole on my 20-year sentence. But if I have life all suspended but 20, I go up for parole as if I had the full life sentence. And that has created an unusual, and I'm not, because I don't have a board, not going to go through the math here, but that creates a mathematical error where people that have a longer suspended sentence actually have a shorter parole eligibility, which obviously is not the legislative intent. It's not well understood by judges, and it's not well understood by the general public. But this has persisted, and then other cases have piled up on that, things like Greco and Cathcart, which you may have heard talked about here before, which create a very complicated process that I have a chart that I have to use when I get somebody. I have to go through a flow chart to figure out how their sentence should be calculated. Do they need to go back to court? So I urge you to invest in fully investigating this issue and coming through a workable solution that takes everyone into account. Thank you.
Good afternoon, committee, once again, Chair, Madam Chair. I just want to start with, this state does have life without parole, which it uses quite frequently in these type of cases. And if a judge determines that he or she is not going to impose a life without parole sentence, but instead is going to give them a parolable life sentence, then we should try to integrate those people into trying to better themselves and rehabilitating themselves into becoming an asset to society. And by doing these type of things, that takes it off the mark. In 1971 was the first time that lifers began to get diminution credits. This body passed a law that said that they could earn them. It integrated them into the bigger system through education, through labor, through work programs and whatnot. It also did their civic duty, so they can have programs that are designed to build them up civically. When you take away the diminution credits, what you're saying is, well, we're going to put you over here in a box, and we don't want to integrate you into the bigger system. I would refrain from doing that. Thank you.
Thank you, Mr. Sexton. Colleagues, any questions for these witnesses? All right, seeing none, that concludes the testimony on this bill, and that concludes HB 697. Thank you for being here. All right, we are going to Delegate Emery's bill. Okay, we'll do Delegate Ruff. HB 169. Do you have your panel?
I do have a panel, if my panelists could come on up. This is the good cause expungement bill.
Hold on.
Let me Mr. Deuce sit here.
That'll be good.
This is expungement day. That's what I've heard.
All right, you may proceed, sir.
Thank you, Madam Chair. Once again, to the hardest working committee in the House of Delegates, I very much appreciate your attention, and I know you all have had a long day already and still have some to go. Some to go, but that's all right. That's why you guys have broad shoulders. So I'm Delegate Malcolm Ruff, District 41 in Baltimore City, and I'm here to present for the third time House Bill 169, that is the good cause expungement bill. A criminal record creates a barrier to housing, employment, financial aid, public assistance, occupational licenses, and much more for over 1.5 million Marylanders with a criminal record. Unfortunately, Maryland has a variety of laws that in combination prevent Marylanders from accessing the expungement services needed to reintegrate into society. You guys have heard many of them, the unit rule, and of course the subsequent conviction statute. But here, we're here to talk about the 93% of crimes that are not eligible for expungement, period, leaving individuals released from incarceration with no recourse for decades and no motivation to be better. For instance, you can be convicted of driving while impaired, which means you had a blood alcohol content of less than 0.08 but more than 0.06, which I'm sure many of us have been guilty of, at least not while driving. And you can never get that expunged from your record. But if you commit real estate discrimination, if you commit fraud and sell real estate without a license, you can get your conviction expunged. Make that make sense. Good cause expungements seek to address the roadblocks by allowing a court to review a conviction and determine whether the charge should remain ineligible or not. I want to get some things straight about the opposition's testimony on this bill. There are a couple of things that this bill does not do. It does not make serious violent felonies eligible for expungement. What it does is allows an individual to make a compelling argument to a judge who we ostensibly have trusted to have sentenced that person in the first place, to determine whether or not they are in a place in their life and they can demonstrate in a court hearing that they deserve the right to have a clean slate because they have done the work to not be a public safety risk. And of course, all of us in this room are concerned about public safety. All of us, including me. Including all of the people that are testifying on behalf of and against this bill. It does not require the courts to grant an expungement. This is about fairness. This is about the opportunity for folks to be motivated to make themselves better and to live a better life. There are several factors that we've heard over the years that need to be imputed on this bill, and we have done that. The factors of determining the nature of the crime, the rehabilitation of the person, the risk to public safety, the history and character of the person, whether they have been denied rights of employment, education, housing, public assistance, licensing, opportunities, economic stability. Last thing I will say, if we can trust judges to sentence folks and to take away their freedom for decades, we should certainly be able to trust them to have the discretion to make a balancing analysis of whether or not someone should be able to be fully reinstated into our society. And with that, I'll allow the rest of the panel to extrapolate on the bill. But I ask for your favorable report on this good cause expungement, HB 169. Thank you so much.
Thank you. I've got just a little bit of corrections here. Jack Budlow, am I in the right bill?
Jack Budlow is here.
Megan McDermott, Adrian Muldrow.
So actually, I have a panel here.
Okay.
Can I have the panel?
I'm sorry, I'll call them next.
No worries. If I can have the panel testify, and then Jack, you can be on the panel. Come on up.
Okay, but they're all favorable, right?
Jack is actually a student at the University of Maryland Law School, and so I would encourage you all to read his written testimony. It was very, very good.
Is there any particular order you want them to go into?
We'll start with Mr. Deuce.
You got it. So Christopher Dews, representing both Out for Justice and Life After Release. Just wanted to level set, as the good delegate also did. I want to start with, as an example of who we're specifically trying to target with a bill like good cause expungements. So with Out for Justice, we have an individual, I'm going to call him Mr. Lancaster, who had, at 21 years of age, had a 2-year-old daughter, was playing in the park with his daughter, had to use the restroom, went inside of a store, I think it was a McDonald's, left his daughter in the car. When he went inside the store, used the restroom, came back outside, and there was a law enforcement officer waiting for him. He was very confused, but to skip to the point, he ended up with a child confinement charge at the age of 21 years old. He has struggled ever since then to secure any type of employment, any type of housing. He's had to move back in with family and parents because no matter what he does, when people look up his record, they see child confinement. For the record, he got 1 year of unsupervised probation. The judge said, well, we know you didn't really do anything wrong. You just need to use the restroom, but you know, it is a crime. It is what it is. So when we're talking about a piece of legislation like this, right, we understand what the state's attorney's office and what other opposition testimony is going to say. But to be clear, this is targeted to be used in rare circumstances for people with very specific situations that if you sat down in front of a judge, they would be able to say, yeah, okay, you know, you did your 5 years on this misdemeanor, you should be able to get that expunged. Now, I also want to highlight, as the delegate said, I just want to make sure this is clear, this does not make any charge just eligible for expungement. You'll hear multiple testimonies, as I've read, that child pornography will just be eligible. Multiple murders will be eligible. This is saying that the judge, a person can go in front of a judge and make that case. They also cannot appeal, and they have to wait once every 3 years before they can get this opportunity again. The whole point of this is to give an individual an opportunity to make their case in front of a judge to explain their circumstances, because everybody's circumstances are actually different when it comes to why certain charges are committed. With that, I simply urge favorable report, and I thank you, Delegate Ruff, for sponsoring.
Thank you, Madam Chair, Vice Chair, members of the committee. My name is Saquon Merritt. I'm a Maryland small business owner and founder of Lightning Electric. I'm also a justice-impacted individual. Today, I want to speak to you not just from a personal place, but from a business and economic standpoint. Maryland says it wants small businesses to grow, wants to give people other opportunities. It also says it wants minority businesses to scale. It wants workforce development and safer communities. But when people like me cannot have an opportunity to have my past conviction expunged, it also blocks me from helping the people in the individual communities, the YNs, some of the ones that we talk about at those gas stations. It prevents me to scale. It prevents me to help them. Why? Because when I can't get my past nonviolent drug conviction expunged, I don't have access to capital. I don't have access to bonding. I don't have access to scale to give these brothers the opportunity and the space to do what we want them to do, and that's thrive and make sure our communities are safer. It's funny, right? I speak on this from a human aspect. A lot of us sometimes I don't think we decipher a person formerly incarcerated in who they are, right? We're all just humans. We make mistakes. I've made mistakes, and I make mistakes I'm not proud about. Even when we had the latest Ms. Laura will even come up here, we would like to encourage and we would like to speak with them about reasons why they wouldn't allow me or others to have our convictions expunged. Let's all sit at the table so we could be on the same side and talk as humans, right, about us changing and having the opportunity to change. I say that to say, again, I know my time is going out. I don't want to belabor y'all for too long. I would urge y'all to encourage to favorable saying on this bill. Because, again, I just think second chances, opportunity should be available for all of us just as humans to thrive and to grow and to be better and give us the opportunity to make things right. Thank you.
Good afternoon to the committee. I'm Megan McDermott. I'm an advocacy director at Maryland Legal Aid. Expungement is a strict statutory process. There's a list of offenses in the code, and if the offense is not on that list, it cannot be expunged. I can tell you I've been in court countless times when a judge has said to one of my clients from the bench, I wish I could expunge your case, but the law will not allow it. This usually occurs in one of two scenarios. The first is the person who's a true diamond in the rough. This diamond screwed up as a kid, but has done everything right for the last 20 years. He's gotten a job, he's raised a family, he's volunteered, gone to school, generally in his own unique way, been an active contributory member of his community, and he has not reoffended. But he can't get his singular offense from decades ago expunged because it's not on the list. The second situation is the client that has a case that is very similar to a charge on the list, but it's not exactly the same. The client who can't get their trespass on private property expunged because the statute only allows for expungement of trespassing on posted property, or the client who can't get their open container citation expunged because the eligible offense is drinking in public. Or there's one of my clients who was charged with street walking in the 1970s and can't get an expungement even though prostitution is eligible for expungement. The statutory framework of the current expungement law provides no flexibility in these matters, even for our trusted judiciary. These are synonymous offenses, and my clients really deserved a second chance. House Bill 169 creates judicial discretion so judges can consider if the most deserving Marylanders are eligible for expungement. We urge a favorable report. Thank you.
Good afternoon, Vice Chair and members of the committee. As Delegate Ruff introduced me, my name is Jack Budlow. I'm a student attorney with the Racial Justice and the Law Clinic at the University of Maryland School of Law. HB 169 would benefit those individuals who could show court two things. First, that a particular criminal conviction has caused them particular harm over the course of many years. They would have to show that this conviction continues to stand in the way of housing, employment, or some other basic life necessity. They desperately need to have the conviction expunged. Second, they would have to show that they have earned the opportunity to have the charge expunged. They have rehabilitated and they're an asset to their community. The clinic represents a man who is 68 years old. He was wrongfully convicted of a crime over 50 years ago. He was exonerated of the crime and pardoned. Despite the pardon, he has been unable to move past the injustice that led to his conviction and incarceration. The main reason for that is that he was also convicted of a charge that flowed from the wrongful conviction. The conviction remains on his record today, and he continues to live with the countless collateral consequences stemming from it, including his struggles to obtain gainful employment and stable housing. These struggles have been detrimental to himself and his family. Our client's conviction cannot be expunged under current Maryland law. HB 169, if enacted, would help our client because he would be eligible to file a good cause expungement petition. The petition would allow him to detail his arduous journey and set forth the myriad reasons why he needs and deserves to have this conviction expunged from his record. HB 169 seeks to bring the possibility of much needed and deserved relief to individuals who have rehabilitated and suffer from the burdens of the conviction they would be seeking to expunge for good cause. The clinic respectfully urges the committee to issue a favorable report.
Thank you. Colleagues, questions for this panel? Yes, Delegate Arakan.
Thank you, Madam Chair. Thank you for Mr. Dews for sharing the story of the guy that was arrested for child confinement at 21. Okay, first of all, that's a whole, you're too young, but we were left in the car as children. I mean, let's just say.
Very much so, yes.
You know what I mean? Yeah, let's just call a spade a spade. What in the world is going on when you can't use I mean, really. So first, let's get that off, because I'm just so exhausted by like the over-policing of parenting in this state. It is like really bonkers town. I'm wondering in my head, and I'm hoping that you can answer my question, if the governor were to pardon him, what kind of avenues could that potentially open up? Could a non-expungible offense then become expungible if he was pardoned?
Actually, you want to take that one maybe first?
Yeah, so once something is pardoned, you still have to go through the expungement process.
Right.
So the pardon itself allows it to be expunged.
Okay,
Because
so
it
there
no
isn't-
longer matters what the underlying offense is.
Okay.
However, it's very difficult to get a pardon. It's a long process.
Well, bring me a letter so I can sign my name on his request, okay?
Or you can just move favorably on
I
this.
could. You know, I gotta tell you, Mr. Deuce has watched me over the years. I'm like very hard against expungements typically, but some of the stuff just today alone has made me go, what? What? It's so bizarre.
I also wanted to quickly add, the reason, because other people have been asking about pardons and stuff like that, it is a very, as Megan said, it's a very difficult process. It also is a bit of a political process, because then, things can be used against any governor depending on what they decide just to pardon, right? And so, for example, when I talked to Mr. Lancaster, now just imagine if I came here with a bill that was specifically for expunging child, like you could see what the reactions would be, but his specific case is so unique that that's the reason why we think good cause would be a great
And
opportunity.
some of these cases, it seems like they were mischarged too. I mean,
Is-
I have seen it happen even in my county with somebody being mischarged with something so outrageous that just not even connected to what's going on. So a child confinement seems like a very extreme. And also, could you just tell me, don't have to, but what happened? He didn't lose custody of his child, did he?
No, he didn't lose custody of his
Okay.
child. He still has his daughter. Again, the judge realized they had to book him with something, and then he, again, 1 year unsupervised probation. They said go forth and be free, but they had to hit him with something, and so to this day he still can't get it, and it probably will never be able to get that off.
Well, if you do seek a pardon, let us know. You'll probably get a lot of support.
Yes, ma'am. Thank you so much for the question.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you very much for bringing the bill, and thank you for everybody for your testimony. The Judiciary chimed in. Did you see the Judiciary's with some 4 recommendations on amendments? You okay with those?
Absolutely. So I would have gotten to that, but, I didn't get to it. So we're definitely cool with the friendly amendments, conviction to change from where the proceeding began to conviction was entered, changing the bill so that only eligible petitioners get a hearing, making sure that there's a provision for leave to refile if you file too early, and then the 7-year waiting period for situations where there are misdemeanors and felonies that the longer waiting period would apply. We absolutely agree with that. But I think it also shows that there is an appetite from the judiciary, even though it was submitted just as information only, which I understand. They didn't say, well, this doesn't make sense. They didn't say this is impracticable. They said this is the way to make this operational, and gave us their expertise. So I've met with the judiciary about these amendments. I let them know that I was perfectly willing to impute them into the bill. So I think that the committee should absolutely take that.
Just one quick question,
to the
reading
bank.
between the lines. Overwhelming the courts with hearings could limit or reduce people's access to justice because we just don't have enough courtrooms and hearing space. If you have every single person who has a conviction applying for, just constantly applying or reapplying every 3, I mean, that you're talking about thousands and thousands of hearings that are going to be permitted overnight. And
Can I respond to that? So
Yes,
I
please.
think initially there will be a lot because there will be a backlog of people that have already waited 7 years and they'll immediately apply. But I think what it will encourage courts to do in every jurisdiction will be what's done in some of the larger jurisdictions, which is dedicate a judge to an expungement docket. There is no provision on how soon your hearing has to happen. So I'm sure that the administrative judges of each court can figure out how to create a system that does not overwhelm overwhelm or overburden each individual bench.
Thank you.
Can I follow up to that briefly too, just to say that these folks are already applying for expungements because people are confused about if their charges are eligible. They already apply and they go to a hearing. So if they're not eligible, the state objects, they go to a hearing. So hearings for these folks who are looking for expungements are already happening. I don't think there would actually be a huge change in the number of hearings that are held.
Thank you. Delegate Phillips.
Yes. Delegate, thank you for bringing the bill. Where else are we doing this? And, you know, many people say the sky is falling. Has the sky fallen? Where else has it happened? And has there been any real significant concern based upon the fact that it's happened somewhere else?
Now, I don't know if there is a good cause exception anywhere but Maryland. And actually, our good cause exception that already applies.
But there are other states that do it this way already.
California, for sure. There has not been an implosion of the courts. They have a much more liberal expungement scheme than what we have right now. And there has not been, like you said, the sky falling. But I think the more important point is, as the racial justice impact, a racial equity impact note dropped while this whole proceeding was happening at about 1:45 today, it specifically says passing this bill will impact Black people to a greater extent due to our overrepresentation in our system, right? So that the real impact is going to be leveling the playing field on the fact that 71% of people who have been incarcerated in this state are Black people when we only represent 30% of the entire population. That's the relief that's needed, and that's why this bill is so, one of the main reasons why this bill is so important.
But I want to reiterate, where they're using or engaging the courts to ultimately review and make the decision, there's been no indication that things have gone awry.
Absolutely not. Absolutely not. And I appreciate the point. Thank you, Delegate.
Thank you. Delegate Stinnett?
Thank you, Madam Chair. Thank you, Delegate. This is a great bill, so hopefully we'll be able to push it through. But I want to ask the questions to Mr. Merritt. You know, tell us a little bit more as far as on what the challenges, especially as a business owner here statewide. You know, our focus is supposed to be really, you know, focused on MBE, minority businesses. But just talk about as far as a little bit more in depth as far as how much of a challenge it's been to you as far as a business owner and this hanging over your head.
Thank you, Delegate Stinnett, for asking me that. It's been extremely challenging. I was released in 2017. I have, for the last 8 years, I've been able to employ at least about 20 to 30 guys, right? I was able to, some way, somehow, without any real financing, but from only place I've ever got financing from was Baltimore Community Lending. No regular institution, the bank institutions has gave me any financing at all. And we're talking about Baltimore Community Lending, an earmark of only around $200,000. I have had a revenue of over $4.3 million in the last 8 years that we don't have now. It went to a lot of our materials, it looked to a lot of my team members, but we are in a tight spot because we can't get access to other capital. We had one of the biggest projects of our career last year, $1.3 million project, and it cost us a little bit more. But in order for us to float payroll and even float that retainage that they keep, that 10% that they really don't tell us about, right, or that we don't know about, $130,000, it's 10%. That's my profit margin. I had to wait 4 to 5 months for that. I need a bridge loan. Couldn't get it. Denied 6, 7 times. SBA won't touch me at all. Why? Because of my past criminal conviction. I got guys that love me, love my story, love what I'm doing, rooting for me behind the scenes, saying they could come home, be a plumbing contract, be any of these other things. Now, we know there's a host of other things us as MBEs have to know in regards to administrative aspect. 75% of what I do is administrative. This is administrative. Getting out here, doing what I need to do, fighting a good fight, right? I just had to drop 3 guys off earlier today at a job with material and everything. I didn't have this on a few hours ago. but I still had to make it here. But again, with capital and with other finances, I can pay a project manager, I can pay a field supervisor, I can pay an estimator, I can pay these other things that these other companies, well-to-do, known, have in their administrative office. I just do not have it because we can't get capital because of my record. I can't help, I can't be the guy with the cape on my back that everybody's seeing. Is straight from Baltimore, Wrightstown and St. Ambrose. That's where I was at. You know, again, not proud of it, but I came from a really tough place. And guys look up to me when they see me, but I can't even thrive as much as I want to because of my criminal background stops me from access to capital and resources to really grow and thrive this company. And I have proven through my revenue that I'm prime. We can handle, I can wire this whole court building, I can wire this whole district, no problem at all. Read blueprints and drawings and everything. And I can teach other brothers to do the same thing. But if I do not get access to capital, I can't do that. And with me not being eligible, my judge, Sherry Bailey, I'm pretty sure probably would expunge my nonviolent drug offense. Can't do it.
Yeah. Thank you, Madam Chair.
Thank you. Any further questions for this panel? Okay, seeing none, I'm going to call the next panel.
Thank you, Madam Chair.
Okay, Adrian Muldrow, Jamie Grace Alexander, Amber Whalen, Marvin Carroll, and I think there's a seat for Sean Link. Okay, who do we have?
Adrian Muldrow.
Thank you.
Marvin won't be able to attend today.
Excuse me?
Marvin Carroll won't be able to attend today.
All right, and your name?
Jamie.
Okay, got it.
And Sean Link. Oh, sorry.
Marvin won't, so I can probably get Zachary Alberts?
Yep, perfect.
And Amber Whalen? Okay, who wants to go first?
I'll go first.
Okay.
Good afternoon, Chair and Vice Chair and members of the committee. My name is Adrian Muldrow. I'm here as an advocate, and I'm also a candidate for the Maryland House of Delegates in the 41st District. And I'm here in strong support of HB 069, Expungement of Good Cause. And I want to start with, honestly, I'm a just and impacted individual, even with a wrongful murder conviction that still haunts me to this day. I represented myself pro se, seeking expungement related to a wrongful conviction. I navigated complex procedural rules without counsel, faced formal opposition from the state, and even with the circumstances, I was denied, and the wrongful murder conviction label was used to shut the door. I have proof of that. I can share that with you guys. That experience taught me two things, right? First, pro se litigants face real barriers in court, right? Second, under current law, too many people are locked out of relief, as we've heard, entirely, even with what they've demonstrated in terms of rehabilitation and rebuilding their lives. Here's why HB 0169 is different and why it's the perfect bill for the moment, right? Right now, Maryland expungement is mostly governed by criminal procedure title number 10, subtitle expungement of convictions. It's limited to select offenses listed under subsection 10.110, with strict waiting periods and eligibility restrictions, in addition to putting the burden on the one seeking expungement. Why Maryland Second Chance Act offers shielding. It's narrower and distinct from expungement, although there's already a good cause provision. It's been, in my opinion, it's misinterpreted and narrowly used, and mainly to excuse timing in non-conviction cases. HB 0169 changes that by expanding judicial discretion. Under this bill, a person could petition to expunge a misdemeanor, felony, after a set waiting period, 5 years, 7 years, 5 years for a misdemeanor, 7 for a felony. But those factors would include rehabilitation, reintegration, and this bill complements other expungement bills that was presented today, which address eligibility across different charge types, and I ask you guys rule favorably in this bill.
Thank you, sir. Who's next?
Not all at once.
Jamie?
I can go next. Thank you, Vice Chair Davis and members of the committee. I want to take a chance to talk about a couple of things. You know, we support good cause expungement for all the reasons that are already laid out. It provides more folks with the ability to petition a judge to show why they deserve a second chance. It's not guaranteed. I can't say that enough. It's not guaranteed that any conviction will now be expunged. The second thing I want to talk about, as it's sort of unofficially expungement day, is this sort of like false dichotomy or false opposition that I feel like is often forced between individuals advocating for expungement and second chances and individuals that say they're on the side of public safeties and victims' rights. It's not that easy and it's not that clear for a variety of reasons. One, as you'll hear today and have heard today, victims often have criminal records, and individuals who have criminal records often become victims. These are not two separate groups of individuals all the time. The second piece is, I am a victim of crime. I'm up here advocating for expungement. I have family members who are victims of crime. I live in Baltimore City. My wife lives in Baltimore City. My family will soon live in Baltimore City. I want public safety. I want to be safe at home, right? There's a body of evidence that show that expungements are good for public safety. When people can access work, when they can pay for housing, education for their children, they are less likely to commit crimes. We are pro-public safety on the expungement side, and so like I'm saying, it's not an either or, it's an and. The final piece I would talk about is this idea of this individual out there who's gonna wait 10 years to get an expungement and then commit a crime again. This is a fictitious person. There's not a person that exists like that. People that recidivate within 2 to 3 years of being released from incarceration. Most expungement, you aren't eligible till 5 to 7 years afterwards, right? So no one's waiting around being good till they get their expungement, and the second they get it, it's like, now I can break into people's homes. That person does not exist. And that is not to make a mockery of real concerns around victims' rights and victims. Like I said, I have been one. It's to say that we care about public safety, and we are here advocating for public safety. Thank you.
Okay, thank you.
I can go next. Thank you. My name is Jamie Grace Alexander, and I'm a paralegal at Baltimore Action Legal Team. BALT is a legal services organization determined to deliver community-focused lawyering to over-criminalized Black Baltimore. Our direct service work includes warrant recall and expungement, working to emancipate people from the lifelong weight of the criminal justice system. Our people pursue expungement as a way to put their past behind them, to mark their progress away from their younger self who made the mistakes which today hold them back. The truth is, every person's life is impacted by their criminal record. In many cases, the way charges are written up make them ineligible for expungement. For example, we have a client who was charged with a 4th-degree sex offense instead of alleged prostitution because he is homosexual. Because of the way his charge was written, it has stayed on his record for decades, and if this bill were to be passed, he would have another avenue by which to re-examine that record. If this bill were to be passed, many of our ineligible clients could easily prove good cause to a judge. Many have tried and been denied because of the current state of the law. In our warrant recall work, we regularly help people prove good cause as an avenue for judges to re-examine active warrants and allow people to show up for their hearing. It is becoming increasingly impossible to find a job or a place to live while being honest about your criminal record. Our clients are mothers, providers, elders, and leaders. Let our people share that honesty with the court and prove they are upstanding citizens. Give people a chance to move on from their records and pass good cause expungement. Thank you.
Thank you. Any questions for this panel, colleagues?
Madam Chair.
Oh, I'm sorry. Your name? We have 2 others. Thank you.
Good afternoon. My name is Amber Whalen, and I'm a resident of District 6. I'm here to share my personal experience and ask for support for HB 169, good cause expungement. As you heard my testimony earlier, I will not repeat the entire story. However, for the record, I want to lay out the basic facts one more time. I have 1 conviction on my record for a threat to commit mass violence. This happened during a mental health crisis. I did not and have not ever hurt anyone. The conviction sounds scary, and when I have background checks for employment or housing, people get a completely different picture of me than who I actually am. I would like for you to support the bill so a panel or experts can decide whether there's convictions like mine that are currently not expungible that could be depending on the context. As a reminder, making something expungible does not guarantee expungement. It gives people a chance to make their case. You have heard my case today. If you think that if I gave you the evidence that proven my story, I should be able to get expungement, I would ask that you support this legislation. I urge a favorable report. Thank you.
Thank you. Mr. Link?
Thank you, Madam Vice Chair and members of the committee. My name is Sean Link, and from the Maryland Office of the Public Defender, we respectfully request that the committee issue a favorable report on this bill. Rehabilitation is a cornerstone of the criminal justice system, the belief that individuals can grow with the right resources. Expungement is rehabilitation in action, removing the stigma of a criminal contact off of someone's record after they've served their time, re-entered the community, and demonstrably turned things around. At its core, this bill allows judges to do what they do best, to use their discretion to consider an individual's specific circumstances and then grant expungement relief if they are persuaded that good cause exists. It's a backstop measure to ensure that no one is barred from relief because of an uncommon disposition or unintended technicality. As you've heard multiple times today, the existing list of expungible convictions has been assembled piecemeal over the decade. It's created a system that's confusing to attorneys as well as petitioners. Many low-level misdemeanors and traffic offenses remain ineligible solely because they have not been added to the list specifically, not due to their severity or any specifically expressed intent to exclude them from eligibility. While this existing system benefits many individuals, it's limited by that rigidity and that complexity. This bill would improve the system by taking the focus off of inflexible statutory designations and placing it instead on the individual, their growth, and their need for relief. It allows state judges to evaluate each person and their petition on their individual merits rather than as a data point on a confusing and limited list. In addition to improving lives by clearing barriers to jobs, to education, to housing, this new opportunity for expungement will also benefit the broader community. It will strengthen families, increase economic productivity, and boost equity by removing a source of assumptions tied to old convictions. It provides a goalpost to inspire those who are newly re-entering society and a well-deserved reward to those who have earned it. We ask for a favorable report.
Thank you. And now, are there any questions for this panel? All right, seeing none, we're going to call our next panel. Thank you.
Thank you. Thank you.
So I have a note on this file that Cassandra is signed up. Yep. Cassandra can come up front. And Trina Selden.
She's a me too.
Excuse me?
She's a me too.
Okay, she's virtual. All right, so we're gonna have Trina Selden virtual.
No, she's me too.
She's me too. I thought she said you too. Okay. Hold on, give me 1 second to get everyone together here. Is Guy Powell virtual? And how about Stephen McDonald?
It's going to be Mitchell, who is on that first page of witnesses.
Yes, Marvin Mitchell, got it. And Guy Powell, Stephen McDonald, and Michael Parsons, virtual?
No, Michael Parsons.
Okay, we'll start there. You may, Cassandra, what's your last name?
Thomas Burrell.
Thank you. You may proceed.
Okay, thank you, members of the council. I know I only have 2 minutes, so I will get I only have 2 minutes, I know, so I will get right to it. Members of the council, reckless endangerment was the charge that I was charged with. And for the past 19 years, these words have haunted my everyday being. At 19 years old, my life was taken away from me, and instead I was handed a scarlet letter A. I was charged and then later arrested back in 2008. With no prior record to speak of, I was sentenced to 4 years' time, 1 year to be served as an inmate doing time, and leaving my infant son of 8 months old who is disabled. I served my time and paid my debt forward to society. Upon my release, I achieved my high school diploma and immediately enrolled into college to become a registered nurse. 2 years into the program, the Board of Nursing pulled my application for my licensed practical nursing and told me that because of my criminal background, I could never be able to become a nurse or work with patients, which was my lifelong dream. I was labeled a liability. For years and years, I've been turned down time and time again. I've been shunned from anything in the medical field involving patients, denying me from any position that involved patient care. For one mistake 19 years ago, leaving me forever tarnished with this character flaw. My hope for this bill is that it will finally set me free from discrimination, free from labels, and finally recognized as a positive member of society for my achievements, and not undermined and disregarded because of a situation that happened when I was a mere teen. My hope for this bill is that for others like myself, we can have hope for the future, not just for their future, but for their families and their children alike. I thank you for your time, council people.
Thank you. Mr. Mitchell? Martin Mitchell? Nope. We don't have a Martin Mitchell?
He should be present in the room, I think.
Oh, Mr. Mitchell.
Well, I see Mr. Powell. Mr. Powell, would you like to proceed?
Yes. Can everyone hear me?
Yes.
Yes, great. Happy Tuesdays. Mr. Powell here to all the Judiciary and the Senate proceedings. My name is Mr. Guy Powell. I live in District 41 and support the good cause expungement. These are the reasons why. When I was 17 years old, spending time with my family in some rentals on Route 40, I was approached by a group of 12 young men from school who made me threats towards my family and me. I told them they needed to step back down and leave. The situation escalated and the gang attacked us. As they grappled with me, I grabbed the nearest item that I could defend myself, which happened to be a knife. I swung it to defend myself because I was scared and afraid of my life. I happened to wound my attacker hand and force him to leave. At that time, of course, law enforcement arrived and arrested me, all of us. As in Maryland, there's no stand your ground law. I was charged with attempted murder and maiming. At the trial, I explained the incident to the judge, who clearly understood my situation and the community hostilities. I was not given any jail time. I repeat, I was given no jail time and only received 5 years of probation and paid restitution to my attacker. The event occurred 35 years ago. Again, 17, I'm now 52 years old. And despite of serving no jail time, it remains on my record. Since then, I've been a father of 3 beautiful children, and I'm just want a better life for them so they won't get caught up in the system like I did, even though it was self-defense. I received 3 degrees, 1 master's degree in social work and from University of Maryland. And I'm currently in my practice, a mental health practice, and I specialize in individual, family, couple, and marriage counseling. It was my way just giving back to the community and doing the best that I can do to lessen the trauma that operates in our community. So I'm in favorable for the good cause, and I'm hoping for a favorable report. Thank you.
Thank you, sir.
Thank you.
Who do we have? Is this Michael Parsons? This is Mr. Mitchell. You can proceed.
Yes, thank you. My name is actually William Mitchell, not Mark. Thank you.
Okay.
Members of the committee, thank you for allowing me to speak. I just wanted to tell you an experience I recently had with the expungement. So back in 2000, from 2000 to 2005, I was addicted to drugs and was convicted of theft, misdemeanor theft, misdemeanor drug possession, and a burglary 3rd degree, which was a felony, but I was breaking into my own home, which is a long story. Later on, I was later convicted of attempted murder, which I served my time. I did 18 years, and it was found that my sentence the whole entire time I was incarcerated was illegal. Today, I sit before you as the Overdose Survivor Outreach Program peer for the University of Maryland. I assist and serve the Hartford, Cecil, and some of Baltimore County community. Any drug overdose that comes into the hospital for the Upper Chesapeake region is my patient. And today, I'm a certified peer recovery specialist. However, there is training that I wanted to take as a peer in Canada. I couldn't go because I'm a felon and I can't get it off my record. The change to the law in October for expungement, I was super excited because it granted me the opportunity to get null processes off, stet dockets that were sitting there, and I filed. Super excited. I started to get some of the null processes going, some of the stet dockets that was coming through, and I felt like I was going to be a citizen, because I don't know what that feels like. I've had a criminal record since I was 18. And then I got the denials. And what has happened is, because I have one disqualifying crime, the attempted murder, all of my criminal history, except this one thing that I cannot change, that the victim, I've actually made amends to them, and they supported me in my release, that is still there. So the judge said, you can't get you can't get any of your convictions expunged because this one disqualifies you. And when I called the clerk thinking it was a mistake, the judge said, I wish I could. To stop trying to add things to the expungement list, this gives us all the opportunity who are doing the right thing to have a second chance. Please vote favorably in this bill. Thank you.
Thank you, sir. We have one last person on this panel. Who do we have?
So we have two more people. We have Restrictive McDonald and, I'm sorry, Councilman Martin, both are available for and.
Okay.
That's Councilman Mitchell on the screen now.
That's Councilman Mitchell?
Correct.
You can proceed, sir.
Greetings, Chair and members of the committee. I appreciate Delegate Ruff for bringing this bill forward again. I remember testifying last year. My name is Martin Mitchell. I'm the former at-large councilman for the city of Laurel and an active NAACP member. I'm here today to speak in strong support of this bill about second chances, fairness, and giving Marylanders the opportunity to truly move forward with their lives. We all know the reality: a criminal record doesn't disappear. After somebody serves their time, it follows them for decades, blocking jobs, housing, financial aid, and the ability to support their families. Over 1.5 million Marylanders carry this burden, many of them people of color, fighting to rebuild in a system stacked against them. Right now, our laws make it nearly impossible for some people to clear a record. Even after years of rehabilitation, minor mistakes or technical rules can leave someone feeling trapped, living under punishment that never ends. This is not justice. That is a sentence. That is a life sentence without bars. House Bill 169 changes that. It gives judges the power to look at the whole person, their rehabilitation, their contributions, their family, their community, and ask one simple question: have they earned the right to a second chance? The bill doesn't automatically erase records. It doesn't excuse past behavior. What it does, it trusts our courts, something which we already do. The same courts we rely on to impose life-changing sentences to decide when someone has earned redemption, because everyone deserves a chance to work, to live, and to support their family, and to contribute to their community without a permanent shadow over their future. That's fairness, that's opportunity, that's justice. And I urge a favorable report of House Bill 169. Thank you today.
Thank you, sir. We have one last person on the favorable panel.
Yes, Mr. Steve McDonald.
Mr. McDonald, you may proceed.
Madam Chair,
Yeah.
I do apologize. Did you say Michael Parsons? I thought I heard that name, and I believe he's online as well.
There is no Michael Parsons online.
He's not showing up.
Okay.
All right, Mr. McDonald, you may proceed.
All right, thank you. My name's Stephen McDonald. I live in Charles County, District 28. I'm a master plumber with Local 5 Plumbers and Gas Fitters. I'm here in support of House Bill 169 because it allows courts to evaluate rehabilitation instead of forcing people to live indefinitely with technical statutory barriers. As a constituent of Vice Chair Davis, I appreciate the committee's consideration on how this legislation will directly affect me as a District 28 resident. I was in a serious car accident when I was 18 years old that caused me to have a serious back injury, and I was prescribed pain medication to treat it and became addicted. I didn't understand the risk of addiction, and my doctor didn't educate me on it, and I began misusing my medication, and I ended up altering my prescription dosage. After serving my sentence, I was committed to recovery and now have been clean for 12 years. College was not financially feasible, and my record would have created some barriers. I chose trade school to try to get my life back on the right path. I graduated from a 5-year apprenticeship program and got my master plumber's license. I'm a licensed tradesman and a primary provider for my children and family. My charge falls under criminal law section 5701D4, and while other statutes covering almost identical charges under section 5601 and 8610 that are able to be expunged, mine cannot, just because of how the statute is written. The conduct is the same, but how the statute is labeled, I'm excluded from relief. That's inconsistency is what keeps my record in place. Right now, judges do not have the discretion to review my case based on my rehabilitation. I worked too hard to be held back. I feel everyone should get a second chance if they change their life for the better. Most union plumbing jobs involve government contracts or federal facilities which require strict background checks. Because of my record, I've been denied placement, promotions, and missed opportunities to advance. I've been to court 3 times and been in front of 3 different judges trying to get this charge expunged. Each one of them said based on my accomplishments, they wish they could have expunged it, but it's just not in law. I just urge to maybe start with like smaller misdemeanors for the good cause and work your way up. But I think it's a good idea and it would help many people that have been struggling from the opioid crisis from the early 2000s. I urge a favorable report.
Thank you, sir. Now, I'm going to do one last check. Is Michael Parsons there yet?
No, he is not.
Okay.
Thank you, Madam Chair.
Okay. Are there any questions for this panel? Seeing none, that concludes this last favorable panel. We have a favorable with amendment. Is Matt Parsons here? You are excused. Thank you. Matt Parsons again? No Matt Parsons. We're going to move on. We're going to move on to the unfavorable panel. We have Laura Wilt, Carrie Borzilleri, and Colin Campbell. Okay, you may proceed.
Thank you. Good afternoon again. Laura Wilt, Senior Attorney with Maryland Crime Victims Resource Center. On behalf of the Resource Center, I respectfully urge an unfavorable report on House Bill 169. We have walked alongside victims and surviving family members throughout the criminal justice system. We do recognize the importance of rehabilitation and second chances. Expungement, however, isn't important. It is not a minor administrative action. We have to get this right. Expungement laws impact so many people in your community, not just those with the convictions, but also the nonprofits working with children, elderly individuals, employers, licensing boards, and volunteers. I ask you to remember them as you consider all of these bills. This bill in particular mandates hearings in every case, as you've heard, and we do not believe it safeguards victim interests at all or accounts for the systemic costs. Public policy must balance rehabilitation with accountability, victim stability, and public safety. Number one, mandates hearings in every case. It says shall hold a hearing in any misdemeanor or felony case after a certain period of time. Somebody mentioned about waiting 10 years before they commit their crime just so they can get something expunged. This isn't 10 years. This is 5 or 7 years, and repetitive filings every 3 years. So we have to recognize the burden that this would put on victims, the courts, et cetera. Importantly, I want to hit the good cause standard that is repeatedly mentioned here. While the factors named in this bill are important, what's missing is striking. What's missing is that there is no victim impact included in the important factors to have the court consider. How about whether they complied with condition of probation? How about if they paid restitution? There is nothing considering whether they've complied with the court order named as good cause. Thank you for your consideration.
Thank you. Next.
Good afternoon. My name is Colin Campbell, and I'm an ASA with the Howard County State's Attorney's Office here on behalf of Rich Gibson, urging this committee to issue an unfavorable report on House Bill 169. This legislation is contrary to the purpose of the expungement statutes, and consequently it poses a danger to the public at large. Maryland law currently allows for the expungement of many misdemeanors and felony convictions. However, the General Assembly was careful in deciding which convictions could be expunged and how long an individual would have to wait to file an expungement. This current legislation gives no consideration to the type of conviction expungements being sought for, allows a person convicted of murder, rape, and even distribution of child pornography to expunge their records. There are no exceptions within this legislation for convictions marked as domestically related or crimes of violence. Law enforcement, prosecutors, and our judges will not know the prior history of an individual and thus can no longer tailor sentencing to the individual. An unintended consequence of this legislation would be the legal licensing, purchase, and carrying of firearms by individuals who are already currently prohibited from doing so due to previous convictions showing their inability to do so. Convictions which would not be eligible for expungement and which would be reason for a carry license not to be issued and a handgun sale to be declined currently. A child care center or school system will no longer know if an applicant has a prior conviction for distribution of child pornography or sexual abuse of a minor. A nursing home or even a law enforcement agency will no longer know that an applicant has a prior conviction for elder abuse, rape, or even first-degree murder. This is clearly not in the best interest of the public and would ultimately pose a danger to Marylanders throughout the state. The Baltimore County Police Department actually just exemplified this in the past year. If the goal of this legislation is to assist individuals in successfully reintegrating into society after their release, the better mechanism to accomplish that is through shielding, not expungement. Finally, you have heard that the surrounding states have expansive shielding laws. Again, that is shielding, not expungement. If this expungement bill dealt with shielding instead, I don't believe that there would be as much opposition, but for the inclusion of all misdemeanors and felonies, which is just far too broad to ensure public safety either way. For these reasons, I respectfully urge an unfavorable report on House Bill 169.
Thank you. You may proceed.
Good afternoon. My name is Carrie Borzilleri, and I'm here on behalf of the Maryland States Attorneys Association. The Maryland States Attorneys Association is opposed to House Bill 169, Criminal Procedure Expungement of Records Good Cause, and asks for an unfavorable report. In 2016, the Maryland legislature embarked on a mission and project which became the Justice Reinvestment Act. Included within this extensive package aimed at addressing the criminal justice system as it existed was a major change and expansion of expungement availability for those intent on first paying their debt to society, but then intent on making a future for themselves without the constraint of a criminal record. In doing so, however, the legislature was cognizant of and created statutes which still required some accountability and protection of society. This bill will take us beyond consideration for some accountability and provide little ability to protect society from those who choose to repeatedly commit offenses. In 2023, the General Assembly lowered the waiting period even more than previously established. House Bill 169 would effectively remove all of the substantive portions of the expungement statutes. It is not an effort to amend Criminal Procedure 110 and is instead a proposal to create a whole new statute. The new statute appears to create the right to expungement of any misdemeanor after 5 years and any felony after 7 years from the completion of the sentence. All that the petitioner is required to do is to convince a judge that there is good cause to do so with consideration of the factors listed in subsection E of the newly created statute. The bill would require a hearing for every petition filed. There is nothing addressing the ability of the state to participate in the process, and there is nothing granting any input or rights to the victims in this process. The bill as amended would appear to grant the ability to a person to expunge absolutely any crime of which they have been convicted simply upon the very generic phrase of good cause. A person convicted of first-degree murder, rape, sexual abuse of a minor, distribution of child pornography, armed carjacking, and so many more outrageous crimes would be able to ask for an expungement. We respectfully urge an unfavorable report on House Bill 169. Thank you.
Thank you. This concludes the unfavorable panel. Are there any questions? Yes, Delegate Arkan.
Thank you, Madam Chair. Thank you guys for being here. So you've given us a whole lot to think about. But that one case of the individual with the child confinement has really bothered me, since so many of us grew up being left in cars while our parents grocery shop for an hour. So I'm just wondering if you could Explain to me, is this charge common, charging someone with child confinement for leaving them in a vehicle to use the restroom? Have you ever seen that before? Is that happening a lot?
I personally have not in the jurisdictions I've worked.
You guys have not?
I've never encountered that charge.
Well, that makes me feel only slightly better. Okay, I do appreciate some of the concerns that you guys raised, and I can see exactly why we may need to do some real research into how to appropriately address some of these obviously kind of like silly situations that folks are getting themselves into that don't really make a lot of sense. So hopefully, I mean, maybe not this year or this bill, but obviously there's some people who are really suffering for no reason at all. I mean, really stupid stuff that in the 90s would have been completely normal. So thanks.
Thank you.
Any further questions? Okay, that concludes the unfavorable panel, and that concludes the testimony on this bill. Which one is it? HB 169. Thank you so much. Okay, we are going to call Delegate Embry, HB 467.
Thank you, Madam Chair. May I ask a few members of witnesses to come up?
Absolutely. You can bring your panel up.
Thank you so much.
I believe there's a favorable with amendment. Do you have a problem?
I do not.
Okay.
Hopefully, we have incorporated those amendments.
Does that
I
mean?
believe we have, so.
Does that mean?
Okay. You may proceed.
Thank you very much, Madam Chair, and everyone. This bill we did pass last year. I have a few amendments, but they don't really get to the heart of the bills. And this year, luckily, we have a Senate sponsor. Chair Smith is the sponsor. Oh, I'm sorry. Sorry. I was just saying this bill we did pass last year, and it is not substantially changed, although I will discuss a few very excellent amendments that some people at this table suggested. So this bill is about due process for parole, people eligible for parole, and it does a number of things like discovery, meaning that documents that will be relied upon by the deciding panel will be provided affirmatively to the inmate and with an amendment to their representative if they have one. It improves sort of deadlines and gives a framework for when they can expect to hear the decision and they can receive the reasons for the decision. Those things are not controversial. There's also annual reporting, which we've added to a little bit, that gives us a better sense. It will give the public a better sense of the outcomes and overall impact of parole decisions. It's also will be disaggregated by race, which is, of course, very important for many of the groups following this work. But the controversial part I will just focus on, which is right now there's this sort of unacknowledged number of people eligible for parole who are not receiving hearings. That is not the position of the department or the position of the Parole Commission, but it is what is happening. And so that's not fair. If we've decided you're eligible for parole, then you're entitled to a hearing. And so the time frame that is provided in the bill, which was a matter of a lot of discussion last year and has not changed from last year, it says the commission does not have the authority to permanently deny parole to anyone who is eligible. It doesn't change eligibility. And if you are eligible, if you are incarcerated to a period of 10 years or less, your sentence is 10 years or less, then you're eligible no later than 2 years after each parole hearing. So they have to set it within 2 years. They can set it more quickly, of course, but no later than 2 years. If the person is sentenced to A sentence over 10 years, it's 3 years, no later than 3 years. And a person sentenced to a period of incarceration over 20 years for a crime against an individual, it's not later than 3 years for the first hearing, and then after that, it's not later than 5 years. So it's trying to acknowledge the seriousness of the crime, whether or not there's a victim, but also guaranteeing that a person eligible is in fact receiving it. The amendments I'll talk about very quickly. Again, I think they're all friendly amendments. They add some of the reporting data, tighten up the what is provided, give examples of what must be provided affirmatively as discovery, strengthens the timeframes, and otherwise, I think, improves the bill. Thank you so much.
Who would like to go next?
Hi, Ann Pack, co-founder and director of advocacy for Prepare, and I was also a member of the work group in the Maryland Equitable Justice Collaborative that looked at parole and decarceration. And this bill is really in bill form our recommendation 10 that was published in the report. So I attached that to my testimony if you'd like to refer back to it to make it a little easier for you to find. But really, the aggregate data that it is requiring is looking, we identified an issue with Maryland data by looking at a prison policy initiative report that was vastly different from a justice policy initiative report. And that was because of an error in a way some of the data was being constructed into the Maryland Parole Commission reports. It makes Maryland look really bad, but Maryland's not doing really bad. So we're trying to get some of that data to even that out. It's reporting the reasonings that the Parole Commission is using. It's providing free copies of the recordings, and it's providing people the documents that they need to, that the statutory factors speak to. So if I go up for parole, they're looking at 11 statutory factors. For example, statutory factor 11 looks at my case plan, my compliance with my case plan, and that's reported in a pre-parole summary with a case manager recommendation. And currently, as an incarcerated individual, I don't have any of those three things. So I can't be compliant with a case plan that I can't read. And if I don't know what's in my pre-parole summary, I can't object to something that's incorrect. And I should have the recommendation that my case manager is making about me. This is somebody that's worked together. I should know what their recommendation is. And so this bill is saying that those things that the decision is being rooted on, I'm going to have those things so that if there's something wrong, I can point that out, and so that I can have fairness and transparency in my process. It establishes those regular timelines that Delegate Embry was talking about, so that I can't suddenly have a non-parolable sentence because somebody made a decision to change my sentence. You've got to come back and look at me, even if it's 5 years from now. You've got to come back and have another look. And so I thank you for your consideration, and I urge a favorable report.
Thank you.
Hi, my name is Olinda Moyd, and I'm here today on behalf of the Maryland Alliance for Justice Reform. We support a favorable report on this bill with the amendments. It's no secret that the Parole Commission needs reform. It has for quite some time. I've practiced before the Maryland Parole Commission for a few decades now. And I'd like to just highlight a couple of examples as to why this transparency and accountability for the Parole Commission is really, really important. One, the point about informing incarcerated individuals of the decision within a specific time period. In March of 2025, I, along with my students from American University, represented Mr. B at his parole hearing. It was a life sentence. We went before 2 commissioners. He's 65 years old, been in prison since 1981. At the end of his hearing, he was told that his case was being put forward to the next step, which is a pre-parole life investigation summary. We left the hearing feeling hopeful. That was a year ago. I have since retired from teaching at American University. We are still waiting for the pre-parole life investigation to be completed by the Parole Commission. Another point, providing documents to the individual regarding what the Parole Commission is going to take into consideration at the hearing. Example, I recently walked into a hearing and had the commissioner read to me a letter from a sitting delegate opposing my client's release. I requested to receive a copy of the parole file. I received it. This letter was not included. My client had the opportunity to review the file 30 days prior to the hearing. This letter was not there. It's important that the individual know what the Parole Commission is taking into consideration when making the decisions. For these reasons, we support House Bill 467. Thank you.
Okay. Matt?
Hi, my name is Gordon Pack, and I really appreciate this opportunity. I am the former chair of the Decarceration and Parole Subcommittee of MEJC. I'm also a parole advocate. I'm also someone who had appearances before the Parole Commission 16 times through a 43-year period. Now, I believe that this is a public safety issue, and I applaud Delegate Embry on this because it is a godsend. It addresses all of the concerns that we raised when we submitted our reports to the steering committee regarding parole. Parole should be transparent. It should be consistent. People going up for hearings need to know what they have to do next time to be successful in getting released. The commission itself has made some improvements with that, but it's not legislated. It's not written down anywhere. So the next commission can come in and say, look, we're not going to do this. So we do need consistency. We do need information about what's taking place there so we can evaluate the people that we trust to make these great decisions. And I'm saying great because when you make a decision to release someone early, that is real serious, and you have to consider a lot of factors. And it's a job that I would not want to have because there are repercussions to this. The wrong decision could mean an issue for someone in the community. It could be an issue for all of us if a person's released and he's not ready or she's not ready for release. So I think that is a real important thing, getting that information out. And I do not believe, and I'm saying this as someone who's been through the system and been in these meetings with the Parole Commission, Department of Parole and Probation, DPS Reentry Services, case management, clinicians that's involved in this space, victims' right advocacy groups, family members of people who are inside, and someone who initiates and interacts with the commission on a regular basis. When these decisions take place, no one should be refused for a long period of time because people can change. So setting a barrier is really good. So for this reason, I urge a favorable vote on this particular issue. Thank you so much.
Good afternoon, Vice Chair, members of the committee. Elizabeth Hilliard with the Office of the Public Defender. I had the honor and pleasure of chairing the work group of the Maryland Equitable Justice Collaborative, under which the Decarceration Subcommittee met. And I got to see weekly, which I couldn't even attend weekly, which really demonstrates the commitment that the rest of the subcommittee held in making these recommendations of folks from all different areas coming together and working together and really trying to make our parole process better. And this is the product of that. We had members from DPSCS, we had community members, we had advocates, we had folks who work in parole, really do the hard work of trying to figure out tangible, achievable steps to take to improve our parole process. And this bill is the product of that. And for those reasons, we thank Delegate Embry for introducing it and urge a favorable report.
Thank you. Colleagues, questions for this panel? Seeing none. Thank you for being here. There is one favorable with amendment that we missed, Dara Johnson. Please come up.
Thank you very much for your work on this. I really appreciate it.
All right, good evening. My name is Dara Johnson, and I'm an associate staff attorney with the ACLU of Maryland, here in support of this bill, if it's amended in line with the revisions that are attached to our written testimony, which we authored in collaboration with the Center for Criminal Justice Reform at the University of Baltimore Law School. So as much of our work at the ACLU focuses on supporting parole candidates at the deepest end of the system, we truly appreciate the fair process that this bill seeks to promote. This especially includes ending the practice of permanently denying parole consideration, as parole refusals can mark a person as unredeemable despite demonstrated progress they could contribute to our communities if given a real chance. We also support a recent change that limits public disclosure of the reasons for a parole decision to those shared by the entire panel, rather than each individual commissioner. This helps reduce the external political pressure that was our primary concern with this provision. To help further get at the heart of the procedural problems with parole consideration, we have also proposed four further updates. The first simply ensures representatives like us have direct access to our clients' parole information, which is currently not always provided and impacts our ability to provide timely support. The second change ensures parole candidates can access victim impact statements and risk assessment reports, subject to appropriate limitations. While these documents are already disclosable, they are kept hidden from parole candidates. This happens often, especially the many who must navigate this process without a lawyer. Affirmative language is needed to make sure everyone has a fair chance to account for all the considerations impacting their freedom. The third revision would set a 12-month deadline to make a final decision after a parole hearing, which is needed as a first step towards making sure candidates are not kept in limbo for an indefinite time and everyone is afforded a genuine expectation of timely decision-making. The last change simply reaffirms the existing confidentiality of parole hearing recordings to make sure this sensitive information is fully protected from undue public access. So with this, we urge a favorable report with these amendments. Thank you.
Thank you so much. This is the last favorable with amendment. Are there any questions? All right, thank you for being here. There is one unfavorable, that is Laura Wilt. No Laura Wilt? All right, that concludes the unfavorable panel on this bill. That concludes the hearing on this bill, HB 467. Thank you so much for being here. We are going to move to the next one, which is Delegate Stinnett. You ready? HB 824.
Oh, boy.
Okay. Give me one moment, please. Is 824 over there? Okay, I don't see 824.
I don't think we can move forward because we don't have a quorum.
Clarifies the panel.
60%?
Huh?
60%.
Yeah, we at least need to have 11.
Oh.
Yeah, 1, 2, 3, 4, 5, 6, 7.
Delegate Stinnett, you have your panel. Christopher Sweeney, Jessica Emerson, Christopher Dews, Trina Selden, in person.
Okay. Saquon, Mayor.
Hold on.
And,
Yes.
okay. And Trina Selden's a me too.
He was signed up as virtual.
Oh.
Mr., well, we're good, said Mr. Merritt. Okay. You may proceed, sir.
Sure. We're good? Okay, all right. Well, before we start, I do want to say quickly that, I just realized today is my 1 year since I've been in the legislature. This is my first day last year, so it's fitting. Yep, so, no, thank you, Madam Chair. Thank you, Madam Chair, and members of the House Judiciary Committee, which is the greatest committee here in the House building. For the record, I am Delegate Sean A. Stinnett, representing the 41st Legislative District in Baltimore City. I am here today to present House Bill 824, Criminal Procedure, Expungement, Conviction of Distribution of Controlled Dangerous Substances, which adds a felony CDS distribution charges under 5602A to the expungement list under Criminal Procedure 10-110. Under current law, possession with the intent to distribute a controlled dangerous substance under 5602 is already eligible for expungement. So if you are in possession of the substance and are arrested, you can have the charge expunged. If you hand the substance to another person, then you are not eligible for expungement. This is a very strange inconsistency in the code, which this bill seeks to resolve by saying that both the intent and the distribution be eligible for expungement after the completion of the sentence and the required rating period of 7 days. We know that the war on drugs started as a war on poverty, and millions of Americans were put into the criminal justice system. This bill does not excuse their participation in CDS distribution, but ensures they can still participate in the Maryland workforce after they have served their time. To be clear, if this bill passed and went into effect today, an individual seeking an expungement for a CDS distribution charge still has to complete the entire sentence, including parole, probation, or other forms of mandatory supervision. Two, also had to wait an additional 7 years after completing the sentence. Three, has to survive potential objections from the state's attorney's office and any possible victims, and cannot get the record expunged if there's a subsequent offense during the waiting period. Also, if this is part of a unit of charges and one of the charges isn't eligible for expungement, then the entire unit wouldn't be eligible for expungement, including the distribution of charge. Again, the passage of this bill would not lead to any decrease in public safety, as there are more than enough safety checks for the expungement of this charge. For this reason, I respectfully urge a favorable report.
Thank you. How would you like to proceed?
Thanks. Christopher Dews, representing both Out for Justice and Life After Release. As the delegate said, this is simply to try to resolve a bit of an inconsistency. We understand the nature of why originally there was a distinction there between the distribution and possession with intent to distribute. However, we believe that the actions are relatively the same in the sense of like what was happening. And the question that we're just really trying to get at here is, at what point does an individual, or should an individual be able to move on from these specific circumstances in their past? Again, with intent being eligible for expungement, but the actual distribution not, it does seem to be a bit of an inconsistency. And when we go to expungement clinics, specifically in Baltimore City, just to be blunt, from an Out for Justice perspective, the vast majority of individuals that walk up to us and want their charges expunged tend to have a distribution charge. And so we're simply pushing this bill out here for the purposes of ensuring that that relief can be granted to them in accordance with Criminal Procedure 10-110. Lots of other things I could say, but I'm going to stop there because long day. Thank you.
Mr. Merritt?
Yes. How you doing?
Good.
Thank you, Madam Chair, Vice Chair, and members. For the record, I'm just going to say my name again, Saquon Merritt. This is the third time I'm speaking today, obviously, so I want to come from a kind of different perspective. So why add distribution to expungement eligibility? Because in many communities, like our great city of Baltimore that I grew up in, distribution was not viewed the way policy debates frame it. It was survival. It was a distorted entrepreneurship. It was young men and women using the only economic model they saw around them, and that was indiscriminately accessible to us all. In destitute communities where legitimate capital is absent, where banks don't lend, where opportunity is scarce, people create informal economies. Many of us are teenagers, young adults, making adult decisions in environments built on scarcity. HB 0824 simply allows distribution under Statute 5-602A to be eligible for petition by amending the expungement statute. It does not erase the conviction. It does not eliminate accountability. It allows a petition. Here's why that matters. When someone transitions from the underground survival to legitimate entrepreneurship like I did, they should not be permanently barred from full participation in the legal economy because of how they survived in poverty decades ago. Many of the same traits that drove people into distribution, risk tolerance, hustle, networking, supply management, are the same traits that make a strong business owner when redirected legally. The question is, do we allow transformation, or do we permanently freeze people in the worst version of themselves years ago? If someone has served their sentence, completed supervision, remained law-abiding, built stability, and contributed to the tax base, what public interest is served by saying they can never even ask a judge for relief? This bill recognizes that people mature, communities evolve, policies evolve, laws should evolve too. I'm not asking you to excuse the past, I'm asking you to acknowledge growth. HB 0824 says that survival in poverty should not equal permanent exclusion from prosperity. I respectfully ask for a favorable report.
Thank you. You can proceed.
Good evening, Vice Chair Davis, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which works to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking and those populations put at highest risk of exploitation. I am also here in support of House Bill 824. At the HTPP, we frequently work with survivors of human trafficking who have been forced to commit criminal acts by their traffickers. One of the most common ways these perpetrators profit off their victims, yet insulate themselves against detection by law enforcement, is by forcing their victims to distribute drugs for them, which often results in the victim being convicted for distributing or dispensing a controlled dangerous substance, which is not currently eligible for expungement. This scheme has the added benefit of allowing the trafficker to establish additional control over their victims by saddling them with a criminal record. For instance, in the infamous Victor Rax forced labor case, which I linked to in my written testimony, Rax, a trusted member of the immigrant community in which he lived, would groom his male victims through excessive gifts and acts of affection. He would eventually request that they repay him by dealing drugs for him and use the profits from those victims' labor to maintain several vacant properties where he would then take his victims and sexually assault them. Once that act of sexual violence was complete, his control over his young victims was also complete, and he was then able to continue to exploit them for their labor with impunity. Many of his 34 victims, the majority of whom were not identified until after his death, said one of the major reasons they delayed reporting what Rax had done to them is that they thought the police would first see them as drug dealers, not abuse victims. This case, while extreme in its reach, illustrates both the power and the effectiveness of this type of forced criminality. House Bill 824 would provide criminalized forced labor survivors with an opportunity to petition the court for expungement of this incredibly stigmatizing conviction. And for this reason, the Human Trafficking Prevention Project supports House Bill 824 and respectfully urges a favorable report. Thank you.
Thank you.
Oh, I'm sorry.
All good.
Put my glasses back on because I'm that age.
Good afternoon, Vice Chair Davis and members of the committee. I appreciate the opportunity to be here. My name is Christopher Sweeney with Maryland Volunteer Lawyer Service. I'm the managing attorney at our Workforce Development Project, where we help to remove barriers to employment for returning citizens who are enrolled in job training programs. That most often takes the form of criminal record expungement. And it can't be overstated the way expungement opens doors to employment and housing that might otherwise be permanently inaccessible to those who have served time in prison. I hope we can all agree that rehabilitation is the best outcome for these individuals. Social and economic stability, becoming a contributing member of society, is the best outcome for an individual who has served time, and that's what this bill is designed to do. As Delegate Stinnett mentioned, possession of controlled substance with intent to distribute is already eligible. And in fact, the act of distribution is criminalized in the exact same subsection of our criminal code. Those are felonies that do carry severe penalties, even potentially decades behind bars. But that's the punishment that's already been designed by this legislative body in our criminal code, and we've entrusted the judiciary to make an appropriate sentence for that individual. But once that sentence has been completed, and then the person spends an additional 7 years proving that they have in fact been rehabilitated, how can we continue to deny them the chance for a career and a stable life? If anything, continued punishment in the form of a permanent criminal record might be more likely to drive someone back toward crime than it is to keep our communities safe. So this bill is a common sense measure to expand expungement access to be in line with what's already been determined eligible by this legislature. And for those reasons, I respectfully urge a favorable report.
Colleagues, questions for this panel? Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. Mr. Dews?
Yes, sir.
You spoke about the difference between distribution and what, possession?
And possession.
And what's the difference?
The difference being that, so possession with intent is, generally speaking, you are in possession of the product, maybe in a certain amount of a certain quantity, but you have not yet distributed it to that individual. Once it has been handed off to that individual, then it is considered a distribution. And I believe the specific statute, is 5602A. And the other, and as Mr. Sweeney mentioned, there are other other provisions in that statute that are eligible, but just that one specific idea of once you hand it to somebody, it's not eligible for expungement.
Right. Now, can you be charged with this if you share some of what you have with a friend?
That is a question that I will pass that to the attorneys. Anybody want to take that? If you share, so if you have possession of it and it's a controlled, and you hand it to your friend, I would say yes. Yeah.
Yes, I'm trying to help you.
Oh, I'm sorry. Yes, thank you, Delegate.
Thank you.
Yes. Thank you, Delegate. Thank you for the question.
Oh, no, not you.
All right, any further questions for this panel? All right, hearing none, thank you for being here. We're going to move to the next favorable panel. On the next panel, we have Trina Selden. Is she here?
No. She's a Me Too.
She's a Me Too. Okay, that leaves Stephen McDonald from Charles County. Mr. McDonald, are you still on? Need your help, virtual. Mr. McDonald, are you there?
Yes.
You may proceed.
Alrighty. I'm Stephen McDonald from Charles County District 28. I'm favorable with amendments to add charge 5701D4. I've testified on multiple bills today simply because my charge should be eligible for expungement, but it's not. The governor's bill last year originally had my charge on it, but it was removed last minute. My charge is under. Yes.
You may proceed.
Oh, alrighty. I'm Stephen McDonald from Charles County District 28.
Mr. McDonald, you're going to have to turn off the other audio.
Okay.
We heard the first part. You just need to turn off whatever you're listening to.
Okay. Because my charge would be eligible for expungement, but it's not. The governor's bill last year originally had my charge on it, but it was moved last minute. My charge is under section 5701D4. I simply want this issue addressed because, again, my charge is eligible for expungement in other statutes, section 5601 and section 8610, but not in section 5701D4. Same conduct, altering and counterfeiting prescriptions. My charge is a lesser offense than the existing charges that are eligible. I don't know which bill will move this year, so I wanted to ensure that I'm on all of them. I'm happy to explain if anyone asks a question. I urge a favorable report.
You got a reaction from the audience, Mr. McDonald.
Yeah.
All right, questions for Mr. McDonald, the last person on this panel? All right, seeing none, that concludes the favorable panel on this bill. We're going to move to the unfavorable panel, and that is Carrie Borzilleri. You may proceed.
Good evening. My name is Carrie Borzilleri. Once again, I am here on behalf of the Maryland States Attorneys Association. The Maryland States Attorneys Association is opposed to House Bill 824, Criminal Procedure Expungement, Conviction of Distribution of Controlled Dangerous Substance, and asks for an unfavorable report. In 2016, the Maryland legislature embarked on a mission and project which became the Justice Reinvestment Act. Included within this extensive package aimed at addressing the criminal justice system as it existed was a major change and expansion of expungement availability for those intent on first paying their debt to society, but then intent on making a future for themselves without the constraint of a criminal record. In doing so, however, the legislature was cognizant of and created statutes which still required some accountability and protection of society. In 2023, the General Assembly lowered the waiting period even more than previously established. Despite the painstaking efforts of the General Assembly to carefully consider all criminal offenses and include those by which it has been determined deserve consideration for expungement, there have been a few occasions where additional eligible offenses have been added. The addition of distribution of a controlled dangerous substance as an offense eligible for expungement, however, should not occur. This crime, in its most simple terms, is being a drug dealer. One who engages in this act or set of acts has made the affirmative decision to distribute a controlled dangerous substance in exchange for money. The act or acts of that person provides a grave amount of danger to those who buy the drugs from them or to all whom the drugs are further distributed. It is an unquestionable truth that these acts cause the deaths of many individuals who then use those drugs. Drug dealing is also an inherently dangerous crime by its very act. Many die or are gravely injured in the battles between drug dealers. Innocent law-abiding citizens and law enforcement are endangered by the acts of drug dealers. Without the active distribution of drugs, there would be no deaths from the use of or contested turf wars. The Maryland States Attorneys Association respectfully requests an unfavorable report for House Bill 824. Thank you very much.
All right, colleagues, any questions for this witness? I think I have one. I know I have one. Does an expungement in any way impair your right to prosecute cases in the future?
Not to my knowledge.
Thank you.
Thank you.
Come on up, panel. On the panel. Okay. Oh, goodness.
Do you need help? You need help with your first panel, or you want? You can call them.
You know what? I think we may need to grab people. Yes, ma'am. Some of our folks they just got tired. They had to go home. I'm hanging there. I still got a little bit left in the tank, just a little bit. Woo! So I guess if you.
Hold on 1 second.
Yes, ma'am.
Let's try to get a full panel up here.
Yes, ma'am. Thank you. Maybe
we can get one more.
Hello. Oh, yeah, and Miss, okay. Yes.
Thank you so much. I just ask that you state your name before you begin your testimony, but we're going to start with Delegate Crutchfield. Thank you.
All right, good evening, Judiciary Committee and Madam Chair. Thank you. Thank you for being here and staying late. So, all right. For the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I am here in support of HB 935. This is legislation that you have seen before, unfortunately. But I do want to add several things to that, and that is that this legislation is a priority of the Legislative Black Caucus. It's a priority of the Women's Caucus, and most of you actually are co-sponsors of this legislation. So I'm happy to be here for those reasons alone, but also to let you know that this legislation is now supported by the FOP, the Maryland State FOP, and for good reasons, because guess what, colleagues? There's something that we did in 2021, and that was to veto. There was a veto of an override of a veto from the then governor, and that was this legislation. So this legislation passed in 2021. The legislation itself is to build a pre-release center for women. That pre-release center was scheduled to be built in 2023. Unfortunately, it did not happen. So we have a broken promise. We made a promise, but now it has been broken. And we are here today to ensure that this promise that has been delayed is actually delivered, because we need to make sure that this particular pre-release center is built for women. The women in our Maryland Institute for Corrections is in dire need of this particular place, for them to actually get the services they need, to actually be able to come out with respect, to get jobs they need, to have all of those things that are necessary for them to be successful. That is what this legislation is really about. And it is making sure that it is built in a proper place, a safe place for women to actually strive and to be comfortable and to be safe as they go about and get the necessary things that they need. So that is really specifically what this legislation does. It provides the specifics on how to build this, where to build this, what it should look like as far as acreage goes, how many beds should be there, what kind of services should be provided. That is all this legislation does. No funding, nothing else, but making sure it is built correctly. And so I want to make sure that you all understand that this is paramount, because this is a promise we made. We got to make sure we deliver on this promise. Now, there may be some more amendments to this bill to, again, clarify it, okay? But most importantly, this is about us, the legislature, and making sure this happens for the women of MCIW. So thank you very much, and I'm going to pass the mic. Thank you, Delegate Crutchfield. Don't start the clock yet. I'm tired. Give me 1 second. I got to catch my breath. Just give me 10 seconds. All right, start the clock. My name's Monica Cooper. I am the Executive Director of the Maryland Justice Project, and I'm here to ask for a favorable vote on HB 935. And I also want to commend you and this committee, because I was sitting there just listening to the testimony, and I can't imagine the challenges you have with trying to do two things: create a just society and to provide people with second chances. It's such a difficult thing to create a safe and space for citizens, for your constituents, and also to provide second chances. So, yeah, I don't envy you guys at all. I know it's tough, and I know it's difficult. But what I do also know that should not be difficult is this right here. This should no longer be difficult. We've been here. I've said all that I could say. We've said all that we could say, and it should not be continuously kicked down the road. When you have the power, seize it. This, the leadership here, from the governor's mansion on down, has had the power to make this happen. You never know when you're not going to be in power, and there are missed opportunities. I have seen legislation on the federal level, on the state level, that have went, that hasn't been, nothing has been done, if you will. It just not doing anything is costly. It is costly not to do anything. So I just want to encourage you guys now that, I mean, you have the power. You can make this happen. It lies on the leadership. It doesn't rely on Department of General Services. It does not rely on the Department of Correctional Services, which they actually my friends. I always like to big up them because we have a great relationship. But you can sometimes be wrong on an issue. But it's nothing that Secretary Scruggs cannot call me, because we have one thing in common. We want people to come home and do well, and we want safe communities. That's what I want. My taxes are extremely high, and I work really hard. So I want my roads to be fixed. I want my streets to be fixed. So we want the same things. Uh-oh, my time's up. Fine. I'm going to take a nap. Thank you.
You can finish your sentence if you'd like.
No, I'm done. I'm actually wiped. I'm tired. I don't have nothing else to say. I appreciate you, though, and congratulations, Madam Vice Chair. It feels so good to say that. Madam Vice Chair.
Thank you so much.
Congratulations.
Thank you so much.
Yes, ma'am.
Who would like to go next?
Since I'm right next to you. Good evening, everyone. I'm Shekinah Braveheart, an executive member of the Women's Pre-Release Equity Coalition. We are a group dedicated to addressing systemic gaps in pre-release and reentry services for women. We respectfully request that this committee issue a favorable report on HB 935. This legislation is a long overdue step towards ensuring that incarcerated women receive effective, gender-responsive pre-release services that support successful reentry that Monica spoke about, strengthen families, and enhance public safety. Now, if you refer to our written testimony, you will see listed among our coalition members the names of 196 incarcerated women. That's nearly a third of the total female prison population in the state. These are experts in their own lives, asking this body to correct a 16-year inequity and uphold the Maryland General Assembly's earlier promise to provide a community-based pre-release facilities and services. Now, many of the women share their experiences with our coalition, illustrating the real world consequences of Maryland's failure to provide adequate pre-release services for women. And I'm just going to tell you a few of these stories. One person believes that she served a harsher sentence because Maryland lacks a pre-release facility for women. She is housed on a maximum security compound, MCIW, with people who will never be eligible for pre-release or work release. She's been assaulted twice. Once she reported it and nothing was done. The second time she fought back and lost her privileges. This has directly impacted her life in other ways. It impacted her family. Her 6-year-old autistic son, her only child, had to undergo open heart surgery while in foster care because there's no community-based service. She couldn't see her son. She couldn't be there. There are no more home passes for people inside. So she is mothering from afar. So these are some of the reasons, my time is up, but some of the reasons why we really need to get this pre-release service open in our communities.
Thank you.
And I'm available for answering some questions.
Thank you.
Good evening, Madam Vice Chair, members of the committee. My name is Lydia Watts, and I'm the Executive Director of the Rebuild, Overcome, and Rise, or ROAR Center at the University of Maryland, Baltimore. I'm speaking in support of HB 935 in my personal capacity. My views are my own. ROAR provides wraparound services to survivors of homicide, non-fatal shootings, sexual assault, and intimate partner violence in Baltimore City. Since 2019, we have served more than 900 people in the city. Most of our clients have experienced multiple victimizations over their lifetimes. My experience interacting with those survivors and the research is very, very clear. Trauma is a primary driver of women's incarceration. Between 70 and 95% of incarcerated women have histories of physical or sexual abuse. Up to 86% are survivors of sexual violence, and the majority have experienced violence in their childhoods. Many of the women serving time for violent offenses committed these acts in the context of intimate partner violence, often to protect themselves and their children. In other words, we have created a survivor to prison pipeline for women. And when these women return home, they face the same barriers that my clients face: unsafe housing, untreated trauma, substance use disorder, lack of employment, and complex systems that are nearly impossible to navigate without help. Yet we send them to reentry programs designed for men, ignoring their safety needs, their caregiving roles, and their trauma histories. Most are mothers, most are survivors, and many are at high risk of being victimized again. HB 935 recognizes that women's pathways into incarceration and their pathways out are different. Gender-responsive, trauma-informed pre-release services will reduce recidivism, improve public safety, and stabilize families. Survivors consistently tell us what they need: safe housing, long-term counseling, legal support, job pathways, and help navigating systems. Providing these supports before release is not just humane, it is cost-effective and prevents further harm. I respectfully urge a favorable report on HB 935. Thank you.
Thank you.
Good evening. Honorable Chair, Vice Chair, and members of the Judiciary Committee. I'm Monica Watkins, past president of the Baltimore Alumni Chapter of Delta Sigma Theta Sorority Incorporated and chair of the Bridge Project of the Baltimore Alumni Chapter, supporting justice-impacted women. I'm here today in support of HB 935 that has been before this body before. Consequently, it is my understanding that you are acutely aware of the lack of services available for women in Maryland. You also know that this bill was heard on the Senate side, SB 187, with wide support, including Maryland Catholic Conference and the Maryland Legislative Agenda for Women. Women continue to have to beg for equal treatment, even in the area of correctional services and preparation for reentry into society. The women of the Bridge program, when they are matched with a mentor, enter the program demonstrating limited preparedness and requiring a host of needs and resources. We have worked with the Maryland Correctional Enterprises and subject matter experts from the National Association of Public Defenders to prepare and train our mentors. But even with that training and ongoing training that we provide, we are ill-equipped to support the many services that the mentees need. We, however, have learned to pivot and pull on the nearly 600 members of the Baltimore Alumni Chapter to fill in the gap due to the lack of pre-release services and preparedness for women. The Prison Policy Initiative states, with an incarceration rate of 49 per 100,000 residents, Maryland incarcerates women at a higher rate than most of our closest international allies. Justice-impacted women, their families, their communities, and the state of Maryland cannot kick this can down the road any longer. I urge your favorable report of HB 935. It will help us better assist our mentees, their families, our communities, their communities, and our state. Thank you.
Thank you. Colleagues, questions for this panel? Seeing none.
Amen. See you later.
All right. We're gonna call up, thank you.
Uh-oh.
We have a late bloomer.
Not so fast.
Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So, Delegate, how far along is this project that we're talking about here? Is this, because I'm looking at the fiscal note, and so what, we're 350,000 in on the $9 million?
Are you talking about how much funding has been used?
Yeah.
Or what are you asking? Okay.
Yeah.
All right. So we're really not sure exactly how much has been used. $9 million has been authorized originally for the initial design phase. Not sure how much of that actually has been used towards the project. What happened is that Department of General Services had located a place in Baltimore City, which is actually a parking lot, across from the Baltimore Detention Center as the location. And at that point in time, there has been probably a minimal amount of real design work done there. And as of now, everything is on pause. So just so everyone will know that it has not proceeded any further other than the location right now of the facility. On pause, hopefully for, again, Department of General Services to locate a new place for the ultimate build out of the facility.
And in the meantime, are we trying to put the money back into the budget? Because I'm looking where it says.
Absolutely.
Oh, absolutely.
Absolutely.
Yes, okay.
Trying to do that.
Thank you so much, Delegate.
All right. Thank you. Now you're officially excused. Thank you so much.
Thank you. Thank you. Thank
All
you.
right. Elizabeth Hilliard? And I think we've got everyone else except Alana Thomas. Is there anyone else? Alana Thomas virtually? Okay. Yes, you can let her in. Ms. Hilliard, you may proceed.
Thank you, Chair. Elizabeth Hilliard with the Office of the Public Defender. Us too, and we urge a favorable report.
Thank you. All right. Alana Thomas? Wait, who is it?
It's Alana Thomas.
We have one more favorable, Alana Thomas. Can you hear me?
I can hear you now, yes.
You may proceed.
Okay, thank you. Good afternoon, Chair, Vice Chair, and committee members. My name is Alana Thomas, and I am a student attorney in the Racial Justice and the Law Clinic at the University of Maryland Francis King Carey School of Law. Today, Maryland operates 6 pre-release facilities for men, but 0 for women. Pre-release facilities are designed to help people transition from prison to community. At their best, these facilities are housed in the community, providing an array of community-focused services that support and allow individuals to search for jobs, gain vocational training, rebuild their families, reconnect with their home communities, adjust to all that has changed in the world outside of prison, and begin the reintegration process. However, these opportunities do not exist for any women in Maryland. Instead, women who have earned pre-release status are housed inside the Maryland Correctional Institution for Women, a maximum security prison. Unlike their male counterparts, they lack access to the community-based reentry supports that are essential for successful reintegration. Instead, they remain in a prison. And Out for Justice has found that many women in pre-release status at MCIW fear for their safety. This is an injustice that grows with urgency each year that needs to be remedied immediately for the sake of the women deprived of access to these community-based supports, their families, and their communities. HB 935 calls for a dedicated pre-release facility in Baltimore City, away from any prison or jail and accessible to public transportation. Such a facility would place women within reach of what they need most during the pre-release period, including gender-responsive services that account for their life experiences and future goals. HB 935 would ensure that women, like men, have access to a comprehensive pre-release facility that supports successful reentry. And for these reasons, the clinic respectfully urges the committee to issue a favorable report on HB 935. Thank you.
Thank you, Ms. Thomas. Are there any questions for this witness? Hearing none, that concludes our favorable panel. And now for our very anxious favorable with amendment panel, we have Beth Tomasello, Matan Zimmer, and Frank Patinella.
Yes, hi.
Thank you. You may proceed.
Thank you. Good afternoon, Madam Vice Chair and members of the committee. My name is Frank Patinella. I'm with the ACLU of Maryland, and we strongly support House Bill 935. First, I want to acknowledge the members of the Maryland Women's Pre-Release Equity Coalition today. If it's okay, I'd like to ask them to please stand. They took a whole day to be with you.
I appreciate it.
And to
Thank you
get your
for being
attention. Thank you.
Advocacy is important. Thank you for being here.
Many of the members have lived experience reentering the community. They help other women with reentry, and they stood outside today in the cold, in the rain, after working for 10 years to get this facility built. This committee has already done the hard work back in 2020. And then again in 2021 with the veto override. The very next year in 2022, as the previous administration was violating the law by not moving the project forward, the legislature passed another bill authorizing $1.2 billion for upgrades to the Orioles and Ravens stadiums. Those renovations are already underway, and the current phase of the project includes a number of upgrades, including a new Jumbotron screen at a cost of $135 million. That's more than what the Women's Pre-Release Center is projected to cost, and the fact that ground has not yet broken on this project is shameful. All the while we're seeing these new Jumbotron screens go up in these stadiums. But I want to give some credit to Governor Moore and his administration. After this bill failed to pass last session, they picked up the ball and have taken some steps forward. But we need to ensure that it moves forward in the right way, and we urge you to work with the Pre-Release Coalition on the amendments to get the site and facility specifications right. The delays are not your fault, but I urge you to keep the promise to these women. They have served their time and are ready to write the new chapter in their lives. Please give them the best chance possible by passing passing House Bill 935 with the coalition's amendments. Thank you.
Thank you. You may proceed.
Thank you. Good evening, Vice Chair Davis and members of the Judiciary Committee. I'm Beth Tomasello, past president of the Montgomery County Women's Democratic Club and executive member of the Women's Pre-Release Equity Coalition since 2019. WDC strongly supports HB 935 with the coalition's amendments, and we thank Delegate Crutchfield for her leadership on this bill. The Maryland Equal Rights Amendment states, equality of rights under the law shall not be abridged or denied because of sex. But since DPSCS closed the one pre-release center for women in late 2009, Maryland's incarcerated women, unlike their male counterparts, have been denied pre-release services because they are housed in a maximum security prison. This blatant ongoing sex discrimination will not end until DPSCS follows the mandates of the Gender Responsive Pre-Release Act of 2021 and builds the Women's Pre-Release Center in Baltimore as required. For 16 years, women who have served their sentences have been released without job training, skills and employment, without an opportunity for family visitation and healthy reunification, and without the chance to relearn vital life skills needed to navigate current daily life successfully. This is not good for the women, their children, or our communities. And a comment by staff members at a men's unit that they have trouble keeping their work release employers because they permanently hire their work release employees upon release is telling. The vast majority of women work at Maryland Correctional Enterprises on the MCIW campus, and therefore they don't have that problem. And I think there is a big distinction between what the services the men are getting and what the women are getting. DPSCS has delayed and evaded the law's clear mandate with only increases in capital costs to show for it. DPSCS does not even plan to begin construction until FY 2031, 10 years after the Gender Responsive Pre-Release Act was enacted by a legislative supermajority and 21 years after the prior Women's Pre-Release Center was closed. Yet to save money, it has proposed building this facility on a lot that is too small and with inadequate bed capacity in the unsafe drug-trafficked Baltimore pretrial and detention center complex. This is simply unacceptable. Well, can I just finish? DPSCS must build a satisfactory facility in a safe location without further delay. We ask this committee to step in once again to make this mandate crystal clear. HB 935 is emergency legislation that will deliver that mandate. Thank you for your consideration and your steadfast support of women's pre-release.
Thank you. Next.
Good evening, Vice Chair, members of the committee. My name is Matan Zemmer. I'm the Maryland Policy Director at Jews United for Justice, which is a longtime member of the coalition. Personally, I've been working on this issue alongside the coalition leaders for years and previously as a legislative staffer. And I'm sort of throwing my remarks to the side. JUFJ has been working on this issue driven by our Jewish values that everyone needs to be treated with dignity. And this issue strikes to the core of that. And I won't speak to what folks have already said because I couldn't agree more. I'll also point to the coalition's written testimony for the amendments that we've suggested. But I just want to say that the legislature has done an incredible thing by passing this legislation in 2021, by continuing to move this forward year after year. So this is just another iteration of that. We wish we didn't have to be here. I'm sure you all wish that as well. But at the core of this, Maryland has the opportunity to be a leader in this space. This project, the Women's Pre-Release Center, represents an opportunity to lead the nation in showing what effective gender-responsive pre-release services can look like. And this bill works to clarify that so that we are on the leading edge of that, to give folks a pathway forward, both women who are incarcerated in Maryland and returning to their communities, but also this represents an opportunity to make an example that then other states can follow as well. We have been behind for far too many years as a state. We've been in violation of the law because of that. And this is an opportunity to correct that for years to come. So I hope that this committee will take action once again. And we look forward to working with the legislature and with the agencies to make this the best possible future for incarcerated women in Maryland. Thank you.
Thank you. This is the favorable with amendment panel. Are there any questions? Delegate McComas.
I just kind of have a couple questions. One, in other words, there's a requirement that it be located near the penitentiary for the pre-release center.
No.
No, it's no longer required?
It was never required. No, it was just required to be located in or adjacent to the zip codes, and this would be Baltimore City, where the most number of women were being released.
Okay. But, so.
In fact, we don't want it near the prison complex.
Okay, so you don't, okay. But the thing is there 3 acres? You need 3 acres at a minimum, right? Is there 3 acres that it would be available in Baltimore City that's not near a drug-infested area or a bad area that there's problems, you know?
We believe
crime?
so. In fact, DGS found such a site, and to save money, the Department of Budget and Management said, no, you can't build there.
The DGS said you can't build there?
No, the Department of Budget and Management said, find a site that's already owned by the Department of Public Safety and Correctional Services.
So is there a site that you can use?
Well,
that they want,
on the
or
buy
that they
into,
approve of?
well, into the Buy Into Be More website for the city of Baltimore that lists all the properties available from the city and private owners. There are, last time I checked, 211 sites of 3 to 5 acres.
So have you found some that you think are good for this project?
I drove some. I don't live in Baltimore, so I would rely on the Baltimoreans.
Delegate
to tell me,
McComas.
But they were
Delegate
there.
McComas, could you pull your mic closer?
Oh, I'm sorry.
They're having
I'm sorry.
problems hearing you.
I guess what I'm just saying is this almost seems like this might be another big delay because you're dealing with the government. I mean, you know, and trying to find something that everybody can agree on.
We are completely open and willing to work with the Department of General Services to find a site. We would go anywhere to look at any site and willing to talk with them. And we actually hope this time this will be a collaborative process between all the stakeholders.
And yes, we do believe that there are sites that can be found that will be in line with the intent of the bill and for the outcomes for women.
So it will be safe and it will be good for, and it'll be, so that people can go to different jobs and get the training. Okay.
Yes.
And I believe everyone involved has the same goal there. So.
Yes.
It's just taken a long time, though.
Absolutely,
Yes, it
absolutely.
has.
We agree.
Thank you. Thank you.
Thank you. This concludes the favorable with amendments.
Thank you all so much.
There's no opposition, so this concludes the hearing on, wait, hold on, somebody make a noise? Hold on, give me a second. There are information, okay, so Jason Davidson, are you all gonna testify? Jason Davidson, Amanda Cram, Ellen Rappaport, and Joe Sedolph. It's a lot of information.
Thank you, Madam Chair.
Okay, thank you.
Good evening, Madam Chair and members of the committee. For the record, my name is Jason Davidson, Director of Government and Legislative Affairs for DPSCS. And for the record, to Ms. Cooper, we are proud to be your friends as well. So, thank you. You have my written testimony. I just wanted to address a few items regarding this issue. We very much appreciate the sponsor's intent to codify in statute gender-responsive programming and services for our women in pre-release. We're currently providing comprehensive gender-responsive programming tailored to meet the specific needs of all incarcerated women at MCIW, and specifically the incarcerated women housed on the pre-release unit have the opportunity to participate in gender-responsive programming exclusively dedicated to them. Our Director of Social Work, Amanda Cram, is here, and we have our Executive Director of Reentry Services, Ellen Rappaport, also here as well, and they can speak to the programming here right after me. I would also like to clarify, we do not have any standalone pre-release facilities for men. They are housed with minimum security incarcerated individuals in minimum security facilities. The pre-release facility that will be built will be the only standalone pre-release facility the state will have, and only for women. The incarcerated women classified as pre-release have a dedicated housing unit, and men in pre-release status are housed in one of our 5 minimum security correctional facilities. Our Deputy Secretary of Operations, David Green, is here with us today. If you have any questions in comparison to the men versus the women, he can absolutely get into the weeds of that for you. And lastly, we just wanted to provide this information to you, and we're here to answer any questions.
Okay, thank you. Delegate Arkin.
Thank you, Madam Chair. Thanks for being here, guys. We always appreciate seeing you. Can you just remind me, I was trying to look up the original bill. I found the bill number, but for some reason, it doesn't say that it was passed in 2020, not on the House or the Senate bill. What am I doing wrong?
There's a veto override in 2021.
It was, but this one says it only had a first reading. What do you know the bill number by any chance? Okay. Okay. Oh, eight.
SB 864.
Okay, that's why I got confused. Okay, I'm trying to look up the history of it, and I'm like, what's happening here? Okay, I appreciate that, and hopefully we can come to, it's still wrong on mine. I'm gonna fight with this thing later, don't you worry. I appreciate you guys coming to the table, though, and hopefully we can come to some kind of appropriate conclusion speedily. And we'll get it back in the budget, I hope.
Okay, thank you so much. That concludes the hearing on HB 935. Thank you.
Do you want?
They weren't testifying, they were giving information. Is there more information you'd like to give each of
We're
you?
fine.
Next time you guys need to sign up as testifying.
Okay.
I mean, I know, I'm not gonna shut it down, please. Please go ahead, but if you're gonna testify, you need to testify.
I'm sorry, I know everybody wants to go home. Good evening, Madam Chair and members of the committee. My name is Amanda Cram. I'm Director of Social Work for the Department of Public Safety and Correctional Services, and here to provide information on House Bill 935. First, I would like to draw attention to the important point that pre-release is a security classification, not an amount of time left on a sentence. In fiscal year 25, 156 women were released from MCIW who were classified as maximum, medium, and minimum security. Only 85 women who were classified as pre-release. In 2020, Secretary Scruggs, then Assistant Secretary of Programs, Treatment, and Reentry.
You can slow down, honey. I'm sorry.
You can slow
down. You can slow down.
Started the process of implementing the Project Fresh Reentry Unit. All pre-release individuals are now housed on one unit, given special privileges and intensive programming with the aim of building a community of women, all working towards a common goal, successful reentry back into the community. All programming on the Project Fresh unit is gender responsive and trauma informed. The social work and reentry teams at MCIW provide individual assessments to better understand each person's goals, needs, community supports, and resources, which allow us to tailor our programming and reentry support to the unique needs of each individual and group. For those of you who attended MCIW tours, you may have noticed that there are a number of individuals who identify as male. And part of being gender responsive is meeting the needs of all unique individuals at the institution. Programming at MCIW is provided both through social workers and community volunteers, and a full list is in the JCR report that was submitted to the budget committees. Having Project Fresh on the main compound of MCIW allows the women classified at higher security levels who are nearing release to access additional programming available to the pre-release population. In addition, it's important for the women on the pre-release unit to have the mentorship of the individuals who have served longer incarcerations. These peer relationships are one of the most valuable tools to assist people in moving through the stages of change, and many times the individuals who have been incarcerated long-term bring stability, perspective, and mentorship. It's an important ecosystem that exists at MCIW. With the Juvenile Restoration Act, Second Look Act, and Geriatric and Medical Parole Bill that was passed last year, we will continue to see more women of higher security levels who need access to reentry services. Thank you for allowing me to provide this valuable information. I'm happy to answer any questions.
Thank you. And you, sir?
Good evening. For the record, my name is Joe Sedatal. I am the Deputy Secretary for the Department of General Services. I really just wanted to be here to make myself available for any questions that you might have so that public safety wasn't up here all by themselves.
I'm going to turn it over to the chair, but before I do, Delegate Taylor.
Thank you, Madam Chair. Thank you, Madam Chair, and welcome back, Madam Chair. I think my question would be for DGS in terms of the funding. There was a question for the first panel about how much money is spent so far. So how much have we invested so far in on the current project?
At this time, we've spent around $350,000 on the initial programming stage.
Okay, and thank you for that. And so there's
there was 9 million, I think, that was appropriated though, but we spent 350.
Sure, yes, Delegate, I could speak to that. The 9.25 million was to be spent for the design phase of the LSRCW project, referred to as the life skills. Oh my God, I'm sorry, I'm acronym heavy, but okay. And since DGS and DPSCS have initiated a temporary pause to the project due to the concerns of the site location from the coalition, DBM has shifted those funds to the fiscal 28 capital budget in anticipation that the site location will have been resolved and ready to move forward with the design phase.
Got it, that's great. And you teed up my next question, which has to do with the location.
Yes, ma'am.
So I know there were significant, well, there were several locations that were reviewed, or, you know, there were several options. One, how did you pick the location that you selected and why? And I know after you tell me that, there were significant issues with that location that the advocates have brought up repeatedly over the years. Why wasn't the location that they prefer a part of the equation?
Sure, I'm going to turn it over to my colleague at DGS, since they have the capital construction agency for the state and the lead, as we are working closely with them.
Yes, ma'am, that's a great question. So the initial kind of run of scale, we narrowed it down to around 14 or 16 different properties. And that was like the initial cut of this. We then evaluated it down to 3, and this is based on the parameters of the law itself that's currently enacted, as well as I believe there were some different parameters that were attached from the previous Secretary of Public Safety, such as location to transit, correct? Right? So a handful of other things. And we had identified 3 sites. One of them was 717, and there were 2 locations that were Baltimore City public schools. We reached out, and at both instances, the 2 public schools were not available for surplus by Baltimore City at the time. They did not intend to release them or close those schools when we were making that decision.
One of the public schools, and remind me, I'm fuzzy on.
There were 2 schools, and one is 717, which is where the location is currently planned for, right across from the other facilities.
Okay. Are you aware that the advocates have a location that's preferable? Is that something that you?
There's been some communication, I believe, and I know and forgive me, I don't have the bill in front of me, but I believe the existing legislation before us right now does include a provision to reevaluate any locations that we've previously looked at to see if they're still available and what that would look like. Obviously, any conversation about that requires whether an acquisition would have to occur, right? If it's not state-owned land, then we would have to go through the process of acquiring the property.
Right, and forgive me for being, can I ask another question? Okay. Okay.
Am I doing okay?
I gotta keep looking this way. I gotta look back and forth. So we are, you know, we're at this point, which I know has been a couple of years since we've been talking about this, if not more than a couple. Have you done sort of that reevaluation already, just to see what it would cost and about, you know, if we did make a shift in the location?
So we've done some preliminary research, just because we've had conversations with the coalition and advocates to kind of see what's out there. Unfortunately, with the real estate market, as you can imagine, you know, these things change on a regular basis. And when you're looking at pending legislation, you have to try to assume what the parameters are going to be based on that legislation, right? So we've done some initial diving on this, but we haven't gotten to the point of saying, hey, is this available and what does that acquisition look like?
Okay, thank you.
Philip?
Thank you, Madam Chair. Real simple question. Do you now have a longer-term budget number for what this may cost the state?
Me again?
Yeah.
So the project is currently budgeted at $108 million, right? It's very hard to say what a number would look like without going into all of that in-depth analysis, such as what would be the cost of acquisition, right? If you're going to the private market, a property might be, you know, $1 million, $1, $5 million, and we don't know that right now, right? Furthermore, legislation before us today does include, I believe it's an increase in overall bed count from what had previously been designed. One of the things that DGS always tries to do is move swiftly and try to do creative things such as alternative procurement methods, working on different parallel paths to try to gain efficiencies, both financially and from a timeline perspective. But I think at this point, we're kind of too early in the stage to really be able to project out any sort of firm number, and I would hate to be in a position to try to give you back and napkin math. My handwriting's terrible.
And I missed some of the previous comments. When is the projected date to have the initial study done? The planning piece?
So there was a design contract that we were prepared to go to the Board of Public Works with in the fall, but the DPSCS, DGS, we've taken a pause to really reevaluate this site location. So a lot of it would be dependent on when that site location is determined. But that's where we then start talking about different procurement methods, whether it's a design bid build, which requires you to go out and procure a design contractor, then go out and acquire a construction contractor, or one of the things that we're always looking at, again, with those parallel paths is a design build. Can we hire somebody to do both, and what efficiencies can be gained? But at this point, as Jason said, there's no funding in the FY27 budget. So, but we want to move as quickly as possible and work in partnership with both our sister agency as well as the advocates to make sure that whatever is built gets built as quickly and as efficiently as it possibly can.
Okay. Thank you.
Seeing none, that concludes this panel and the testimony for House Bill 935.
Later to both of you guys.
Oh, thank you so much. Very good to see you. I'm sorry I missed your testimony. Take care. Delegate Phillips, we're going to call up House Bill 16 and House Bill 113. And along with you, Delegate Phillips, I'm going to call up Elizabeth Hilliard, and I see Mr. McKeeson already there. Is Elizabeth Hilliard still here? Oh, there she is. Okay, whenever you're ready, Delegate.
Thank you, Madam Chair. And thank you, Madam Vice Chair, and to the members of the committee. I'm Scott Phillips, delegate for the 10th Legislative District. Under current law, the Maryland Parole Commission consists of 10 full-time commissioners who primarily review the most serious cases, homicide and life sentences. Yet nearly 60% of all parole hearings are conducted by hearing examiners, individuals hired by the Secretary of Public Safety without Senate confirmation. A single examiner may conduct a hearing and issue a recommendation that becomes final if no exception is filed. The structure demands professionalism, balance, and accountability. HB 16 strengthens that structure, and our proposed amendments refine it in 5 critical ways. 1, preserving and professionalizing the hearing examiners. We preserve the role, and these are the amendments, we preserve the role of the hearing examiners while professionalizing future hiring standards. Future examiners would be required to have at least 4-year degrees in psychology, psychiatry, social work, education, or related fields, or have 4 years of relevant work experience or training in similar disciplines. This does not impact examiners, and hiring discretion remains with the Secretary of Corrections. Additionally, no more than 30% of future hearing examiners would be individuals with prior correctional services. We think it's important to have a variety of individuals in that position. So there would be no more than 30% correctional services or law enforcement employment experience. Research indicates that approximately 8 of 10 current examiners with known public employment histories are former DPSCS employees. A broader professional perspective strengthens parole decision-making. Number 2, expanding the commission scope. HB 16 expands the cases heard by the commissioners to include individuals serving sentences of 15 years or more, not solely life sentences. An expanded commission should be empowered to review a wider range of serious cases. 3, addressing commission vacancies. These amendments would require the recommendation panel to submit candidates and a commissioner to be appointed within 90 days of vacancy opening. Persistent vacancies, slow hearings, and reduce access to parole. Timeliness restores operational stability. 4, there would be representation on the recommendation panel. This bill adds 2 members to the recommendation panel, 1 individual formerly incarcerated in a Maryland prison and 1 immediate relative of a formerly or currently incarcerated individual. And I have a couple of others. 5, updating the commission's voting standards. I'll speak a little bit more to this if asked a question. Thank you.
Hello, I'm Doreen McKesson. I'm the Executive Director of Campaign Zero, a social justice organization focused on ending mass incarceration and police violence. We did a national analysis of all the parole systems, all the states that currently have parole and the 17 states that do not have active parole, and support these recommendations. I won't repeat what Delegate Phillips said, but I will remind us that the way the law that was written is that parole commissioners only hold the hearings for people who were convicted of murder or who have a life sentence, and hearing examiners do the rest of the hearings. So you are more likely to get a hearing actually by a hearing examiner in the state of Maryland and not actually a parole commissioner. The hearing examiners do the hearing, they write it up and send it to the parole commissioner. So most people will never have the experience of actually being in front of the person making the ultimate decision about their parole status. What this bill does is actually provide some sense of requirements for that role. Today, there are really none besides being an adult. And when we look at the qualifications, most of the people, 8 of the people, there are only 2 people that we can't find any work history on. Everybody who we could find work history on who isn't a hearing examiner is a former employee of the Department of Corrections. We don't believe it was the intent of the parole process to just take employees of the Department of Corrections and make them the decision makers about parole. The question before us was who should be a part of the process to determine if somebody is ready to return to society. And we think that there should be a range of people involved in that, including law enforcement, including corrections, but importantly, including other people. The bill would also include, for the first time, people who are convicted of who are sentenced to more than 15 years. They would also be heard by parole commissioners. It would only broaden the scope around 1,500 people in a given year, but it would balance it out more so more people will be likely to be in front of a parole commissioner and not have their case only heard by a hearing examiner. And the last thing I'll focus on is that it will have a stipulation for hearing examiners that no more than 30% of the body of hearing examiners, which there is no cap on in the law, will not be corrections or law enforcement employees.
Thank you. Good evening. Welcome back, Madam Chair, Vice Chair. Members of the committee, Elizabeth Hilliard with the Office of the Public Defender. We'd like to thank Delegate Phillips for bringing this bill, and we particularly urge a favorable report with the amendments that the delegate has articulated. I personally, when I worked in the post-conviction division, worked on parole revocations. Our parole commissioners are tasked with incredibly difficult and important decisions every day. They are sometimes deciding whether to revoke someone's sentence for the rest of their life. Because we are entrusting them with such incredibly important decisions, we need to make sure that they are being appointed and taking their role from individuals with recommendations from individuals who have lived experience, and that we are also ensuring that there is a transparent and accessible way to understand how they are being appointed. So we are extremely, extremely glad to see the amendments to include a formerly incarcerated individual on the recommendation panel and a family member of a formerly or currently incarcerated individual, as well as seeing that there are going to be some guardrails put in place surrounding the hearing examiners and the requirements that will be imposed on them. And we urge a favorable report and are happy to answer any questions.
Thank you. I see that we've got more folks. We've got Alinda Moyd, and we've got Ann Pack. Favorable with amendment, correct?
That's correct.
Okay, whenever you're ready.
Good evening, Chairman Bartlett and Vice Chair, and of course my delegate, Kim Taylor, and the rest of the committee members. My name is Olinda Moyd, and I'm testifying on behalf of the Maryland Alliance for Justice Reform. Paroling authorities wield great power. As I said in my previous testimony, the Maryland Parole Commission, who I have practiced in front of for years, certainly needs significant reformation. I've represented individuals not just before the Maryland Parole Commission, but also before the Federal Parole Commission, before the DC local paroling authorities. I have also written and been published on why it's important for parole decision makers to look like the communities that they serve in order to avoid racial inequities. I do believe that the creation of a nomination panel is really critical. The system that we have set up right now, you've heard what our parole commission has historically looked like. I've gone before parole commissioners, most of them with law enforcement backgrounds, most of them with correctional backgrounds. I've walked out of so many hearings and wondered, how did this person ever get in a position where they are making a decision about the life of someone else? Chairman Ely, if he were here, he would say that, and he has said to me recently, Olinda, the current composition of the commissioners is more diverse than it's ever been, and that's correct. But the creation of a panel will ensure that long after his tenure, that will continue to be the case. One amendment that I would like to highlight that we differ with the sponsor is the creation of who should serve on the panel. We believe that it should be one incarcerated person that represents a woman who has been incarcerated, one formerly incarcerated person who represents a male perspective and a loved one. We do not believe that a woman should be excluded from being silenced and not heard in the panel selection process. Thank you.
Thank you, Mrs. Pack.
Thank you. Ann Pack, co-founder and director of advocacy for Prepare. And I will say this bill has come a long way, and with the amendments that the delegate has put forth today, we have really made some very excellent progress. We're looking at impacted voices. I agree with Olinda that we do need to include female formerly incarcerated voices. We have hearing officers with education or experience, allowing people from more diverse backgrounds, not just DPSCS people who are moving up the ranks, but people that have a diversity of experience that gives us a real 360 view and a more balanced commission and a more balanced group of hearing officers. Correction to change it from needing 6 affirmative votes, as it says now, to needing the majority of the commission, so that commission number can change, but we'll always need the majority. That's kind of technical, but I think that's really important. And the expansion of the panel. The one point where I still have a large concern, we were down, and when we were doing the work in MEJC that I've talked to you about before, we got down at one point to 6 commissioners instead of 10. It dwindled. There was a 2-year period where a seat sat vacant between 2023 and 2025, and that's only very recently been rectified. And when that happens, that slows down revocation hearings, and those people have due process rights. That slows down life sentence parole processes, and we're adding more people, right? We're taking these 15-year non-aggregated sentences, and even more people are going to be heard by commissioners. So if we get down to 6, this is critical. I like that the 90 days is an ambitious goal. I don't think it's a goal that we can hit because the training alone to become a commissioner is more than 90 days. And I think we need a guardrail. So there's an amendment here. If a vacancy exists on the commission, that the secretary shall appoint a hearing examiner to act as interim within 30 days. I would say 15. We need that guardrail in order for this to function, or the seats could sit vacant for 2 years while hearings pile up.
Thank you. Members, do we have any questions? Delegate Woods.
Thank you, Delegate Phillips, for this legislation. I just have one quick question. You said in your testimony that you would preserve the role of the current commissioners, but that's
The current examiners.
the current I said commissioners, excuse me, current examiners, but that's not actually written in the legislation. How can we assure that?
So we do have an amendment. The amendment is being drafted to go through those 5 different amendments that I discussed. And so that would be a certainty.
Okay, thank you. Thank you, Madam Chair.
And let me say, we really worked hard. We've spent time with the hearing examiners. I think I talked to about 7 out of 10 of the hearing examiners just to hear their point of view. We've met with the ACLU. We really have tried to look at this 360 to figure out what makes sense. And I want to say kind of what started all of this for me. Mr. McKesson started it, but then we started looking at the numbers, and I began looking at the DPSCS, their own numbers in terms of the numbers of hearings, the numbers of opportunities, the numbers of individuals that were actually receiving parole. And over about a 4 to 5 year period, particularly prior to and after COVID, the numbers of individuals that were getting their hearings continued to go down. And so you begin to ask the question, why? And there were a number of reasons why, but one of the reasons were just addressed, right? We were down, and there were no appointments of of parole commissioners for an extended period of time. I believe you put this in the hands of the governor and a nominating commission, and they submit those names, similar to as what we do with judges. We don't have judges' positions open for years. It just doesn't happen. And so it's a similar concept, in my opinion.
Thank you so much. Thank you, Madam Chair.
Delegate Simmons.
Thank you, Madam Chair, and thank you, panel. Delegate, can you explain a little bit, number one, about the fiscal note, and as well as that expansion from that 10 to 20, 15, 20 commissioners, and what does that look like and the purpose behind it?
Yeah, so there is going to be a fiscal note, right? But I believe there's a significant offset on that fiscal note. Because if you think about it, if you are able to do more hearings and more people are eligible for parole, think about it at approximately $60,000 to $70,000 per person. Doesn't take much to address the fiscal note.
All right, thank you.
Go right ahead.
And just when we look at the fiscal note, there was some confusion on the fiscal note between this bill and Delegate Embry's bill, because the fiscal note for this bill includes some of the provisions of Delegate Embry's for some reason. But when we look at the numbers, there are a lot of questions about how many hearings even happen. So in the fiscal note for Delegate Embry's bill, it says that there are 4,800 hearings that happen every year. We submitted this as backup, but every time we FOIA the department to ask how many hearings happen a year, we get a different number. The 2025 numbers are not public, and the 2024 report has been pulled from the website. So there is an open question generally about the number of hearings, and there's been a conversation about a backlog that the department also cannot quantify. So we believe that there's a backlog. People have experienced a backlog, but we have tried to work alongside the department to have numbers that we all could understand, which is why Delegate Embry's bill with the annual report will be powerful, but the fiscal note does have numbers that we have never seen before.
And it's really difficult to verify. Let me just say this. We actually sat down with the Assistant Secretary of DPSCS, who is responsible for data, and they just acknowledged that they are really attempting to clean it up. So any numbers that we have before us, I think, are challenged in and of themselves.
Obviously. All right, thank you.
Members, are there any other questions? Seeing none, that concludes this panel for House Bill 16. We're going to move on, if we have anyone, let's see. John Sexton, are you still here? Oh, you're
And
still
can
here.
I say, Madam Chair, that this bill did pass
I'm sorry.
last year? Can I just say that this bill did pass last year?
Yes,
Just a reminder.
thank you. John Sexton, Dar Johnson.
You have Gordon Pack on this as well?
I did have you, but I have you crossed out for some reason. So why don't you come on up?
We don't want to cross Gordon out.
I know, I don't know. I want to hear your testimony. All right, so however you all want to start, works for me.
Yes. I will start because I hopefully will keep it brief. My name is Dar Johnson. I'm an associate staff attorney with the ACLU of Maryland, and we are in support of this bill as amended. These amendments do reflect changes that were a part of the joint proposal that's attached to our written testimony that was developed in collaboration with the Office of the Public Defender, Prepare, the Maryland Alliance for Justice Reform, and the Center for Criminal Justice Reform at the University of Baltimore Law School. And I will not reiterate all of those proposed amendments because I said they do align with what's been raised today. Apart from what other supporters have mentioned with having an incarcerated person who was formerly incarcerated at the Maryland Correctional Institute for Women, and then other provisions that we think would help to better address the issues happening here. And lastly, I'll just note that we, at the ACLU, we do have just a general concern about one of the updates that revises the commission voting process, specifically for those with life sentences, basically because we maintain the position that people released after serving life are among those with the lowest risk of recidivism and should not be subject to any different parole process. So with this in mind, we urge a favorable report on this bill if amended, and I'm definitely open to any questions you all may have.
Madam Vice Chair, committee members, thank you. I'm going to be real brief. Delegate Phillips should be commended. He's taken in a whole lot of information from a whole lot of different sources and has tried to do the right thing and make this bill as best as it can be. I think there might be a few more things to do, but I think he's making such a Herculean effort to get this done. I think he should be commended for that. Very quickly, I want to reiterate something that he said about the fiscal note. He is absolutely correct. The system is chock full of people that are backlogged that cannot get out. A lot of them are old people, geriatric people that cannot get out the door because the process isn't going. And I want to make something else clear. It's not because of the current people that are there. I know there's been a lot made about DPS employees being circulated there, but since Ely's gotten there, he's made a lot of effort, a lot of progress in trying to move this ball forward. There's a backlog that was created decades ago by Glenn Denning, and it's been in the ditch ever since, and he's just now getting to get it out, and this bill will help him do that. I would add, though, that I want to reiterate what Ann Boucher said. She said about the fulfillment of a commissioner. If a commissioner is vacant, it should be able to be filled instantaneously, at least during an interim. There should be a means of an interim appointment to that post. It's critical that that happens. The commissioners do a whole lot of work, and when you get down several of them, particularly if 3 or 4 go at the same time or about the same time, it gets a little crazy. Lastly, I want to make a note is the thing about the appointment panel, picking people, that's great, that's fine. But when the governor has to appoint those people, the governor has to believe in what he's doing too. And then in the past, I've seen governors that don't believe in that, and he puts people on the parole commission or on boards that doesn't even believe in parole. So you have to be careful about that. I think you should have a standard and say what that standard is about who the person is that you want to fill that vacancy. Thank you.
Mr. Pack?
All right, Gordon Pack, and I appreciate this opportunity, and I'm not going to take up a whole lot of time here because I'm tired too. I had the great fortune and blessing of being the chair of a committee under the Maryland Equitable Justice Collaborative, whose sole purpose was to improve the parole scheme in Maryland as a means of decarceration. I've had the opportunity to work with the leaders involved in this particular area, the Parole Commission, the Department of Parole and Probation, DPS, different heads, clinical law firms, attorneys, professors. And what we came up in the discussion is a lot of things that's taking place in this bill. I do support the bill, and I want everybody to vote favorably with the bill, but with the amendments that were mentioned. But I also have to put this caveat there is that my concern is that 90 days may not be enough time to fill a vacancy for a commission. Realistically, it's like saying that I can get from here to Baltimore in the next 30 minutes. It might say that, but you got traffic and all this stuff, I might not make it there. So in reality, when we're looking at this, we have to look at realistically what it takes to get this done. So if we're going to have a committee to appoint and look at people and make recommendations to the governor, that may take 90 days. By the time the governor responds, that might take a little more than 90 days. By the time the person gets in the seat. So realistically, I think that we need to look at how we can retain those who are doing an effective job, which means that we have to look at also records, what they're doing, make judgments based on performances. But I also believe that it means that we have to make sure we have people on board, because in 4 years from now, it may be a whole new cycle where we have this big lapse of 3 people, 4 people missing from the Parole Commission. And when you have an influx of people coming in, that takes time too, because they have to be trained. So we need to look at how we can do this in an effective manner where we can keep the commission fully functioned and they can operate as best as they can. Thank you for your time.
Thank you. Members, do we have any questions? Seeing none, that concludes this panel, and it concludes our bill hearing for House Bill 16. We're going to move on to Delegate Phillips, House Bill 113. And Delegate Phillips, I'm just going to start calling names. Jamie Grace Alexander, Jessica Emerson, Christopher Sweeney, Christopher Dews. I think that's about as far as I can go. Yep. We can usually fit 6, so you got to just go kind of tight.
We can tighten up.
Tighten up. Got it, okay.
As we're getting settled in, Madam Speaker, I'll go ahead and get started.
Or chair works fine too.
It's been a long day, Madam Chair. It's been a long day. All right. Chair Bartlett, Vice Chair Davis, and to the committee. I'm here today to present House Bill 113, Criminal Procedure Expungement of Records, resisting arrest and making a false statement to a law enforcement officer. Think about this. I'm a young person, and I get stopped by police, and I pull away. I simply pull away. And the police officer says, was I in a particular situation or a particular place? And I say, no, I wasn't there. But at the end of the day, I pulled away, resisting arrest, and I actually was there, false statement. These charges were originally slated to be added to the expungement list under the Governor's Expungement Reform Act of 2025, which passed this committee last year. However, last-minute negotiations had the list of charges reduced in the Senate. We are simply following up this session to have these charges added back in. The reason is that we know, from children to adults, that when people face the fear of potential arrest or loss of liberty, survival instincts kick in. And they may not behave in their best long-term interest. We know that a criminal record has a long-term deleterious effect on employment, housing, and education long after the individual has served their sentence. Once an individual has served their time, in this case, a maximum term of 6 months for a false statement to an officer or 3 years for resisting arrest, they need to be able to properly reacclimate to society. To be clear, if this bill passed and went into effect today, an individual seeking expungement for either of these charges has to complete the entire sentence, including parole, probation, or other forms of mandatory supervision, has to wait an additional 5 years after the completion of the sentence, has to survive potential objections from the state's attorney's office or any possible victims, and can't get the record expunged if there's a subsequent offense during their waiting period. Also, if this is part of a unit of charges and one of the charges isn't eligible for expungement, then these charges wouldn't be eligible for expungement. The most recent data shows that in the last 2 fiscal years, there were roughly 290 convictions for false statements and resisting arrest in Maryland. Again, the passage of this bill would not lead to any decrease in public safety, as there are more than enough safety checks for the expungement of these non-violent misdemeanor charges. For these reasons, I urge a favorable report.
I will go next, my nice little corner office here. So Christopher Dews, representing Out for Justice and the Center for Urban Families, also Life After Release. Just want to say, friendly reminder, these are nonviolent. These specific charges are often used, as Delegate Phillips mentioned, as part of the unit rule, though we understand why the unit rule exists. The idea that these specific nonviolent charges, lying to an officer because you're scared, giving them the wrong name, for example, we just firmly and strongly believe that after an individual has served their time, be it for specifically lying to an officer, is about 6 months, and then also considering the waiting period of an additional 5 years after they have done that, we just strongly believe that they should be able to get that charge expunged. As the delegate said, the world is not going to end on this one. It is the governor's office originally approved it. Negotiations were had in the Senate, and it was taken out of the bill. Can't speak to that specifically, but what we will simply say is that these charges hold a lot of people back. And again, these are nonviolent situations in which an individual gets scared and then just says what they have to say to avoid the loss of liberty. So for those reasons, I urge a favorable report. Happy to answer any questions about the bill. Thank you. Yes, ma'am.
Good evening. My name is Bobby Colick, and I'm a resident of District 45. And I'm here to ask you to support House Bill 113, which would make false statement to a law enforcement officer expungible. 30 years ago, as a teenager, I got pulled over to a minor traffic violation. It was a long time ago, and I can't remember exactly what it was for. It could have been not stopping at a stop sign, or speeding, or not using my turn signal. Because like so many kids, I was scared of getting in trouble. I lied and used my friend's name when the officer pulled me over and asked me for my information. That conviction is so minor, I think we all can agree as a scared teenager lying to an officer and their name shouldn't prevent them from advancing their career for the rest of their life. I know it was a mistake and something that I should not do, and I have been suffering for those 30 years of not being able to get that charge expunged from my record. I've been working at the Center for Urban Families for almost 10 years. I started off as an intern there, progressed to work at the front desk, and I have worked my way all the way up to being a senior grants accountant. On weeknights and Saturdays during tax season, I help run volunteer a VITA site at Center for Urban Families. And where I help hundreds of low-income Marylanders prepare and file their taxes for free. My dream is to get my CPA, which would come with a sizable income increase that would help support me and my family. My record prevents me from doing that. For the sake of me and others like like me, who made dumb mistakes that didn't hurt anyone when they were a dumb teenager, I would ask for a favorable report of House Bill 113.
Thank you. My name is Jamie Grace Alexander, and I'm a paralegal with Baltimore Action Legal Team. BALT is a legal collective formed in response to community calls for legal support during the protests that followed Freddie Gray's murder in 2015. Our direct service work includes warrant recall and expungement, working to emancipate people from the lifelong weight of the criminal justice system. There are lots of reasons why somebody may resist arrest or make a false statement to a police officer, but to me, the most notable reason is fear. When in panic mode, people do anything they can to preserve their life. Arrest is a matter of life and death to many people, as we have seen in unprosecuted murders by police. Often in our expungement work, we see this charge tacked on top of other minor charges for which our client was later exonerated. And in these cases, even though the charges for which they were arrested were proven to be unsubstantiated, their resistance to police arrest will stay with them forever. We can't expunge their record. Police lobbyists will tell you that this charge should follow people and that people who resist arrest are untrustworthy and dangerous, and we plainly disagree. People are scared. There are conditions and guardrails baked into this bill to prevent exacerbating this issue. Making this eligible will not make people suddenly feel free to treat police however they want. Punishment will continue to exist, and this bill doesn't change that. For these reasons, I urge a favorable report on this bill. Thank you.
Good evening, Chair Bartlett, Vice Chair Davis, and members of the committee. Again, my name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which works to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking in those populations put at highest risk of exploitation. I am also here in support of House Bill 113. As you know, the HTPP, we frequently work with survivors of human trafficking who have been forced to commit criminal acts by their traffickers. One of the most common ways that perpetrators both insulate themselves against detection by law enforcement and detach their victims from their former straight identities is by forcing their victims to use aliases. This commonly results in charges for making a false statement to a law enforcement officer, which is not eligible for expungement. Additionally, our clients have universally experienced trauma, regardless of whether that trauma is from trafficking or not. As a result, many of them have resisting arrest charges on their record, which, as you've heard from my fellow panelists, is typically linked to a fear response that comes in reaction to being locked up. When any human being is faced with an experience that is perceived as being life-threatening, an uncontrollable physiological response occurs in which the individual will attempt to either fight, flight, freeze, or fawn their way out of the situation in an attempt to survive it. In individuals who have experienced chronic trauma, however, like the majority of HTPP clients have, their quote-unquote survival radar becomes far too sensitive, and they often perceive a life-threatening situation where there is none, causing them to react in a far more extreme manner than the situation warrants. So while being arrested is indeed a frightening experience for anyone, for people who have experienced chronic trauma, it can be perceived as far more dangerous than that, causing them to fight back as if their lives were in danger, even if in actuality they were not. Therefore, the inclusion of these three stigmatizing convictions in the expungement statute would be a life-saving opportunity for criminalized survivors as they try to move on with their lives after significant violence and trauma. For these reasons, the Human Trafficking Prevention Project supports House Bill 113 and respectfully urges a favorable report. Thank you.
Good evening, Madam Chair, Vice Chair, and the rest of the committee. I appreciate your time today. Again, my name is Chris Sweeney. I'm with Maryland Volunteer Lawyer Service. I'm the managing attorney for our Workforce Development Project, and we work with returning citizens who are enrolled in job training programs to help remove barriers to employment. And through that position, I've represented over 1,000 people seeking criminal record expungement, and I can speak from personal experience that
again, as you've heard a lot today, the personal, economic, and societal impact of letting people remove criminal records after they've already served their time cannot be overstated. Living with a permanent criminal record for a misdemeanor conviction is an unjust burden that indefinitely punishes people who are seeking to better their situation. Far too often, I've met with clients who have a case on their record where resisting arrest is the only conviction in that case. They were charged with several other things. They were only convicted of resisting arrest. So just pause and think about that for a second. You are guilty of resisting arrest, but you are not guilty for the alleged crimes that led to you being arrested in the first place. And then that case will be on your record for the rest of your life, preventing you from getting employment. I know that these charges might cause some concern because it deals with behavior that's directed at law enforcement. But frankly, I think moralizing over the nuances of these misdemeanor offenses is missing the forest for the trees when it comes to the purpose of expungement. These are people who have served their entire sentence and then gone an additional 5 years with no new convictions. Expungement is about giving people another chance. Expungement means believing that people deserve a chance to prove that they're better than their lowest moment. Expunging these cases is not a matter of public safety, it's a matter of justice for those people. So I appreciate your time. I urge a favorable report.
Thank you. And I will say, Ms. Emerson, I was just saying the other day that I hadn't seen you this session, so it's very good to see you.
Great to see you.
Members, do we have any questions? Delegate Conaway.
Oh, thank you, Chair. I just lost what I had my cursor on all this time. But thank you, Delegate and panel, for coming out to testify. Delegate, so in your example, just as an academic type of thing, the person gets pulled over and they pull off, and then they get the resisting arrest charge?
Potentially.
Because being pulled over was part of the investigation, or, in other words, they weren't Mirandized, so they don't really know that they're under arrest. They know that they're just trying to flee from this
So once I've pulled you over,
yes,
I gotta think this one through, and I may be wrong. I need some criminal law experts in here. But once I've pulled you over, and then you pull away, and then so you're stopped, and you leave without the permission of the police officer. The police officer then pursues you, stops you again.
Oh, that's the...
Right? At that point, he can then say, well, now I'm charging you, right, for leaving the scene, and tack on resisting arrest. I would think yes.
Okay, the reason why I was asking, I was thinking about a person that was walking, and we used to have the cannabis citation
docket.
Yes, where you could tell the law enforcement that your name was Mickey Mouse, and they'd give you the $40 ticket, and you keep going so you wouldn't get arrested for that. So I was wondering what's the...
That's a false statement.
I understand that, and we had the citation where even if you gave the false statement, all they could do is give you the citation, and you owed the $40 charge. You remember that? That was on the cannabis, before we legalized the cannabis. So that was a false statement. But anyway, so in the testimony in the bill, it was something about how somebody testified that if you gave the false statement to law enforcement, it was such a terrible thing. Would you agree that that's terrible? Okay, well, let's take you off the spot. So since you've been on committee, have you heard that it's okay for law enforcement to lie to juveniles when they interrogate them?
Yeah.
So how is it okay for someone to lie to me and I can't lie back to them? Or isn't that so?
I like your logic. I like your logic.
Thank you, Delegate.
I like your logic, Delegate.
No, that's a vote for his bill.
Is it?
Oh, Lord. That's a bill for next session. It's not what this one's about.
I know where he's going.
And here I thought, Delegate Conaway,
yes.
I thought your question was going to be and I have you as Ms. Lewis, Bobby Lewis?
Yes.
Yeah, okay. I thought your question was going to be, what age, you said you were when you were charged?
19.
19?
Yes.
Okay. I thought you were going to ask, at what age do we teach young people
God.
not that lying to a police officer is a crime? I thought that's what you were going to ask. And it's a rhetorical question somewhat, because we don't. We don't teach children that lying to a police officer is a crime.
Well, now I teach my children that.
Well, yes.
Yeah,
So that's where I thought you were going.
Thank you, Chair.
Yep, you're welcome. All righty. Members, do we have any other questions? All right. Thank you very much for this panel.
Thank you.
That concludes our bill. No, I have, is Mr. McDonald virtual? Yes. Could you bring him in? And is Matt Parsons available?
Matt Parsons is not present.
Thank you.
Yes, sir.
Matt Parsons available?
Matt Parsons is not present.
Thank you. Okay, Mr. McDonald, you will need to mute your YouTube, please. Thank you, and then whenever you're ready, you may begin.
Okay, thank you. I'm Stephen McDonald from Charles County, District 28. I'm favorable with amendments to add criminal charge 56701D4. I've testified on multiple bills today simply because my charge should be eligible for expungement, but it's not. The governor's bill last year originally had my charge on it, but it was removed last minute. My charge is under section 5701D4. I'm simply want this issue addressed because, again, my charge is eligible for expungement in other statutes, section 5601 and 8610, but it's not in 5701D4. It's the same conduct, altering and counterfeiting prescriptions. My charge is a lesser offense than the existing charges are that are eligible now. I urge a favorable report.
Thank you, Mr. McDonald. Do we have any questions, members? Okay, seeing none, thank you and have a good evening. That concludes our bill hearing for, House Bill 113. I'm going to move on now to Delegate Moon for the last two bills of the evening. And Delegate Moon, I'd like to call House Bill 360 first, if you have your witnesses here, if they are available. This has the largest, members. Yep, members, I just want to let everyone know, members, that we have quite a few witnesses on this bill, and we're going to try to go quickly because after this, we have a very short bill hearing. So we're going to call up Grayson Wiggins, Nan Gibson, Shaheem Washington, and Ryan Ewing.
We got 6.
And don't worry, okay. So Shaheem Washington?
Yes.
Okay. We've got Ryan Ewing. I see Ms. Emerson, Nan Gibson, and I don't see, Grayson Wiggins. Okay, great. All righty. So whenever you all are ready, we're ready to hear from you. Thank you, Delegate.
All right. Thank you, Madam Chair. House Bill 360 is the Clean Slate Act. It is a bill that you could refer to many different ways, but at its heart, it basically takes criminal records that are currently eligible for expungement, and it says rather than making individuals figure out how to apply for expungement, that the state would, by some mechanism, take that task on for them. So again, it doesn't change eligibility for expungement. You have to already be eligible for an expungement, but if you are, for certain nonviolent crimes, this bill would, again, the state would initiate the application for expungement for the individuals. Just by way of background, this concept of like people would popularly call this automatic expungement, but I think that's a little too simple and it confuses a lot of terms. But this concept of the state doing this, well, number one, why do we do it? Because hundreds of thousands of people are eligible to expunge their records in Maryland, but very few of them have the know-how for doing this. And so thousands of people continue to have employment and educational opportunities withheld from them because of a criminal record that they may not be aware of how to expunge. We also have growing precedent for practices like this. Actually, it was Larry Hogan, when he was governor, began automatically expunging traffic offenses off your record. Minor traffic offenses started coming off your record after 3 years. And when we legalized cannabis and built the recreational adult use system for that, we are, I believe, still undertaking the process of automatically expunging simple possession of cannabis records. Lastly, I do believe the courts are now automatically shielding non-convictions after 3 years on the record. So that's 3 different streams of records being automatically cleared, shielded, expunged in some way. And this bill, again, attempts to put forward a permanent policy for the state where we will take what we deem minor convictions, and we can debate by amendment, whether we got it right, but we think these are fairly minor convictions here, that after 7 years, the state, again, can initiate the expungement process on behalf of our residents. A couple technical points, and I know my time's about to ding. Expungement is defined multiple ways in the code, and this particular expungement is, I think, the expungement that people most care about. It is getting the records out of the criminal background database that employers will take a look at, and it's getting them out of case search where the public will broadly take a look at it. And with that, I have a great panel here that's happy to fill in the blanks.
Thank you. Ms. Gibson, can we just go right on down the line? Unless you have a
Absolutely.
particular order you wanted to go. Okay, thank you.
Terrific. Chair Bartlett, Vice Chair Davis, and committee members, I'm Nan Gibson, Executive Director at the JP Morgan Chase Policy Center. Thank you for the opportunity to speak in support of Clean Slate HB 360. JP Morgan Chase has more than 600 employees in Maryland, serving 1.3 million consumer and business customers across the state. We believe business has a role, indeed an opportunity, to help more people share in the benefits of economic growth. We're committed to giving people across the country a second chance. Over the last 6 years, nationwide, JP Morgan Chase has hired more than 21,000 people whose history had no bearing on the requirements of the job they were seeking. And we are actively encouraging other companies to do the same through the Second Chance Business Coalition, working with more than 50 large companies across industries to deploy best practices for second chance hiring. To achieve systemic change, however, we need common sense measures like Clean Slate to lower barriers to employment and create greater economic opportunity. More than 400,000 Maryland residents are eligible to have their records cleared, but very few pursue the complex, costly process, even though they have fulfilled their justice system obligations. Estimates show this costs the Maryland economy roughly $1.5 billion annually in lost earnings due to clearable records. Clean slate legislation can help get more talent into in-demand careers that fuel economic growth. I want to also mention this will also benefit the 1 in 3 veterans, our veterans serving our country, who have civilian records, which you will hear more about today from the Veteran Justice Commission in just a minute. This legislation will help bolster the state's economy by more fully tapping the talents of thousands of Maryland residents. We urge a favorable report of HB 360. Thank you.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce in full support of the bill. I want to thank Delegate Moon for bringing it forward. We don't just see this as an expungement bill, and I think Delegate Moon did a great job of explaining what the bill does. We also see this as an economic generation policy, so something that's going to create economic mobility and spur economic growth here in the state of Maryland. To back that position up, I just wanted to note that the U.S. Chamber of Commerce has found that underemployment of individuals with records costs the United States economy $87 billion a year. And a study in Michigan found that automatic expungement record clearing, similar to this bill, increased wages by more than 20%. The higher wages is good for local businesses as consumers have more earning power and they spend money with those local businesses. And then as a state that's grappling with a continuing budget issue, it certainly would be helpful to have some additional revenue flowing and some additional economic growth going here in the state of Maryland. And for those reasons, we're supportive of the bill. Thank you.
Good evening, Madam Chair, Madam Vice Chair, members of the committee. My name is Ryan Ewing, and in addition to being a Maryland attorney and a native of Talbot County on the Eastern Shore, I am a campaign strategist at the Clean Slate Initiative. It's a national nonprofit organization whose mission is to work alongside states to streamline record sealing process and to ensure that everyone who meets the requirements has eligible arrest and conviction records sealed through an automated process. I'm here on behalf of the Clean Slate Initiative to express our strong support for House Bill 360, which aims to address and rectify the impact of past records on individuals and communities. As of 2019, around 1 million adults in Maryland, or 22% of the adult population, have some form of a record. Arrest and conviction records often present significant barriers to employment, housing, education, and social reintegration. Clean Slate legislation has proven to be an effective tool for addressing these challenges by allowing eligible individuals to have their records expunged through an automated digital process, giving them a fresh start. In Maryland, only 2% of people with convictions eligible for expungement under the current petition-based system get relief. Under the current system, which is costly and difficult for the average person to navigate, it would take 86 years to expunge all of the eligible convictions. On day one of implementation, Clean Slate will provide full record relief to 407,000 adults, or 40% of those with records in this state. 13 states in Washington, D.C. have enacted Clean Slate laws, including neighboring states of Delaware, Virginia, and Pennsylvania. And the positive impact on individuals and communities has been substantial. Implementing similar legislation in Maryland would significantly bolster public safety and stimulate economic growth. As was mentioned, the current estimated aggregate annual learnings loss associated with convictions eligible for record expungement in Maryland is $1.5 billion of taxable income. This estimate does not include income loss for those with just non-conviction or arrest records. That's just the convictions. In addition, Clean Slate can reduce racial disparities in Maryland. Black adults have higher conviction rates than white adults. Clean Slate legislation would shrink this disparity by 1/3. In conclusion, I urge your support of House Bill 360.
Good evening. Bill strongly supports the Maryland Clean Slate Act. And to note that we had about 10 or so other leaders here in support. They had to leave because of the time constraints and things of that nature. My name is Shaheen Washington, and I'm a leader with BUILD, the Baltimoreans United in Leadership Development, a coalition of more than 50 religious congregations, nonprofits, and Turnaround Tuesday, a jobs movement that came out of BUILD and has connected more than 2,600 people to living wage employment. I am also a returning citizen. Over the last 3 years, we've listened to more than 1,000 people coming home from incarceration. And when we asked them what the biggest roadblock to rebuilding their lives were, one issue kept rising to the top, and that was the need to seal their records. Having a record affects nearly every part of your life: employment, housing, stability, something that I know all too well. If it had not been for Turnaround Tuesday building relationships with employers willing to give people like me a real opportunity, my story could have been very different. Because of that chance, I've been able to provide for my growing family and now step into leadership to organize and educate others. But this bill isn't about me. Every week at Turnaround Tuesday, I sit with men and women who are ready to work, who have completed programs, stayed out of trouble, showed up consistently, and still lose job offers after a background check. I've seen parents denied housing because of old charges that no longer reflect who they are. I watch people try to get their record sealed and navigate the system, confused by the rules, discouraged by the delays, and often giving up entirely. When we make second chances dependent on someone's ability to navigate a complicated legal process, we are not creating fairness, we are creating barriers. The Clean Slate Act changes that. It removes unnecessary obstacles and allows people who have already paid their debt to move forward with dignity by digitally sealing their records. It means hundreds of thousands of Marylanders will have a real opportunity to compete for jobs, secure housing, and to build stable lives. And when people can work and provide for their families, our communities are stronger and safer. A second chance shouldn't depend on paperwork. Let Maryland be a state that believes in redemption, removes barriers to opportunity, and ensures that a mistake is not a life sentence to poverty. I urge you to vote favorably on the Maryland Clean Slate Act.
Thank you. Members, do we have any questions? Delegate Williams.
Thank you. Sorry. Thank you, Madam Chair. I think I'm losing my voice. Thank you, Delegate, for bringing this bill. Actually, I saw I'm a co-sponsor of the bill. I really do believe in the premise of the bill. Just a quick question for Mr. Ewing. I don't know if there was more stats that you wanted to mention, but with this bill, and like I said, I believe in the initiative and the effort and the why behind the bill. You still have to file the paperwork, though. Is there still an application process associated with this?
No, Delegate, to answer your question, this is an automated process, and so the burden is shifted from a petitioner in that context going to court with paperwork to the government itself. In this instance, the courts would initiate a review of the data and indicate when, after the appropriate waiting period, a person's record would be eligible. This is misdemeanor only and non-conviction only.
Got it, which is why, and this helps to streamline that process and make it easier. Perfect. And then was there, I think you ran out of time there. I don't know if there was anything else that you had wanted to add there at the end.
Just that we had some survey research out of states that have implemented this law, and in Pennsylvania, Utah, and Michigan, they have implemented the law already, and those indications are quite good, that people are reporting improvement at work, in family relationships, and in mental health and health or self-esteem.
It was good to see that this has been done in a wide variety of states, red states, blue states, purple states.
Yes.
Good. Thank you.
Thank you.
Thank you. Members, do we have any other questions? Delegate Taylor.
Thank you, Madam Chair. Thank you, Delegate Moon. How does this bill differ from good cause?
So good cause, as I understand it, doesn't have a crime restriction, and so it's really, that's more of a Hail Mary play, so that if someone
just gave me a football reference that I do not understand.
Got you.
All I know is you do something like that, and
yeah, that's a good. So it's sort in a way it's sort of the opposite. Like this bill would try and clear through as many of the routine minor records as possible, and I think that bill is really getting at, I don't want to call them extraordinary cases, but unusual cases. The sort of diamonds in the rough where someone had a really bad break and their case may not be eligible, and you might not want to add that crime to the list of eligible cases, but that person had a really bad case, so maybe we should let them off.
Got it. Thank you.
Members, do we have any other questions? All right, seeing none, that concludes this panel. I'm going to call up the next favorable panel: Meredith Gerard, Nicole Bannister, Christopher Cano, Megan McDermott, Jamie Grace Alexander, Sabrina Ndiaye. Let's see how we're doing. I have Meredith Gerard, yes. Nicole Bannister, yes. I don't have Christopher Cano. I have Megan McDermott, Sabrina Ndiaye, and I have Jamie. Okay, great. I could probably get one more person. Lori James Towns, could you come up? Can you all squeeze in just a little bit more? Sure. All right, perfect. All right, so what we're gonna, kind of squeeze down. There you go. so we can get. Okay. So we're going to start on this end and just work our way down. You don't have to wait for me to tell you to start. You can start, and there you go. Thank you.
Thank you so much, Chair Bartlett and members of the committee. My name is Nicole Bannister. I am the Director of Policy and Advocacy at the Responsible Business Initiative for Justice and a resident of Prince George's County. We're a nonprofit that works with companies to champion solutions that promote public safety, deliver justice, and strengthen communities. Since our inception, RBIJ has collaborated with companies of all sizes in 24 states to advocate for practical policy reforms and expand workforce opportunities and stimulate economic growth. We strongly support the passage of Clean Slate Maryland HB 360 to provide deserving individuals with the second chance that they have earned. The Maryland business community strongly supports Clean Slate, as evident by the support and testimony provided from a range of prominent businesses, including the Maryland State Chamber, who you just heard from, as well as the Salisbury Area Chamber, Flick Shop, Lillian Southern Box Catering, and Flagler Force, who will be testifying virtually today as well. According to a recent poll conducted by the Small Business Majority, 84% of small business owners agree that Clean Slate policies will open up a pool of applicants that have earned a second chance. Clean Slate will give employers the opportunity to recruit from an underutilized talent pool while making Maryland a safer and more prosperous place to live and work. The current petition-based record sealing process is complicated, burdensome, and seldom accessed. We know that in Maryland, less than 2% of eligible individuals receive the clearance that they are entitled to. By automating the record sealing process, businesses across the state can give hardworking individuals the chance to meaningfully contribute to the economy. Companies have seen firsthand how automatic record sealing strengthens the communities they serve while also benefiting their bottom line. By expanding the pool of talent businesses can recruit into long-term sustaining jobs, Clean Slate will reduce recidivism. By making Maryland a safer place to live and work, we can continue to attract new talent, new employers, and new investments. I urge a favorable report.
Good evening, Madam Chair, Vice Chair, and members of the committee. My name is Meredith Gerard. I'm Executive Director at Shore Legal Access. This bill is incredibly important for the underemployed and, frankly, underutilized workforce that we have in our rural communities. Shore Legal Access provides free legal assistance for people with limited means across 8 counties on the Eastern Shore. And as a provider of legal services of this type, we know firsthand what is at stake. One of our recent clients, Thomas, came to us after he experienced homelessness. He couldn't find housing due to an old low-level misdemeanor that was on his record. We helped him through the traditional petition-based process, and he described a transformative moment of hope when he finally got his record expunged. And today he's gainfully employed. He's caring for older adults in his community, and he's not the exception. This bill is for Thomas, and there are 407,000 others. In recent polling, Marylanders overwhelmingly support this effort. So now is the time to modernize our systems so that it's really catching up with the values that we have as a community. And I just want to point out that this bill will create public shielding of those records, but still people, if they want to completely clear that record, would still have to go through the petition-based process. House Bill 360 automates what already ought to be happening. And this reform is needed so that we can have stronger families and stronger communities. We urge your support. Thank you.
Good evening to the committee. My name is Megan McDermott. I'm an advocacy director at Maryland Legal Aid. A clean slate law would help the many Marylanders who don't realize they're eligible for expungement or who cannot navigate the court process. It would also help alleviate the already strapped resources of legal service providers and the courts. On its face, the current expungement process seems simple and accessible, but it's not. The statute changes every year, and each type of charge or disposition has a different set of rules. Conviction petitions require a filing fee. If someone can't pay the fee, they have to figure out how to navigate the fee waiver system. People think expungement is an administrative process, but that's not accurate. Many petitioners end up in court for expungements. Often people need a lawyer to help them, and if they can't afford one, they turn to Maryland Legal Aid, Shore Legal Access, Office of the Public Defender, other sister legal service organizations for help. People with money and resources to hire an attorney or take off work or secure childcare for court hearings can probably navigate the expungement process, but low-income people often don't have those luxuries. Clean Slate helps everyone, petitioners, practitioners, and the courts by doing away with court hearings and filing fees for already eligible misdemeanors, thus restoring equity to the expungement process. We urge a favorable report. Thank you.
Good evening, Honorable Chair and Vice Chair in this committee. My name is Dr. Sabrina Njai, and I'm here before you today in support of HB 360. I am an integrative psychotherapist and have facilitated hundreds of groups for women who have experienced extreme trauma. I'm also the Vice Chair of the Baltimore Alumni Chapter of Delta Sigma Theta Sorority's Bridge Project, a mentoring program for justice-impacted women. In addition to mentoring justice-impacted women towards their definition of a better life, we advocate legislatively to remove barriers that these women face as they work to restore themselves, their families, and their communities. This legislation represents a significant stride towards justice and redemption, underpinned by our shared belief in second chances and rehabilitation. House Bill 360 moves us closer to empowering returning citizens with the mechanism to petition for expungement of certain eligible offenses. Allow me to expound on the profound impact expungement could have. Returning citizens are empowered through increased employment opportunities because their criminal record is often the biggest hurdle in securing gainful employment. Rehabilitated citizens gain access to housing, create and enhance stability and growth for their families. An expunged record widens the gate for those who seek self-improvement and economic mobility through higher education and training. When certain offenses are wiped clean from a person's record, it dismantles barriers to community engagement, supports family unity, and fosters societal inclusion. HB 360 embodies the values of forgiveness, growth, and equity. Members of this committee, on behalf of Delta Sigma Theta Sorority Incorporated, I urge you to contemplate the long-term benefits that HB 360 will usher in, not only for individuals seeking redemption, but for society at large, which thrives when each of its members is accorded dignity and opportunity. Please issue a favorable report. Thank you.
Hello, my name is Jamie Grace Alexander. I'm a paralegal at BALT. Y'all heard from me already several times today about the work that we do at BALT, but I'll just say that I've expunged hundreds of records, and I sit every day with the tension that every day those hundreds of records that I have expunged are created in a single day. At BALT, the majority of our client work is expungement, seeing clients who have had criminal records for most of their lives, regardless of the time since their last charge. Frequently, we see elders with charges from the 80s and 90s who bear the weight of overcharging as a political strategy from some long-past politician or police chief. Since their arrests, these people have become grandparents, become disabled, become leaders in their communities, and this record has been following them the whole time, preventing them from accessing opportunities that they would be good for, holding them back to their past mistakes, and taunting them with recidivism. Understandably, people hold their record with shame and fear of disappointment that often prevents them from seeking help. Furthermore, older records can be physical only. Frequently, we need to make record requests with the court to get information on people's decades-old charges. Where many nonprofits focus on lessening the problem, I'm trying to organize myself out of a job. If you pass this bill, you can free your constituents. Yeah, go ahead, laugh. When many nonprofits focus on lessening the problem, I'm trying to organize myself out of a job. If you pass this bill, you can free your constituents of the weight of criminalization that follows them in a way that we can never do as legal service providers. Thank you.
Good evening, Honorable Chair, Vice Chair, and members of the Judiciary Committee. I'm Lori James, and I sit here before you in support of House Bill 360 as the Executive Director of the National Association for Public Defense, an organization of 30,000 members across the country, including the Maryland Office of Public Defenders. I'm also representing Baltimore Alumni Chapter of Delta Sigma Theta Incorporated, with a local membership of more than 600 and an international organization legislation with more than 1,000 chapters. 25 of those chapters are in Maryland, representing every single county. I've spent my entire professional career involved in criminal justice reform or public defense. This legislation represents significant stride towards justice, redemption, underpinned by our shared belief and second chances. I want to just talk a little bit about the experience of working with system-impacted men and women. As I said, I've had a long career in this. My career started as an expert witness working on capital murder cases in Maryland. I've also worked on UNGER cases, and I've also worked on juvenile resentencing cases as an expert, examining the barriers that men and women face coming back into society. I know firsthand, I've held hands, I've seen the barriers in which they face, not being able to get proper housing, not being able to move in with family members because of a conviction, not being able to go back to school, even though many of them are educated. I did my first internship at BCCC, and those men there were so smart, so smart. And they gave me all sorts of advice. And to know that many of them came home and could not get proper jobs. They couldn't be a counselor. They couldn't be a social worker like I was and like I am. And so I asked that the committee favorably support this bill to give people opportunities to do right, to make a future for themselves. I've seen firsthand the implications of not being able to take care of your children even though you want to. I urge the committee to vote in favor of this bill. Thank you.
Thank you. Members, do we have any questions? Delegate Conaway.
Thank you, panel, for coming in to testify. From the person from Bolt, how much do you charge to do expungement?
All of our expungements are free.
All your expungements are free?
That's correct.
Okay, thank you so very much. Where are you located?
We do legal clinics in West Baltimore mostly, but we operate legal clinics all over Baltimore trying to see the people who are most affected by overcriminalization.
So what you do, workshops?
We do legal clinics. One of the legal clinics that we do is with Penn North Recovery Center. So we go up to Penn North Recovery Center. We have people come in with expungement records, and Penn North Recovery Center also calls clients that they know who have records. They come in and they see us, and then we take those records home. I'm very lucky to work from home, and I type, expunge their records.
Thank you so very much.
Really have a question, so sweet. I just want, I'm sorry, I couldn't help myself, and I'm sure, right, Delegate, shameless plug, so myself and Delegate Nicola, we're both proud members of Delta Sigma Theta Sorority Incorporated. So thank you so much, SOARs, for being here. As you know, social action is the linchpin of our organization, and you guys have just exemplified that so well today, so thank you.
Thank you.
Isn't that so? I'm sorry, it has to be quiet.
Thank you all for being here. And Ms. Gerard, I wish you safe travels back to the shore. All righty. Oh, Delegate Stinnett, I'm sorry.
No, just real quick, I want to mention before you walk away, I'm glad that you shouted out BCCC because I'm a graduate and a former instructor at BCCC, so thank you.
Thank you.
Right.
All right. All right, thank you very much. And is Sarah Anderson on virtual? Yes, she is. Okay, and Heather Warnken? You can go ahead and call in, Ms. Anderson. Okay, and Monica Watkins. Christopher Dews, are you testifying?
Yes.
Zachary Alberts.
Yes, I'm here. One moment.
Hassan Giordano. Mr. Giordano?
Me too.
Okay, is Martin Mitchell online and Andrea Grimm?
I'm testifying on behalf of Martin Mitchell as well. He's in Me Too.
And what did you say about Andrea Grimm? Okay, so let's go ahead and start on this end and just work our way down. Thank you.
Hi, Zach Alberts, Director of Advocacy at the Center for Urban Families. Most of what I wanted to say has already been covered for two things. One, I'll note that Hassan is long day, is State's Attorney Bates' Chief of Staff, and State's Attorney Bates supported this legislation last year and supports it this year. So we're glad to have State's attorneys as partners. The other thing I would note quickly is that low-cost legal services like legal aid, MVLS, and BALT are very valuable, very rare commodities to help Marylanders who don't have a lot of money, who need legal relief. A bill like this, that's an easy computer program that will do a lot of grunt work automatically, will free them up to do more complicated things that computers can't do, but are important. And so from that point of view, we would ask you to vote favorably for this bill. Thank you.
Good evening, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of HB 360. So this body has already recognized that permanent punishment is not good for Maryland. It's not good for our economy, not for our residents. It's carefully passed laws designed to provide relief for those who qualify. And in the interest of time, I'm going to cut a lot of this testimony, but this point really bears repeating. This bill is about the huge gap between eligibility and access. So research consistently shows that across the country, under petition-based systems, uptake rates are often well below 10%. But this is particularly bad in Maryland, where only 2% of those eligible ever receive the relief that they are entitled to. HB 360 is a common sense, bipartisan solution already adopted in 13 diverse states and counting. The Expungement Reform Act last year was a huge step forward and one very much taken with this next step in mind. But automation is how we effectively implement and scale the impact of these laws. And lastly, I just want to note regarding any fiscal note concerns, this isn't just about easing the burden on would-be petitioners. This bill transitions us to a system designed to also greatly reduce the judiciary's burden and administrative costs down the road. Let's make second chances real. Let's implement them effectively. We urge a favorable report. Thank you.
Christopher Dews, representing Life After Lease in Prince George's County and Out for Justice, also on behalf of Mr. Mitchell. Just wanted to quickly just make sure that we're clear on some things, what this bill is and what it is not. Just to be clear, this is more record sealing than expungement. I know that there was some unfavorable testimony that had mentioned people not getting access to the records and things being just disappearing from public, just appearing, period. Just to be clear, this bill is just sealing the record. The regular petition process is not touched. This is just removal from public view, and we thank Delegate Moon for his sponsorship and leadership pushing us in that direction. I also wanted to just highlight again that this is for low-level misdemeanors that are already eligible for expungement, and then also, and again, and the opposition testimony, I believe something was written that maybe individuals may not want their record automatically expunged. Again, this is removal from public view, so there will always be access to that record for individuals who do not want the automated process to happen. Last thing I wanted to mention was there was a line, I believe I was informed from, I won't name the opposition, I'll just, out of respect for them, I'll just say that they were not allowed to see, I'll be blunt, the State's Attorneys Association. They said that they were not allowed to review the records before they were automatically removed from public view. Previous versions of this bill in the past actually gave them the ability to do that, and then that was removed because they said it would have been too much of a burden to try to review the automated cases. So this bill, we did the best that we possibly could to ensure that all the parties would have been happy. DV, any type of DV or assault was removed. So this is, again, low-level misdemeanors that we're just trying to remove from public view. Thank you. Happy to answer questions.
Good evening, Honorable Chair, Vice Chair, and members of the Judiciary Committee. I'm Monica Watkins, past president of the Baltimore Alumni Chapter of Delta Sigma Theta Sorority Incorporated, and I established the BRIDGE project, which stands for Bringing Resources and Information Designed to Grow and Empower project into the Baltimore Alumni Chapter. I support HB 360 as a step towards truly giving returning citizens the opportunity to be successful re-entering the community. The BRIDGE project aligns with our National Grand Chapter's initiative to empower women and girls. Several years ago, I was competitively selected to work on a 10-month program with other members of my sorority from around the country. This research-based leadership program focused on shaping our sorority's initiatives for impactful change. We chose to support justice-impacted women, providing resources, advocacy, information, and empowerment. And while our focus is on women of color, our strategic alliances and initiatives yield positive outcomes for all. Justice-impacted Marylanders and those in our program have expressly identified the inability to secure employment due to excruciatingly long and complicated processes to have their records erased after they have paid their debt to society. The inability to support their families is particularly harsh in the Black community. The Maryland General Assembly's Department of Legislative Services has prepared racial equity impact notes for other expungement bills this year and in years past. Here is one of DLS's critical data points. The Department of Public Safety and Correctional Services reports that as of January 2026, Black individuals make up 71% of Maryland's prison population, contrasted with their 30% of this share of the state's overall population. It is therefore a reasonable assumption that Black individuals comprise a meaningful portion of the population seeking to expunge criminal records. Members of the committee, the women we mentor in Baltimore City and Baltimore County are facing insurmountable odds. Members of my chapter and other chapters around the state are here to also demonstrate support for this bill. I respectfully urge your favorable report on House Bill 360 to give justice-impacted citizens of our state the opportunity at a better life that will result in enhanced quality of life for all of us. Thank you.
Thank you. Andrea Grimm.
Good evening, Chair Bartlett and members of the committee. My name is Andrea Grimm, and I'm the Workforce Development Specialist at Flagger Force. Flagger Force is a leading short-term traffic control company providing services through the eastern United States. We proudly employ 380 and growing Marylanders, including individuals with criminal records. We work to keep our communities moving, not only by directing the flow of traffic for our clients, but also through job creation and career development within the communities in which they live. We cannot overstate the effects of fair chance hiring and the access to opportunities it leads to those with criminal records. Research shows that recidivism rates drop from 52% without sustained employment to 16% among individuals who secure and maintain employment. Today, I'm here to ask you to consider automating the record sealing process. The clean slate will open up employment opportunities for individuals who have earned a second chance. For Flagger Force, the Clean Slate Initiative facilitates the employment of more individuals in Maryland, thereby expanding workforce participation and strengthening community reintegration efforts. I have observed the difference that a good job can make in somebody's life. As an advocate of fair chance hiring, Flagger Force believes all people deserve dignity of work regardless of their past mistakes. By breaking down barriers and providing opportunities for justice-impacted individuals, Flagger Force is not only transforming lives, but it's also building stronger, more resilient communities for the future. Thank you for your time this evening, and I respectfully ask you to consider a favorable report of this bill.
Thank you. Sarah Anderson.
Madam Chair and members of the committee. My name is Sarah Anderson, Associate Director of Criminal Justice and Civil Liberties at the R Street Institute, a nonprofit, nonpartisan public policy organization focused on evidence-based criminal justice reform and limited effective government. I'm here today in support of the Clean Slate Act. This bill creates an automatic process to expunge certain eligible criminal records after a defined period of law-abiding conduct. It sets clear eligibility standards and waiting periods and is supported by research showing that record sealing improves outcomes while maintaining public safety. The legislation does not destroy records. They remain accessible for appropriate governmental and public safety purposes. It simply limits public visibility so that once someone has met the statutory requirements and remained crime-free, old records no longer operate as permanent barriers. Automation is critical. In Maryland, approximately 40% of individuals with criminal records already qualify for petition-based sealing, yet fewer than 2% have obtained relief. That gap reflects procedural complexity, not public safety concerns. The employment consequences of a criminal record are significant. An arrest or conviction reduces the likelihood of receiving a callback or job offer by nearly 50%, and 94% of employers report using background checks. Research shows that individuals who remain crime-free for 5 to 7 years are no more likely to reoffend than those without a record. Continuing public penalties after demonstrated rehabilitation does little to advance safety. In a state where nearly 1/4 of adults have a criminal record, these barriers affect individuals, families, and the broader economy. States that have implemented automated record sealing laws have seen improvements in employment, housing stability, educational attainment, and overall well-being. House Bill 360 offers Maryland a unique opportunity to modernize the system, improve efficiency, and remove unnecessary barriers while still preserving public safety safeguards. We urge a favorable report. Thank you for your time.
Thank you. Members, do we have any questions? Delegate Conaway?
Thank you, panel, for coming in to testify. So what can a person do if this bill passed if they don't want their record to be sealed or shielded from the public? Mr. Dews, maybe you can.
Yeah, that's a question that I will pass to my colleagues. No, because that's not what, yes, I don't mean to.
So as a few different panelists have pointed out, it's really important to note that this is about hiding the record from public view, not destroying the record. So the record still very much exists. So if the person wants to obtain the documentation of their record for any reason, but I guess if what you're asking, if when they apply for a job or an apartment, they want to call someone up and say, you may not have found this on a background check, but this charge existed.
No.
Yeah,
no, Mr. Dews did.
Yeah, no, I will.
No, I'll make it more specific.
Yes, sir.
So April 2020, the Fulton County solicitor wanted to expunge Martin Luther King's record.
Well, again, with
Suppose if you're an activist and you don't want your record to be expunged.
Yeah.
I mean, we have activists out here, we have people that get arrested all the time.
Yes.
And they consider that to be a badge of honor.
Yes.
So who are you to take their
No, I'm actually 100% in agreement with you. With regards to this bill, that case file would still be in existence, so there actually wouldn't be.
No, not if you do it automatically.
Well, no, this is removing it from public view. So you're saying they want it visible for public view.
I'm just going to speak up for some of the people that I know that are activists. They want you to know their record, and they're proud that they're paying the price for standing up for what they believe in. Do you agree with that?
I would agree with that, and I think they would still have access to that.
No, they want you to have access to it.
Yeah.
They want the public to put it in and see their whole story and what happened to them and their record, and then they can tell you how their life is affected by what you can't see if you shield it.
Yeah,
So,
and they could go to the courthouse and still get the access. Go ahead, Kevin, I'm sorry. Good question.
This is also only for low-level misdemeanors. So clean slate has already been very narrowly defined. So the things that are getting automatically shielded from public view are a small subset of charges.
Yes, I fail to understand that sitting on the back of refusing to get up and give your seat up and moving to the back of the bus can get you a charge like Rosa Parks had that they're talking about expunging. Would you agree? Is that a low-level offense? Would you agree?
I would agree, and I also think the cost benefit of the way that the 70% of the cases that go through the criminal justice system being misdemeanor charges that are haunting people for life and creating barriers to economic opportunity.
Right. You missed the whole point that I'm making about the situation. So
If I can,
I'm fine. Thank
my
you
last
so very
point
much.
would be to say that
You
they
missed the
could.
point too.
My apologies, sir.
Yeah.
But they would still have access to.
Well,
they
you need to
could
come
get-
legislate Black Caucus. Come on, you want to keep coming with it?
Okay.
You got it.
All right.
Thank you, delegate.
All right. Been here long, everybody's tired, but we're still gonna maintain. All right, so we're gonna excuse this panel. Thank you very much. Thank you all.
Thank you.
We're going to go to unfavorable panel. Carrie Bozzolari. I'm sorry?
Right now.
Oh, wait. I have David McEwen, but I don't have you yet. I'm going to call you.
Okay.
Yep. I'm going to call Carrie, and then I'm going to call you.
Okay.
Okay?
Thank you. Good evening, once again. My name is Carrie Borzilleri, and I'm here on behalf of the Maryland States Attorneys Association. The Maryland States Attorneys Association is opposed to House Bill 360. Right now, prosecutors are catching more and more ineligible cases slipping through the cracks due to the lack of human review. In Worcester County, there have been cases in which a co-defendant case was null-prossed, but the remaining co-defendant was still pending trial, and yet the records were expunged. Under the current statutory structure, the state's attorney's office reviews each expungement to determine eligibility. Criminal Procedure Article 10-110 has a wise requirement that the expungement request be given an assessment that, giving due regard to the nature of the crime, the history and character of the person, and the person's success at rehabilitation, the person is not a risk to public safety, and that an expungement would be in the interest of justice. There are unquestionably some convictions which would be eligible for expungement, where expungement would be contrary to public safety or the interest of justice. With this proposed legislation, the state and the victim would not be permitted to do anything to attempt to prevent the automatic expungement of the offense, whether or not eligible. In summary, the proposed legislation is impossible to carry out, creates very real circumstances, creating a public safety risk. We ask for an unfavorable report. Thank you.
Thank you. Quick question.
Yes.
You said, and I didn't catch everything, but you said that in a situation where there are two defendants.
Yes.
There's one defendant, and you said something got expunged even though there was a co-defendant. Can you just explain that one more time, please?
Yes, sure. Basically, what happened is, my understanding at least, is there was a co-defendant that still had an ongoing trial or pending trial, and the records were expunged. The co-defendant was null-prossed, and the records were expunged, and therefore the prosecutor did not have access to the records for that co-defendant who still had the pending case. So basically, there was a glitch in the system that I don't think anybody knows why at this point, but there is, obviously, systems will have glitches, and that's the concern here, that there will be glitches in the system, and cases that maybe should not have been automatically expunged will be automatically expunged, which would cause problems.
Do you have any other examples?
I do not.
Okay. Delegate McComas?
Just real quick, my concern is whether you're a defense attorney or a prosecutor, you may need to go back because you need to get a picture of this person back to, maybe a juvenile record, or if they've had a lot of interaction, if they have had, minor drug or alcohol stuff. So and then they kind of go off the rails, and you need to know all that background. And so if things get expunged and you don't have access to that stuff, or if the problem is that at a certain point all this stuff's going to get piled up somewhere, and somebody's going to say, we got to get rid of this stuff, and that stuff could be valuable. The other thing is, it's also valuable if you want to research your family tree and kind of go back and see what the other folks did a generation or two ago. So I'm just thinking that I'm kind of concerned about this whole thing. How's it going to work? And it's going to cost money. So anyway.
Yes, thank you.
And that's all.
Thank you. Members, do we have any other questions? Seeing none, we're going to call up information. David McEwen, please.
It's been a long day. Well, thank you. My name is General Mac McEwen. I'm retired after 33 years in the Army, and I serve currently as the Director of the Veterans Justice Commission, an initiative of the Council on Criminal Justice. I'm grateful to be here. The Council is an independent, nonpartisan, invitational membership organization and think tank serving as this incubator of policy and leadership in the criminal justice field. I will just take a second to tell you that they've done some work on women's justice, long sentences, all kinds of stuff, so they're a great resource. In 2022, the council assembled the Veterans Justice Commission, chaired by the former Secretary of Defense Chuck Hagel, and plus Leon Panetta was also a member. The commission research concluded that veterans who commit offenses as a result of service-related conditions represent a unique class of defendants in our criminal justice system. The conditions of their underlying criminality are often partially created by the government that prosecutes them. We send our men and women to war knowing that some will bring the war home with them via criminal conduct. And it's a tragedy that those that once wore the cloth of their nation now wear the cloth of incarceration. I provided a detailed written testimony for the record, but we have to acknowledge that there's a complex set of needs and risk factors of justice-involved veterans distinctive from those characteristics of civilians with a military background. These proposals flow from studies that show that service-related trauma exposures combined with increased incidence of mental health and substance use disorders elevates veterans' risks of involvement in the criminal justice system. Once those individuals enter the civilian justice system, they face harsher penalties and outcomes than their civilian counterparts. Research on sentencing and supervision of veterans are sparse, but the studies have compared state prison sentences to veterans. They're 22% more likely to be sentenced for violent crimes. The commission recommended that the federal and state governments adopt statutory frameworks and incentives to improve veterans' diversions, deferred adjudication, participations in treatment courts, sentencing mitigation, and records clearance. I'll end with this. People who have served this nation through service in our armed forces have sacrificed to protect us. It's time to recognize that sacrifice and take steps to ensure that our veterans are not lost in prisons and jails, but instead receive interventions that both hold them accountable and help them resume their responsibilities to their families, their communities, and their countries. We must acknowledge the scars veterans bear from fighting for us to help them heal. We must do better. We must not leave them behind. I'll answer any questions I know about how many veterans you have in your jails. It's a high percentage of your veterans that have served, and I'll be happy to take any questions.
Thank you. And so you said you knew, do you have data on how many?
Yeah, you have.
In your testimony,
I'm not sure I put it in my testimony.
Okay.
In 2023, you have 688 veterans incarcerated. That's 4.3% of your prison population. And you probably do better than most states on identifying veterans, because it's a problem, identifying veterans in your population. But you probably do one of the better jobs in the 50 states, because we conducted a study. And you do one of the better jobs because you do both you do a hybrid thing, you do self-reporting, and you use the VRSS system from the VA. So I commend you on that.
well, thank you. I appreciate your testimony. Members, do we have any questions? Okay, seeing none. Thank you very much, General.
Thank you.
Members, that concludes our testimony and bill hearing for House Bill 360. Our last bill for the night is House Bill 131. Delegate Moon. I'm going to call up Christopher Cano, who is not here, correct? Okay, Melissa Rothstein and Christopher Dews.
Well, thank you, everyone who's leaving, for sticking around so late. Appreciate it.
Yes. Thanks for hanging in there with us.
And we've got nearly a full house in the committee, so it's a good day. Colleagues, House Bill 131 is what I consider a technical cleanup bill from years of expungement policy, including a lot of the stuff you heard today. And it does a couple things. So in 2015, we began this process of record shielding with what was called the Second Chance Act. And the Second Chance Act allowed you to shield from case search different types of criminal records. When we created that law in 10-306 of the Criminal Procedure Article, we wrote a series of things that you could not do with information that had been shielded from case search. These were things like if you're applying for school, a job, or a government application, your refusal to answer questions about information that was shielded from case search could not be the sole reason for you being denied that thing. Then we came back and we have a different section of law that deals with expungement in 10-109 of the criminal procedure. We attempted a very similar undertaking in 10-109, where we attempted to say if a record had been expunged, now it's obliterated, it's not supposed to exist. That information also is similarly supposed to be restricted for different things, employer, school, and government applications. Here's the problem. Those two lists do not line up. The list of restrictions for shielded data is stronger than the list of restrictions for expunged data. It doesn't make any sense. The expunged data is supposed to be obliterated, so it ought to have stronger restrictions. So I'm just trying to streamline what's going on here and make the two lists as similar as possible in the bill. I actually don't think I got it quite right, so I have an amendment coming to tweak that. But that's what that is. So you'll see the language doesn't line up. On one side, we restrict permits, registrations, and admissions, but on another side, it says licenses, permits, registrations, and it just doesn't line up. So I'm trying to fix that after all these years. The second piece of the bill is one that I think Claire actually may have flagged some time ago. I don't know if you even remember this, Claire, but when we decided to try and create a pilot for automatic cannabis expungement, we set it up much the way you see in what the Clean Slate bill is proposing, where we would remove the information from case search and we would remove the information from the criminal justice repository where people look up your background checks. And that was supposed to be automatic cannabis expungement. We just take it out of those two places. But since then, the courts have rolled out the MDEC database system statewide, and it seems to me that since MDEC was created after the cannabis expungement policy, the cannabis expunged data may live on in metadata and records in MDEC. And I include it here simply because I think that's a policy question that we need to decide at some point. So there it is. And I'm happy to now turn it over to some panelists with additional color.
Okay. Good evening. My name is Melissa Rothstein. I'm an expungement attorney for Out for Justice, and I urge you to issue a favorable report on House Bill 131, and I thank Delegate Moon for bringing this bill. The bulk of my testimony was going to be about the importance of expungements. I'm hoping you've heard that already enough today, so I will spare you that. I do want to highlight, however, that the most common question that arises after somebody's has had a case expunged is for them to ask, do I have to say that I have had this case? And the confusion in the law has really has made that a harder question to answer than it should be, and really appreciate that this would be an opportunity to fix that. And with that, I'm available if there are any questions.
Christopher Dews, representing Life After Lease and Center for Urban Families. Me too. It's a long night.
Thank you. Members, do we have any questions? Seeing none. That concludes our bill hearing for House Bill 131 and concludes all bills for the evening. We are adjourned.